Everybody should after vacation, Monday, Tuesday. Or apply last day. Sir, that withdraw ಮಾಡ್ಕೊಂಡ್ಬಿಟ್ಟಂತೆ. ಅದ್ ಮೆಮೊ ಇರ್ಬೇಕಾಗಿತ್ತು ಹಂಗೆ ಇವತ್ತು ಆಟೋಮೆಟಿಕ್ ಬಂದಿರೋದು. 2:30 ಬೇಡ ಅಥವಾ ಸಾಟರ್ಡೆ ಇದು ಫ್ರೈಡೆ ಬೇಡ ಅಂತಿದ್ರೆ ಮಂಡೇ ಹಾಕಿರೋದು. ನೀವು ನಾಟ್ ಕ್ವೆಸ್ಟ್ ಮಾಡ್ಕೊಂಡ್ಬಿಟ್ರೆ ಅವ್ರು ನನ್ಗೆ ತಂದು ಅವ್ರು ಕೇಳ್ತಾರೆ ಕಂಟಿನ್ಯೂ ಮಾಡಿ ಬೇಕಾಗಿ. ನೀವು ನಂಗೊಂದು ಮಾತು ಹೇಳಿದ್ರು ಅದನ್ನೇ ಕಂಟಿನ್ಯೂ ಇವತ್ತು ಇನ್ನೊಂದು ಮೂವ್ ಮಾಡೋ ನೆಸೆಸಿಟಿ ಕೇಳಿ. ನಾಳೆಗೆ ಅಂದ್ರೆ ಇಲ್ಲ, ನಾಳೆ ಒಂದೇ ದಿವಸ ಇರೋದು ನೋಡೋಣ ಏನು ಹೇಳ್ತಾರೆ ಬರ್ಲಿ. ಈ ವಾರದಲ್ಲ ಅದು ಒಂದೇ ಎಲ್ಲ ಮಂಡೇ. ನಾನು 2 ದಿವಸ ರಜೆ. ಅವರಲ್ಲಿ ಬರ್ಲಿಲ್ವಾ ಅವರು 28 ವಿಜಯಕುಮಾರ್ ಪಾಟೀಲ್ ಸಾಹೇಬ್. ಗೌರ್ಮೆಂಟ್ ಎಮೋಸ್ ಎಲ್ಲ ಅಲ್ಲೇ ಮೂವ್ ಮಾಡ್ರಿ. ಎಮೋಸ್ ಅಲ್ಲಿ ಮೂವ್ ಮಾಡ್ಲಿ, ಅರ್ಜೆನ್ಸಿ ಇರೋದು ಅಲ್ಲೇ. PSJ ರಿಕ್ವೆಸ್ಟ್ ಅಂತ ಹಾಕ್ಬೇಕು. ಅಡ್ಜರ್ಮೆಂಟ್ ಹಾಕ್ಬೇಕು. ಅಡ್ಜರ್ಮೆಂಟ್ಸ್ ರಿಕ್ವೆಸ್ಟ್. ಅವ್ರು ಒಂದೊಂದ್ಸಲ ಹೇಳಲ್ಲ. ನೀವು ಆ ಕಡೆ ಅವ್ರು ಕೇಳಿಲ್ಲ, ನಾನು ಕೇಳಿ. April 24th April.
No, now what is that? You have filed an application for vacating. No. Vacating. We'll see your test tarik on the 16th. Yes.
16.
RFA tagli. RFA kudi. Friday active on Friday.
A short date will
RFA will give it the date.
There was an interim order that was passed, my lord. Based on the interim order which was passed, had been challenged under MA. While the MA is pending, my lord, what they are doing, they're destroying entire crop that I have
What is
built.
that? Fresh matter or old
Fresh matter, my lord. What I'm
Fresh
seeking
matter
for
kodi tomorrow.
at today 2:30, my lord.
Fresh matter to tomorrow. Tomorrow.
This one I'm requesting for 2:30.
Tomorrow.
Today. They are already in the property, cutting off the trees and the entire coffee
Tomorrow,
plantation.
mister. Tomorrow. Kodi fresh matter. Fresh. Wait. Fresh matter kodi alla.
Fresh matter for tomorrow.
Fresh matter tomorrow. Fresh matter tomorrow. No, not today, tomorrow. Yes. Kodi. Yes.
Fresh matter. Fresh matter.
Fresh kodi. RFA kodi, which Friday ಬರುತ್ತೆ. One Friday. Wait. RFA ಕತ್ತಾಳಿ.
RFA ಕೊಟ್ಬಿಡಿ. RFA ಕೊಡಿ sir, RFA.
Court, my lord, directed me to serve the copy of the petition to the other side. They have served, my lord.
RFA.
For consider, writ petition, my lord. For consideration of the interim prayer, not date as given on 26th, my lord. It has not been listed, my lord. 26th date ಕೊಡಿ sir, ಬಂದಿಲ್ಲ.
9th.
Short date maybe.
9th, yes.
Published.
Recall. Even after recall, execution they passed an order. After my recall, I presented it to the court as to your office. I said it itself is legal, execution is not immediate. Without saying that, they issued the execution to police warrant. Hence, I request for 2:30.
Tomorrow. Yes.
My lords, in this case, what happens?
Tomorrow. Yes.
My lords, already the Sambal court has been disposed, directed to dispose the matter in 3 months. But again, they have obtained the interim order, my lord, in another writ petition. My lord, these senior citizen matter, my lords, the age
Fresh
about
matter or
old
pending?
matter, my lords.
Yes. Application for vacating is
I
filed.
did not file anything, my lords.
Yes. This matter on 27th. Yes.
27th, sir.
Yes.
Pending matter, my lord. Pending matter, my lord.
Pending matter 27th. Yes.
My lords,
Vacating say 15th. Yes.
my lords, may I just mention list 1, serial number 50. My lords, 2 matters are already listed, but there are 3 connected matters. My lords, last date of hearing 27 March, it was that we had not serviced to the other side because cavator is there. My lords, that has been served, so my lords may just take up that connected matter also in this.
Pending.
Yes, my lord, this is a new matter, but
Yes. 9th.
no, my lords. My lords, 2 matters are already listed today. That matter in which we have not got a writ petition number is still
If it is listed, you wait when the matter is called, then you can mention that for connecting. Yes.
My lord, status quo order was passed from the scheduled property. I have filed an vacating stay application in both the matter, my lord.
Vacating. Yes. This matter on 16th. Yes.
Stage ಇದ್ರೆ after vacation.
Fresh matter tomorrow, Mister.
My lords,
Withdraw tomorrow. Yes. Kodi nodi correct.
my lords, parties have settled the matter and they're trying to withdraw the matter, my lords. Can you
Withdraw
withdraw?
tomorrow. Yes.
Tomorrow.
Yes. 15th. Yes.
Your
It's a
lordship kindly,
disposed of matter.
RFA one pending matter for extension of the interim order, your lordship. Because I have filed an application for restoration.
Yes.
Tomorrow, your lordship.
RFA will have it on 10th. Yes. 10th.
Lords, this is a
10th.
disposed of
Much-
matter.
23 na.
20, sir, 20.
Here.
Next.
16th. Yes.
My lords, this is a disposed of matter. My lords had disposed of this matter, directing the parties to maintain status quo. My lords, we have filed an IA for clarification. Now, my lords, the parties are not able to use the road, my lords. They're not able to install any pipes for wastewater management. My lords, if my lords may kindly modify that order. We have filed, the order is of status quo. We have filed an IA for clarification, seeking direction of this honorable court to install pipes, my lords. Wastewater hogak jaga illa, Swami iga.
That and all we can't do. Yes. 16th. Yes.
Grateful.
because the building has completely collapsed. Just second week you can make any.
27th. Yes.
My lord.
Pending.
24 sir.
28th. Yes.
Your lordship, it's an RFA of 2022, your lordship.
RFA 30. Friday.
Pending, my lord. Earlier date was given, but not listed, my lord.
Pending
Seniors,
matter.
yes.
26th. 27th. Yes. Modification of interim order. Yes. 27th. Yes. Withdrawal tomorrow.
ಬಂದಿದ್ಯಾ? ಹೇಳಿ ಸಾಹೇಬ್ರೆ.
Lord, one matter, one fresh matter for 2:30.
Tomorrow. No 2:30.
Please.
Fresh matter tomorrow. Tomorrow. Fresh matter tomorrow. Yes.
ವಿತ್ಡ್ರಾ ಮಾಡೋದು ಯಾರು? ಹೇಳಿ ಸರ್ ಸಾಹೇಬ್ರಿಗೆ ಹೇಳಿ. ಸೀರಿಯಲ್ ನಂಬರ್
37, your lordship, sir, any permission to withdraw it.
37.
Filed in a memo for that 9915.
Please, your lordship.
Yes, filed in a memo seeking leave of this court to withdraw this writ petition. Memo is taken on record. The above writ petition is dismissed as withdrawn.
Adjournments, if any adjournments,
Serial number 47.
Yenamma adu?
to withdraw,
Serial number?
Serial number 47.
1.
serial number 1 withdraw.
Yes. Correct number note.
Number correct ಇದೆ.
Yes, filed in a memo seeking leave of this court to withdraw this petition, dismissed as withdrawn.
No, 47.
128. You are appearing for? At the request of petitioner, leave this matter after 4 weeks.
Serial number 47.
47. Interim order granted earlier is extended till next. 47. Yes.
One
Lord,
week-
serial number
one-
66.
47.
Voice.
Yes, at the request of counsel for the petitioner, leave this matter. 2 weeks time is granted.
1
to
week.
comply. 1 week to comply of subjection.
My lord,
73.
ಮಾಡಿದೆ.
73. Interim order granted. Elida, awaiting service of notice. Interim order granted earlier is extended till next.
My lord, serial number 103, my lord.
Bharat.
103, my lord. Process has been taken on 27/3 of last month, my lord.
10.
3. Process has been taken on 27/3 of last month, my lord.
Learned counsel for the petitioner submits that needful has been done. Office to verify and proceed for.
Interim order may be extended.
Interim order granted earlier is extended till next.
My lord, 66, serial number.
Yes.
135, my lords.
135.
Last matter, my lords. In this case, I am representing the petitioner, my lords. Already informed to the respondent counsel, my lords.
135. At the request of counsel for the petitioner, leave this matter after 3 weeks.
My lord, serial number 134, my lord.
Till next.
In the same list.
88. 88. Awaiting service of notice to respondent. Interim order granted earlier is extended till next date of hearing. Yes.
My lord, 66 serial number
and
134, my lord.
134.
Serial number 134. In that, I'm appearing for the respondent, my lord. Actually, on the last occasion, your lordship had directed the office to verify my statement of objection filed to the interim order granted earlier and put up in the preliminary hearing, my lord. And it is today also, it is posted in the B group.
Verify, madam.
Then here the court officer orge.
We will verify. If that order is there, we'll have it.
Order last time, 25/3/26 ಗೆ ಮಾಡಿರೋದು. ನಾನೇ ಇದ್ದೆ ಅವತ್ತು. I have even shown my statement of objection filed by me.
No, fresh matter.
Fresh matter, my lord.
Notice is not issued.
Notice is issued, I filed my wakalat
Then
and I
why-
filed my objections also.
Then
It
why
was
it is
supposed to come
preliminary?
in
Why preliminary hearing?
B group it is posted, my lord. That's what I don't know, my lord.
ಗೆ ಬರ್ಬೇಕಲ್ಲ preliminary hearing ಗೆ ಯಾಕೆ ಬರ್ಬೇಕು?
ಅದು ಈಗ ನಾನು objection ಹಾಕ್ದೆ. Interim order
Objection
ಆಗಿದೆ.
ಹಾಕಿದ್ರೆ ಬರ್ಬೇಕಂತ ಎಲ್ಲ ಐತ್ರಿ. There is no such.
ಅದು vacating ಹಾಕಿದೀನಿ ಸ್ವಾಮಿ, urgency
Vacating
ಇದೆ.
ಹಾಕಿ. Vacating-
Urgency ಇದೆ, ಅದಕ್ಕೋಸ್ಕರ ದಯವಿಟ್ಟು.
No, if you file in a vacating, we'll pass an order.
Vacating ಹಾಕಿದೀನಿ. Objection ಇದೆ, vacating ಹಾಕಿದೀನಿ. ಈಗ ಬೇಕಂದ್ರೆ ನಾನು ಆಫೀಸ್ ಕಾಪಿ ಕೊಡ್ತೀನಿ ತಮ್ಗೆ.
There is no interim application for vacating.
Application objection ಹಾಕಿದೀನಿ.
Objection ಗೂ vacating ಗೂ ವ್ಯತ್ಯಾಸ ಇದೆ ರೀ. What is this, Mr. Counsel?
My lord, serial number 66 and 60.
Filed an application for vacating.
ನಾನು application ಹಾಕ್ತೀನಿ ಇನ್ನೊಂದು.
Vacating application ಹಾಕಿದೀರಾ?
ಅದು ಹಾಕಿಲ್ಲ, objection ಹಾಕಿದೀನಿ. Vacating interim order ಗೆ objection ಹಾಕ್ದೆ. My lord, serial number 66 and 66.1.
Is this matter next week?
Serial number
ನಾವು
118.
ಡೇಟ್ ಒಂದು ಫಿಕ್ಸ್ ಮಾಡ್ತೀವಿ.
Vacating application ಹಾಕಿದ್ರೆ ಬರುತ್ತೆ.
ನಾಳೆನೇ ಹಾಕ್ತೀನಿ. ನಾಳೆನೇ ಹಾಕ್ತೀನಿ. ಅದಕ್ಕೆ ಒಂದು ಡೇಟ್ ತಾವು.
On 16th, yes.
My lord, 66 and 66.1, my lords. Matter may kindly put on the 27th, my lords.
60?
66 and 66.1, my lords. I've informed the other side. Please, my lords.
You are appearing for?
My lords, I appear for the petitioner in 66 and for respondent in 66.1.
Yes, at the request of counsel for the petitioner. Is this matter?
27th, my lords.
28.
Please, my lord. Interim order may be extended.
Extended till next date of it.
Hello,
Most
serial
grateful.
number 118. Appear for the petition in that matter, my lord. The notice has not been issued. Your lordship on the last date of occasion raised the issue of maintainability. So I filed an amendment application pertaining to my writ petition on the same. It's been placed under hearing for interlocutory applications. If your lordship will place it for preliminary hearing as a fresh matter because maintainability has still not been addressed. 118.
Notice is not yet issued.
No, notice not. It's only on the issue of maintainability.
Yes, leave this matter in preliminary hearing list
Monday, my lord.
on 7th. Yes.
Posting. Vacating stay, my lord. Kindly on Monday.
Not Monday, madam.
My lord,
Yes.
we are engaged with the senior counsel in this matter, that's why.
16th, yes.
16th.
Dali, withdrawal tomorrow.
Lord, quote number 28 matter. My office objection, only one date has to be corrected.
Serial number.
Serial number 105.
10?
I'll do it to the post from 105.
ಮಾಡದಿದ್ರೆ ಮಾಡಿ, yes, yes.
Serial number 26. Kindly explain.
It can be,
20?
next week it can be posted.
26. What?
For the petitioner.
Hmm.
I need some. Kindly next week.
At the request of counsel for the petitioner, read this matter next week. Yes.
Serial number 104.
104.
Lord, 1 year, my lord, they have taken to, even the process have not been given, they have obtained the interim order. Process have not given because colluded, it's a colluded petition filed by them. Without extending the interim order, my lord, because they posted for arguments, suit for partition, posted for argument. Production of the court witness, production of document application, that has already application was allowed, the document was marked. Now, the unnecessary to prolong this case, though it has been, writ petition was filed by taking the interim order.
The other side is not there.
That's right, my lord, but
Let us see when the
they're prolonged, the only intention is, they want to prolong the case.
Let us see when the matter is called. Yes, they are not.
Serial number 97.
Serial number?
Serial number 97, my lord.
Yes.
97, I appear for the petitioner. I pray for
Yes.
a week's time, my lord, because it has returned as not claimed.
Yes, sir, the
The-
request of counsel. Yes. At the request
Interim
of
order
counsel.
may be-
Yes. Request of the petitioner, leave this matter up to 2 weeks. Interim order granted earlier is extended till next date of hearing. Yes.
Much obliged.
Photo number 28, matter, my lord. Photo number 28.
Yes, 20.
Serial number, list 1, my lord. Serial number 39, my lord. Adjournment.
No,
my lord.
all
We are
that-
for the petition.
No, all that matter, whichever date you want, you ask that court officer and take the date. In
Interim
this-
order.
from tomorrow, no, it is not there. From Monday, any date, if you want, you can take. Interim order, wherever is there, we'll extend that. Interim order extend.
My lords, memo for posting, my lords. Lords,
First matter,
No, my lords. It's old matter.
which year?
2024, my lords.
Yes, 28.
Date was given twice, my lords, but the matter was not listed before the
28,
court.
28, yes.
Yeah,
Memo for posting, my lord.
Which year?
The 25 only. 25, my lord.
25, sir.
Yes, 28, yes. Pending. Pending matter. Which year?
25 matter, but this, without jurisdiction, not the injunction.
Yes, 22nd, yes.
Number 1 for preliminary hearing, serial number 1 adjourned, serial number 2, YV Prakash for petitioner.
Appear for
Corrected
the
matter, HDS
respondent,
Sanghvi. Serial number 2, YV Prakash.
Appear for the respondent, my lords.
Yes.
Suit for recovery, commercial court, my lord.
Hmm.
At the stage of reply arguments on the main, the plaintiff has filed an application for reopening the case and has wanted to produce several documents, that is running accounts. That has been allowed. Again, that this petition has been filed, my
Where
lord.
is that order?
It's in page number 42, my lord. In page number 42.
Yes. Read.
Heard counsel for plaintiff on IA number 8 to 10. Defense are already heard. These IAs are filed by the plaintiff at the stage of arguments for reopening evidence that recalling PW1 for further chief examination for the purpose of marking one document. That is the ledger extract which is produced along with IA number 10. The principal objection raised by the other side is that the document is being produced after inordinate delay. However, the law is settled that no relevant evidence should be kept out of court. It is noted that although some of the invoices in respect of which payment is claimed relate to the year 2017, in the trial, the ledger extract of the year 2017.
Mr. Counsel, this is a commercial suit.
Yes, my lords.
General suit, it has been given a finding.
Yes. Now,
Then a delay, you have to be explained under.
yes. The learned trial court judge has very well held that this document is relevant. Next paragraph, your lordship may kindly go. It cannot be said that the producing this document, plaintiff is trying to fill up lacuna in the evidence because there is a clear averment in the plaint. And also invoices have already been produced to show that the claim is being made, including for the invoices from the year 2017, and only ledger extract is being produced.
Even if it is a relevant, law is that why you have not produced earlier?
Yes.
That is
Earlier, yes. Now, the petitioner is very smart enough, my lords. He has not produced the entire order sheet before this honorable court. I request your lordships to please go
What is
through
that
the
order sheet?
order sheet of this case. Your
Yes.
lordships may kindly.
Then we'll hear.
Only, I will not conclude, I will not take 5 minutes.
This is for a preliminary hearing, Mr. I
My
can't
lord.
hear you detail here.
My lords, I will not take more than 5 minutes. Only 5 sentences, I will conclude my arguments.
Yes.
Your lordships may kindly appreciate.
Yes, what is that? You can't
It is
give
an
it.
order sheet. It is an order sheet. It is a
What do you
complete
want to
order
say?
sheet.
Yes, put it.
He produces only the operative portions. At the time of written statement, the petitioner has not produced any scrap of paper before the trial court. At the time of leading evidence, he come up with the 3 applications. Your lordships may kindly peruse it. Order sheet dated 18/6/24, my lords. 3rd page, I have marked it from the
Yes.
written statement is filed by the defendant 2 sets.
Yes.
Then later on 11/7/2024, there is no representation for the defendant. Since the defendant have not filed documents, there is no question of plaintiff filing statement of admission and denial. Later, my lords, your lordships may turn it to the next page. They produce three application under order 11 rule 110 that has been allowed by the trial court.
But you have not challenged that.
Because, my lords, it is already they have stated that no document has to be kept out of the court. It has to, your lordship may kindly appreciate.
You see that commercial.
Yes, my lords, now the Commercial Court Act is very clear. If the prima facie reasons has been specified, the trial court can allow the said application.
Yes.
And my application has been allowed.
Yes.
The plaintiff petitioner here is not appeared before this honorable with clean hands.
Mr.
They one hand they have not produced at the time of written statement. I'll conclude.
Whether they have produced is not
No,
material.
no,
The law is that when they filed in a petition,
My lord,
all
no,
documents
there is a
must be
best-
disclosed.
that
is
has
the
been
law.
explained.
Those documents were in their
My lord.
custody at that filing of suit
Yeah,
itself.
That has been
You are in
explained
my
by the
written
trial
statement
court.
itself.
Third, issue notice.
Notice ಆಗಿದೆ.
ಆಗಿದೆ ಸ್ವಾಮಿ. Already arguments ನಲ್ಲಿ post ಆಗಿರೋದು 3 they are from 24 they are prolonging the matter.
I am not prolonging, Mr. Don't say like that. See,
No, wait.
every time he is submitting like that.
I have convinced, I am granting an interim order. We'll see that after hearing. Yes. Heard. Issue notice. It is not, see, court has given a finding like in a general suit.
Please,
This is
My
not
lord,
that, Mr. Yes.
the law is well settled for both the parties.
Heard. Issue notice. Stay of further proceedings in OS number 143 of 2024 pending in the file of 80.
Stay has already been granted, my lord, in this matter.
Stay is there.
Already it is there.
Then why it is posted today?
They have moved and it has been posted for preliminary hearing.
No.
It's already been, stay has already been granted.
Of three matters has been
After hearing
connected,
them
my
all, stay has
lords.
been granted.
Other 2 WPs has been connected along with this petition.
Other, in that also interim order is there.
Yes, my
Yes,
lords.
yes. Now all the 3 matters. interim orders are
Otherly,
there.
no, they have not produced any documents in that also.
Yes, leave this matter in B group on 21st. Yes, we'll hear that.
Interim order may kindly be extended.
Interim order
My
extended
lord,
till next.
matter of 24. Next week, your lordships may kindly
They're
grant
all
us.
24, that's what I am
Yeah,
surprised.
your lordships may please.
Without filing any vacating, it is coming. Yes.
They are seeking this, last year also, it has been
Yes,
listed,
yes,
they are
we'll hear.
seeking more than 10-15 adjournments they have taken.
Kindly see the order sheet, my lord.
Yes. Yes.
It's not against to the records.
Correct.
First time, last occasion, I took time.
Badrinath.
Which date, your lordships?
21st. Yes.
Defendant's writ petitioner. Plaintiff died during the pendency of the suit.
Hmm.
LR application filed. We have disputed that the LR to be brought on record is not the LR of the plaintiff. Without inquiry, the court allows the application.
Who are that by LRs? What is the relationship between that?
She claims that she is the daughter of the plaintiff. We have disputed. We have disputed.
Court file.
Yes, where is that order?
Next year, Jim.
Who are you?
I am the defendant.
No, what are you? Are you family members or a third party?
No, his plaintiff is, herself is a third party.
No, that suit for?
Suit for partition.
Partition.
Suit
Now
for
that, what
partition.
is the relationship between the plaintiff and that?
Well, we have disputed the relationship with the plaintiff.
Yes,
There
where is
no-
that order?
Annexed here, G, my lord. Page number 42.
42.
Counsel for defendant number 1, 2. 5725, order date 5725.
57?
5725. Page number 42, my lord.
42, yes.
Counsel for defendant number 124 filed application 151 CPC along with written statement. Plaintiff counsel submits that he has no objection to the above IA. Accordingly, IA is allowed on cost of rupees so and so. The written statement is taken on record. Plaintiff counsel present and submits that LR application is still pending for consideration. Hence, peruse the IA and the same is hereby allowed in the interest of justice. So without inquiry, seriously disputed.
Now, what is the stage in the suit?
Stage is that now the plaintiff has to file amended plaint. That is the stage.
Where that, have you filed an objection to the, for an
Yes.
IA?
I have filed objection.
Where is that?
That is annexure F minute. It starts from para number 3.
Where is that objection?
Annexure F minute, page number 38.
38.
38, 3.
What is?
Para number 3. These defendants submit that Shivamma is not the wife of late Puttirappa. That is the plaintiff note. As shown in the cause title, Shivamma was Pinston. These defendants are at loss to understand that how Shivamma is shown as wife of late Puttirappa. These defendants do not know late Puttirappa and he is allegedly the husband of Srimati Shivamma. Hence, the proposed legal representative.
Notice. Stay of further proceedings in OS number 392 of 2022 pending in the file of first additional senior civil judge JMFC Ramnagar till next date of hearing.
Cell number 4, Kenduli SM.
For the petitioners, my lord, the defendant's petition, they are the bona fide purchasers, suit for partition. I have filed the application to framing additional issue that was rejected.
What is the traditional issue you are sought for?
The partial partition is not maintainable. They have not mentioned the other properties. They have taken a contention in the plaint. I kindly request the lordship. Para number, page number 10, your lordship.
Page number?
10, your lordship.
Where is that order, Mr.
Order is page number 29, your lordship.
Read.
Page number 29, lordship. Suit for partial partition is not maintainable and plaintiff has not included other.
No, you read from 28.
28. Yes, lord.
Admittedly, plaintiff has
Admittedly, the plaintiff has filed the present suit seeking partition and separate possession in respect of the suit scheduled properties. After the institution of the suit, defendant number 3 and 4 filed their written statement admitting the relationship, denying the other plaint government. At para number 6, they have pleaded that suit for partial partition is not maintainable and the plaintiff has not included other family properties in the suit scheduled property. However, the written statement governments are silent on as what are all the properties available for the partition.
You have to disclose which are the properties.
Humble submission. I kindly.
Where is your written statement?
My written statement I have taken contention. Before that, your lordship, I request the page number 10 of the plaint, your lordship. Ink page 10, your lordship. Para number 6. Last 4 lines, your lordship.
Yes.
Para number 6. Since the defendants hurriedly attempting to dispose of the only surviving suit properties, presently the suit is filed only with respect to same. The other property details will be furnished later. This is the plaint.
Okay, yav the property.
Lordship, this is the plaint. Their contention. This is not my contention, lordship. They have not disclosed.
The manager of the family requested to allot 1/3 share by the meets and bonds.
This is the plaint, your lordship.
But the defendant outrightly rejected the claim. The plaintiff directed to get share. Since the defendant hurriedly dispose of only surviving suit, presently the suit is filed only in respect of the same. Other properties detail will be furnished later.
In WS, I have taken contention, lordship.
Where is that your contention?
Page number 15, your lordship. WS, para number 16.
1/5.
Yes, your lordship. Para number 6, middle portion. As per the pleadings of the plaintiff, partial partition of the suit scheduled property is not maintainable and liable to be dismissed with costs if the plaintiff other family property is not included in the suit scheduled property for want of partition.
Stay of further proceedings in OS number 332 of 2023 pending in the file of Principal Civil Judge JMFC Shimoga till next date of hearing.
Okay.
Cell number 5, T Krishna for petitioner, Tejasvi KV.
Lord, I beg to appear for the caveat.
Appear for the petition.
Yes.
My Lord.
High Counsel Udayala appears in this matter. Is on his legs before the other court may request for a short accommodation.
Yes, when do you want? He came.
My Lord?
He came.
I'm sorry.
Yes.
I had circulated a compendium of cases, whether my lordship.
Yes, let us
Yes,
see.
yes,
what
yes,
is
of
this?
course.
Yes.
Lord, here, if your lordship take, my lord, the plain, which my lords get at page 47.
46.
46.
Yes. Yes.
The suit, my lord, is for in respect of an immovable property.
Yes.
Please come to, my lord, page 52 or 51. My lord, I'm sorry if there's any change, page number is mistake, my lord.
Yes.
Your lordship may pardon me.
51.
52, bottom.
Yes.
Otherly, permanent injunction restrain the defendant from interfering in the peaceful possession and enjoyment of suit schedule property. Now, if your lords look at, my lord, para 22 and 23,
Yes.
or 23 alone, suit is for injunction and a court.
No, that page or para?
Para, my lord, 20, idu, page 52.
Page 52, there is a prayer.
ಹೌದು ಆಮೇಲೆ ಅದರಲ್ಲೇ ಪಾರ 23 ತಾವು ನೋಡಿದ್ರೆ
Yes, 23, yes.
Suit is for injunction, court fee of rupees 1,000 is paid on the memorandum of complaint under section 26C of the Karnataka Court Fees and Suits Valuation Act 1958. For the purpose of jurisdiction, my lord, is valued at 6 lakhs.
Yes.
We have paid a court fee on, my lord, on that 6 lakhs.
Yes.
If your lords look at, my lord, the written statement on the next page, at, my lord, running page 58, not a whisper that the court does not have jurisdiction.
Yes. Yes.
What is not there, my lord, I can't, my lord,
yes.
say. Not a whisper. In the entire written statement, I have gone through, my lord, it
Yes.
in extenso.
Yes.
That, my lord, the court does not have jurisdiction is not even, my lord, the case made out.
Yes.
Thereafter, my lord, they filed, my lord, an application. My lord, we had filed an application for IA. That was allowed for injunction.
Yes.
Matter came up before your lordship's court. If my lords come to, my lord, running page, you would have judgment delivered. Sandesham. Please come to, my lord, running page.
131.
Order passed by this honorable court, my lord. 100.
Yes.
131 is a different judgment, my lord, altogether.
Yes.
100, if your lords has come to.
Yes.
Please come to, my lord, what is the order that has been passed?
Yes.
Page 101, bottom. Learned counsel, the appellant absent. Counsel for the respondent is present. Counsel for the respondent brought to the notice of this court the valuation made before the trial court to the tune of 6 lakhs in para 23. Learned counsel for the appellant in the morning session submitted that the property value is more, and he submitted that this court is having jurisdiction. Said content cannot be accepted, my lord. Therefore, what I am submitting is this honorable court noticed, my lord, that 6 lakhs is, my lord, the valuation.
Yes.
Thereafter, my lord, they file an application, my lord, under section 8 of the Arbitration and Conciliation Act.
Yes.
That was heard. During the course of the hearing, my lord, of that application,
Yes.
trial court, my lord, passes this order, my lord, at running page, my lord, 41, saying that, my lord, it does not have jurisdiction. Page 41, my lord, is the relevant, page, my lord, page 21, my lord, sorry. 21, my lord, sorry.
21.
Yeah, my lord, ಇದನ್ನ ಹಾಕ್ಬೇಕಾದ್ರೆ ಎರಡು page 41, 21.
21 is that.
Yes, my lord.
Yes.
That's the impugned order.
Yes.
Trial court, my lord, comes to the conclusion that, my lord, the plaintiff is to be returned. My submission to your lordship is, well, please come also, my lord, to come to, my lord, page 47.
Yes.
Or, I'm sorry, 33. 33 at the bottom.
Yes.
In view of the ratio laid down in the above judgment, since the present suit is only for bare injunction, not for any declaration title, there can't be two valuations as far as jurisdiction court fee is concerned. Hence, the court is directs the return of the plaintiff to enable the plaintiff to present the suit before the jurisdiction civil judge court. As indicated in the order sheet, plaintiff has paid a court fee of rupees 39,385 by way of deed. That's, my lord, equivalent to that 6 lakhs. My submission to your lordships is the jurisdiction, my lord, is, my lord, can be only, my lord, in the court,
Yes.
which has, my lord, the pecuniary jurisdiction. If my lord sees the jurisdiction, my lord, is based on, my lord, the value. The value of the property, my lord, we have valued at 6 crore, 6 lakhs. 6 lakhs, my lord, comes within, my lord, the senior division, not the junior division. Civil Courts Act, my lord, if your lordship take.
Yes, 5 lakhs is the
Yes,
limited.
yes.
Yes.
Therefore, The
No,
court,
this-
my lord, had jurisdiction. What?
This is filed in senior division.
Yes, my lord.
6 lakhs is the senior division.
Correct.
Yes.
The court says, under section 26C, both, my lord, must be the same valuation. If you are to look at, my lord, the Court Fees Act, it specifies 26C, my lord, you can value it at any amount.
Yes.
But then, Court Fees Act.
No, see, you may be wrongly stated 1,006 lakhs.
Correct.
6 lakhs has to be taken.
That's all, my lord, I'm saying.
See,
And, my lord, not only that, I also want to place before your lordships two other things.
Yes.
If they have not raised, my lord, the plea of jurisdiction for the last 8 years,
Yes.
can, my lord, that be raised, my lord, for the first time? Section 21, my lord, is very clear on that aspect. Secondly, my lord, I'll give you a lot of, my lord, two judgment for my lord's consideration.
Now that you have taken notice,
Well,
we'll hear the matter.
in fact, I think last time I had circulated a bunch of judgments. My learned senior wanted to peruse them.
That's all right, I have perused it.
Yes.
Yes, no, now that, what is the value of the property?
My lord, I will, if my learned senior is completed, I will like to.
No, then we want to hear finally, we'll
Yes,
fix
my
that.
lord. Yes, my lord.
Not for that.
No, my lord,
preliminary-
we will, I'm ready with the arguments.
No. Today I can't hear that on preliminary hearing as a final.
Your lords may give a fixed date. my
Fixed
lord.
date.
Yes,
Because so many matters there in
I
the
know,
final hearing,
naturally,
we can't-
because morning,
Therefore,
100
yes,
people
morning,
are here.
yes.
And your lordships are still smiling.
Only that you are the respondent. No, other respondents are there. You are you are appearing.
Yes, I appear for all.
You are appearing for all.
Yes.
Yes. So and so, Cavator undertake to appear for respondent number 1 to 4.
If 15 minutes, I can convince my lordship that this is a matter which has to be.
It will take, my lord,
dismissed.
at least about an hour, I'll point out, because.
No, again, he has to answer,
Yes,
then
yes.
it will take.
My lord, my preliminary objection is there with regard to the factum that if you come to this court with unclean hands, you cannot invoke section 227.
Yes.
As far as my lordship is not sitting in a civil revisional jurisdiction, they have not filed a civil revision here.
Yes.
If an extraordinary jurisdiction is sought to be invoked, my lord, they cannot pollute the stream of justice. The Supreme Court in a catenary of judgments has held.
Yes.
Now, my lord, I would take my lordship. What they do is they have precipitated the recusal of a former judge of this court in an arbitral proceedings by intimidation, by threatening him. My lord, when I'll take my lordship to few paragraphs.
So that which date you want?
My lord, any Thursday, my lord, next Thursday of my lordship.
Thursday, no. 15, 16th is Thursday, no? 16th or 23rd, Thursday.
16th is fine, my lord. 16th.
Wednesday, Thursday, or 23rd.
23rd, my lord, is better. 16,
23rd.
my lord, too many parted matters are there.
Yes, leave this matter 23rd in B group. You are taking notice to all respondents.
Yes, my lord. If can I request top of the board, my lord, so that it could be taken up.
23rd.
Top of the board on 23rd.
Top of the board, see, first 80 matters is preliminary hearing first time. That should be in the top of the board.
But subsequent to the same.
Subsequent it will come. Yes. That is what every day there are more than 100 matters preliminary hearing. Without preliminary hearing, I can't go to that final hearing matter because there are urgent matters, interim order. The court has posted the matter for an judgment. Therefore, only after that I can take other matters. Yes.
Serial number 6, Venkata Raghavan R. Serial number
Petition,
6.
my lords, this is a
Yes.
petition invoking the supervisory jurisdiction of this honorable court.
Yes.
The lower court has gone ahead and accepted the written
Now, what is the
statement.
suit for?
It is a suit. We have provided an interior services to the respondent and we are claiming the money for the same, my lords. That is the crux of the suit.
No, suit for recovery.
Suit for recovery of money. Yes, my lords.
Yes. Then what has
So
happened?
written statement ಏನಾಗಿದೆ ಅಂದ್ರೆ ಅವರು beyond the period of 120 days they have filed the written statement. The order, my lords, at page number 246.
No, what is that order you are challenging?
My lords, they have accepted the written statement beyond the period of 120 days.
Where is that?
That
order?
impugn order is annexure T, page number 271, my lords.
Annexure T.
Annexure T, page 271.
Yes.
June alle mugiyate 120 days. July 7th ಗೆ they have accepted. This order that has been passed states that they are accepting the written statement, my
The written
lords.
statement.
My lords, also they have accepted a counterclaim also.
In view of the memo hereby dismissed as not trust, defendant filed an IA permission to take wakalat and record heard the allowing interest of justice. Accordingly, wakalat filed by the along with the written statement counterclaim is hereby taken on record. Cost of ₹800 for a work meant by plaintiff counterclaim. The defendant and the defendant is directed to furnish valuation slip. Yes, when that summons is served.
My lord, on 246, that is on 31st January 2025.
This is a commercial court or this thing?
Normal civil court, my lords.
When the suit is filed?
The suit was filed in 2024, my lords.
Where is that 120 days is restricted?
My lords, at page number 246, 31st January 2025.
No,
here.
where is that law which has been prescribed only 120 days?
Order 8, my lords. Order 8.
Subject to satisfaction of the court.
Yes, my lords. Order 8 says the written statement that beyond a period of 120 days, there has to be reasons recorded by this court. My lord, this court has not recorded any reasons whatsoever. It has gone a step ahead, flouted the law, and also accepted the counterclaim, my lords. I mean, a counterclaim is filed, and IA has to be.
You take notice.
Yes.
Heard.
My lord, we have also filed an IA for stay of the for the stay, my lords, and IA also has been filed.
For what?
For stay of those impugned order, my lords, and the
impugned order cannot stay. You
for
can
the proceedings, my lords. My apologies.
Proceedings can be stayed. Yes.
For the proceedings, my lords. My apologies. For the proceedings.
Further proceedings in OS number. What is that OS number, Mr.?
1743, my lords.
Further proceedings in OS number 1743 of 2024. Pending in the file of second additional senior civil judge, Bangalore, rural, till next date of hearing. Yes.
Till number 7, Pramod R.
Lord, suit for their injunction has been filed against the Tahsildar and others government officials. Wherein the suit, my lord, I have filed an application along with the plaintiff, my lord, section 80 application for exemption of notice to the government, my lord. That application was rejected. There is no urgency, my lord. Against that, we have preferred this writ petition, my lord. In this matter, my lord, I am in the possession of the associated property. I have also filed an application for regularization at annexure G, my lord. And now they are trying to dispossess me from the suit schedule property, my lord. Therefore, I filed an application for exemption of notice to the government, that is Tahsildar, my lord.
What is that order?
That is order at my lord annexure. Page 54, my lord, annex H. 56 is the, 55 is the order portion, my lord. 55 page.
Read.
The plaintiffs have filed IA number 1, section 80, subsection 2 of CPC with a prayer to permit them to sue the defendant by dispensing of the prior notice as required to be given under section 80 subsection 2 of CPC. In the affidavit annexed to the IA, the plaintiff contends that they have filed the present suit for the relief of injunction raised IA to be allowed and the notice to be dispensed. Heard arguments of the counsel or plaintiff are argued the material on record. Section 82 lays down that a suit to obtain the urgent relief may be instituted with the leave of the court, and the court, if it is satisfied there is no urgent relief, the court can return the plaintiff for presentation after complying with the requirement of section 81. The affidavit and document do not disclose the requirement of any urgent and immediate relief against the defendant. Therefore, on being satisfied there is no urgency relief required, hence IA is dismissed.
Yes, where is government?
ಇದರಲ್ಲಿ ಸ್ಟೇಟಸ್ ಕೋ ಆರ್ಡರ್ ಆಗಿದೆ ಸ್ವಾಮಿ, ನೋಟಿಸ್ ಆಗಿದೆ, ಲಾಸ್ಟ್ ಟೈಮ್
ಆಗಿದೆಯಾ?
ಆಗಿದೆ. ಇಂಟ್ರಿ ಆರ್ಡರ್ ಇಲ್ಲ.
Yes, leave this matter in B group.
Interim order may kindly.
Interim order granted earlier is extended till next date of hearing.
Till number 8, Mahesh BJ for petitioner.
Caveat, my lord.
Yes.
Need to file the reply.
Lord, a futile exercise, my lord, is sought to be made, seeking appointment of commissioner. Lord, because considering the relief sought for in the suit, Lord, the appointment of commissioner is of no relevance at all.
Suit for?
Suit is, my lord, for declaration that a joint development agreement executed between the parties is sought to be cancelled. 2013, my mother executed a joint development agreement in favor of the defendant for construction of a property, of a building in my property.
Yes.
But he did not commence the work.
What
2017, I issued legal notice and sought for cancellation of the agreement.
Who has filed this application?
This application is filed by the defendant.
What is that?
Defendant's contention is,
No,
there
where is
was-
that prior in that application?
prior is not to inspect the property, page 48.
Yes.
To visit the scheduled property and to submit the report of the encroachment on the suit scheduled property by the third party or Srimati Veena Saraswati on the suit scheduled property. But suit is not for possession, mandatory injunction or anything.
Cancellation of?
Suit is cancellation of joint development agreement because he
By
did
the
not
possession.
proceed with the
Joint development
construction.
agreement is for the construction of the building on the social premises, my lord. Other the.
No,
the-
cancellation.
One submission, my lord. Plaintiff has not yet suppressed the plaintiff, the petition.
No, suit is for cancellation of some documents. That's
Yes.
all.
That's all. Lord.
What is that required for the commissioner to give an, even commissioner says that there is an encroachment. Is it related to that? What is that order of the court, Mr.?
My lord, one submission, my lord. Then
Court
I'll make my
proceeded to hold
submission.
that, since in cross-examination, PW1 has given a concession that
Page 14
he has
maybe.
no objection.
Page 14
A
maybe, look
concession
into.
given by a party cannot be a ground.
Page
No, no,
14 maybe,
just I'm
one submission, my lord, only
14,
page
ma'am.
14, page 14 maybe. It is the order portion, my lord. It is order passed by the trial court, my lord. Page 14, internal page 14. During the course of examination of PW1, that is plaintiff, on 9/11/2023, in page number 15, para 8 of the cross-examination of PW1, she stated that she was confronted with 3 photographs and suggested there was trespass in the property by Veena Saraswati. She has closed it and protected her site, but PW1 denied the location and site of the property. She stated that Veena Saraswati has recovered her 20 feet property and in the process also encroached her property to the extent of 300 square feet, and she submitted no objection if a court commissioner is appointed to inspect the spot and report the encroachment if any. Based on this cross-examination, the learned counsel for the defendant sought to appoint an advocate commissioner to make a local inspection of the property of plaintiff and defendant to ascertain who has actually encroached upon the suit property, to what extent there is encroachment to it. The one of the remedies sought by the plaintiff is mandatory injunction and damages also. The case of the defendant is that since there is an encroachment by third party in the suit property, therefore authorities are not granting the necessary building sanction plans for construction of the building in the suit property. Therefore, it is necessary, just and necessary to inspect the suit property and to ascertain whether there is encroachment of the.
No, you
suit
also
property.
sought for permanent injunction.
Permanent injunction, my lord, not to, permanent injunction, mandatory injunction, a direction to the sub-registrar to execute the.
Prior C.
Yes, my lord. Permanent injunction is, my lord, not.
Restraining defendant from interfering into the peaceful possession and enjoyment. Then they have to find out that who is in the possession. And you have also not
No, it
dispute.
is, no, it is not their
No,
case
no, no, no.
that.
This is commissioner report is not in respect of the prior A and B.
Yes,
Prior A and B, commissioner ನೀವು possession ಅಲ್ಲಿ ಇದ್ದೀರಾ, ನೀವು encroach ಮಾಡಿದ್ದೀರಾ ಅಂದ್ರೂ ಕೂಡ that will not affect the prior.
No, I
The
understood,
prior
ma'am.
C is that you sought for an injunction.
No, he admits that he is nowhere in possession. It is not his case. He is only a developer. It is not his case is,
Yes.
since there was an encroachment of road, BBMP did not sanction the
Yes.
plan. That is the reason he did not proceed for construction of the building. And that is the reason. And he admits that he has no objection for cancellation of the joint development agreement. That is his cross-examination.
You are
Reason
taking
by
notice
law.
It
to.
is not his case
Plan-
that he is in
plan-
possession of the
Till here.
property.
For the reason of.
Mister, you are taking notice to whom?
Sole defendant, my lord.
No, there are 3 defendants. Serial number ಎಷ್ಟು ಇದು?
Well, I am for the defendants. Sir, I am for the plaintiff's respondents.
Yes, you are
If
taking.
plan was granted, my lord,
Three
I would have
notice.
completed the construction.
Well, I am taking notice for all the respondents,
No, who is?
for the plaintiffs, my lord.
You are appearing for the plaintiff.
I am for
Mister.
the plaintiff
You can't
respondents.
take notice to others, mister. Either you can dispense it, not taking notice, mister.
It can
You
be
are the
dispensed
plaintiff, how can
because
you take notice?
one
to others?
person can, my lord.
Yes, you are appearing for R1.
Yes, my lord.
Caveator is undertake to appear for respondent number 1.
2 and 3, my lord, notice may be
1 to
dispensed. They
3,
were the
filed in a memo
co-plaintiffs.
seeking dispensation of notice. What is the stage in the suit, mister?
Now the.
Matter was posted for,
Yes.
I submit, my lord, matter was,
Yes.
but
how-
matter was posted for final arguments. I completed my arguments. At the time of reply arguments of the, my lord, defendant, this application is sought to be pressed.
Yes, yes.
One submission, my lord, one
Here
submission.
that
One day
will
only.
grant
One day
stay, mister.
submission, my lord.
ಆಯ್ತ್ರಿ
ಫೈವ್ ಟೂಗೆ ಅವರು ಒಂದೇ ಒಂದು
Any day
ಅವ್ರೇ-
next week,
he
Lord, it can be
himself,
finally
ಒಂದು
ಆಯ್ತಪ್ಪ.
submission.
ನೀವು
Five tool, try-
ಇವೆಲ್ಲ ಎಕ್ಸರ್ಸೈಸ್ ಮಾಡ್ತಿರೋದು ಯಾಕೆ ಗೊತ್ತಾ? ಸೂಟ್ ಡಿಲೇ ಆಗ್ಬೇಕಂತ. ನಾನು ಸ್ಟೇ
ಇಲ್ಲ,
ಕೊಡ್ತಿದ್ದೀನಲ್ಲ,
ನಾನು-
ಮತ್ತೆ ಯಾಕೆ ಸುಮ್ನೆ
ಸ್ಟೇ ಕೊಡ್ತೀನಿ.
ಕೇಳೋದೇ ಇಲ್ಲಲ್ಲ ನೀವು ಸುಮ್ನೆ
ಸಾರಿ
ನೀವು ಮಾಡ್ತಿರೋದೇ ಇವೆಲ್ಲ ಯಾಕೆ ಗೊತ್ತಾ? ಲಾಸ್ಟ್ ಮೂಮೆಂಟ್ ಅಲ್ಲಿ ಹಾಕೋದು ಸ್ಟೇ
ಇಲ್ಲ, ನಾನು ಮುಂಚೆನೆ ಹಾಕಿದ್ದೀನಿ.
ಆಯ್ತು, ಏನೋ ಒಂದು ಗ್ರೌಂಡ್ ಮೇಡ್ ಔಟ್ ಮಾಡಿದ್ರೆ ನಾನು ಸ್ಟೇ ಕೊಡ್ತಾ ಇದ್ದೀನಿ, ಮತ್ತೆ ಯಾಕೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತೀರಾ?
ಎವಿಡೆನ್ಸ್ ಟೈಮ್ ನಲ್ಲೇ ನಾನು
I am hearing this GM matter from last 1 month. I know that how that advocates are moving that applications, how they are getting an order and all. You want that suit to be delayed? Now I am granting in a stay. Why do you want to argue for?
ನನಗೆ ಡಿಲೇ ಬೇಕಿಲ್ಲ ಸ್ವಾಮಿ. ಐ ವಾಂಟ್ ಟು ಕಂಪ್ಲೀಟ್ ಆಸ್ ಅರ್ಲಿ ಆಸ್ ಪಾಸಿಬಲ್. ಅದನ್ನ
Yes.
ಬೇಕಿದ್ರೆ ಮಾಡಿ.
Stay of
ಆಮೇಲೆ ಇಲ್ಲಿ my lord,
number 50
May I make one submission, Lord?
49 of 2019 pending in the file of 35th,
My
36th.
Lord, may I make one submission? I will not press for this because my own suit shall not be stayed. Your Lordship may kindly have it next week, any date, my Lord, for.
That I can't give you an assurance. Therefore, because of this lot of pendencies of preliminary hearing, I don't know whether I will reach it or not.
ನಾವು ದಿ ಸ್ಟೇಜ್
And,
ಅವರೇ
because of these holidays also coming. Therefore, I am telling that, yes. When do you
ಒಂದೇ
want-
ಒಂದು ರೆಸ್ಪೆಕ್ಟಬಲ್ ಸಬ್ಮಿಷನ್. ಅವರೇ ಕೋರ್ಟ್ ಕಮಿಷನ್ ಅವರೇ ನೋ ಅಬ್ಜೆಕ್ಷನ್ ಹೇಳಿದ್ದಾರೆ ಸ್ವಾಮಿ ಫಾರ್ ಅಪಾಯಿಂಟ್ಮೆಂಟ್.
ಆಯ್ತ್ರಿ, ಅದೇ ಗ್ರೌಂಡ್ ಮೇಲೆ ಈಗ ನಾನು ಸ್ಟೇ ಕೊಡ್ತಾ ಇದ್ದೀನಿ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದೀನಲ್ಲ, ಇವಾಗ ಮೇಡ್ ಔಟ್ ಅನ್ ಕೇಸ್.
ನಾನ್ ಡಿಲೇ ಮಾಡ್ತಿಲ್ಲ, ಅವ್ರು ಡಿಲೇ ಮಾಡ್ತಿದ್ದಾರೆ ಅವ್ರ ಸೂಟ್ಗೆ.
I have already argued.
Yes.
Posted for return.
Leave this matter in B group on 22nd. Yes.
Cell number 9, Sanat Kumar Shetty K for petitioner.
Lord, arises from execution proceedings. My Lord, it was a suit for specific performance
Yes.
of a joint development agreement.
Yes.
Plaintiff is the developer.
Yes.
A decree is granted to the effect that the defendant shall perform the terms of the joint development agreement.
Yes.
In pursuance of that, an execution petition is filed. In the execution petition, my Lord, the relief that are sought for go beyond the scope of the decree.
What is that order now you are
My Lord,
challenging?
I am not challenged, I have challenged the entire proceedings, my Lord.
What is that?
So it is, the court has no jurisdiction to entertain the execution petition at all.
Why?
It is beyond the scope of the decree itself.
What is that beyond the scope of degree? What
My
they are
Lord, the agreement contemplates, my Lord, sharing of the sites that are formed in the ratio of 65% and 35%. That has to be formed only after the approval of the layout plan. That is not done. It is the allegation of the plaintiff. The sale deed will have to be executed only after the sites are formed. Sites are to be formed after the approval of the plans. Even according to the plaintiff government's approved plan is not obtained. Therefore, question of executing the sale deed does not arise at all. That is not the scope of the decree at all.
Have you filed such a objection before that by executing court?
Yes, my Lord, I have filed it. I have filed an application under section 47.
What is that order passed?
No order is passed, my Lord. I am questioning the execution procedure.
No, that let there be you can seek a stay of there also in that executing court, or you can raise that objection. How can you seek a quashing of execution here, Mr.?
That is what I have sought for, my Lord.
You can seek there, you take notice.
Yes.
Or issue notice, issue emerent notice. Yes.
In the meanwhile, stay me.
No, let us see. Yes. Can that
number-
execution be quashed here? Yes.
Cell number 10, GB Nandish Gowda for petitioner.
Appear for the respondent.
Yes.
Lord, this matter was heard for some time on the last occasion. Defendant writ petition. Suit for injunction. Interim order of temporary injunction has been granted against the defendant. The same was confirmed by the first appellate court.
Yes.
My Lord, suit scheduled property, my Lord, the landed property, my Lord, immovable property. At the first instance, my Lord, the subject matter of land in question granted. Suit for bare injunction. Interim order of temporary injunction has been granted in favor of the plaintiff.
Yes.
The same was confirmed by the first appellate court.
Yes.
My Lord, the scheduled property is the landed property, immovable property, my Lord.
Yes.
The same was granted in favor of my mother-in-law by name Kadamma. Regarding grant, my Lord, not in dispute. During her lifetime, my Lord, the grant is made for self and on behalf of the joint family, my Lord. Grant. My Lord, grant, my Lord, on 10/11/1994.
Grant under which provision?
My Lord, it is regularization of unauthorized cultivation.
Regularization,
Howdu.
Land Revenue Act.
Howdu.
Yes.
My lord, during her lifetime, my mother-in-law, my lord,
Where is that grant order? Have you produced that?
my lord, this is, my lord, I have not produced. I will narrate the facts first. I have produced, my lord, along with memo.
Yes.
My lord, my husband, my lord, the predeceased. Therefore, under circumstances, my lord, my mother-in-law executed a registered will in my favor during her lifetime.
No, it is granted in your mother-in-law's name.
Mother-in-law's name.
What is her name?
Kalamma.
Kalamma.
Howdu. Grant certificate is also produced along with memo.
Yes.
My lord, the plaintiff herein, my lord, got cancelled that registered will that was executed in my favor, my lord. And my lord, he entered on the very same day, my lord, he entered into an agreement of sale.
Who is plaintiff?
Plaintiff, my lord, he is not the member of the joint family.
No, then
outsider.
No, he is get it cancelled that will.
Cancel will ಮಾಡಿ agreement of sale ಮಾಡಿಸ್ಕೊಂಡ್ರು.
ಯಾರು ನಿಮ್ಮ mother-in-law ಹತ್ರ?
Mother-in-law ಹತ್ರ.
Yes.
My lord, the agreement of sale, my lord, on 15/1/2025. 15/1/2025. My lord, the suit filed, my lord, on 18/1/2025. Before service of summons, on the very next date, my lord, defendant appeared through counsel. Kalamma appeared through counsel, and matter is settled on the very same date. It is relevant to note that, my lord, the suit filed by the on behalf of
specific performance.
ಹೌದು. Suit service summons serve ಆಗಲಿಲ್ಲ. Within a span of 3 days, suit filed. Notice not yet ordered, summons not yet ordered. On the very first date of hearing, my lord, the defendant appeared through his counsel, and matter is got it settled. Thereafter, my lord, I filed the suit for the relief of declaration and injunction regarding, my lord, with respect to whatever the decree collusive is in nature, and the same is not, my lord, the binding. And I sought for the interim order of stay to stay of the execution of the decree specific performance. At the first instance, my lord, the stay has been granted in my favor. Thereafter, my lord, the plaintiff herein, my lord, has filed one more suit for the relief of injunction. And my lord, the temporary injunction has been granted. Based on the temporary injunction obtained, whatever the stay I obtained in the before the declaration suit, the same has cancelled. And my lord, at the first instance, after hearing on both the sides only, this honorable court, may not be pleased to grant interim order of status quo. And writ petition disposed of. The counsel appearing for the respondent has made an allegation against my client, stating that, my lord, I am trying to interfere with possession. My lord, it is, my lord, the immovable property, house is there. My lord, the standing trees are there.
Now, what is that property? It's a vacant site or?
No, coconut and arecanut plantations are there. Apart from that, my lord, the house is there. Borewell is there. My lord, since, my lord, on account of the death of my husband, I am gainfully employed in somewhere in Arakulgod, my lord. Taking undue advantage of in my absence in the, he is, my lord, my lord, prepared the agreement of sale and got obtained the collusive decree. On the last revenue record. So on the last occasion, my lord, I filed memo. It is still stands in the name of the Kalamma only.
Yes. Where is that?
26 March, my lord, Kudi. I am permitted to pass on this, my lord. The same was filed it in the counter itself.
Yes, Kudi. Yes.
Illi grant at the first, my lord, whatever I have made a submission, grant is for self and on behalf of the joint family. The grant certificate reflects, my lord, Kalamba.
Yelli the grant certificate.
Adu memo hakottidini last occasion. I am permitted to pass one more set of copies, my lord. ಅದು ಓಪನ್ ಕೋರ್ಟ್ ಅಲ್ಲೇ ಕೊಟ್ಟಿದ್ದೀನಿ.
ಗ್ರಾಂಟ್ ಸರ್ಟಿಫಿಕೇಟ್ ಇದೆ.
ಅಲ್ಲಿ ಕಾಳಂಬ ಎಂಬುವವರಿಗೂ ಅವರ ವಾರಸುದಾರರಾದವರ ಪ್ರತಿನಿಧಿಗಳಿಗೂ ಮತ್ತು ಹವಾಲ್ದಾರರಿಗೂ ಸರ್ವೆ ಖಾತೆ ನಿರ್ಬಂಧನೆ ಕಾಯಂ ಮಾಡಿರುತ್ತೇನೆ. When such being the case, my lord,
ನಿಯಮಿತ ಸರ್ಕಾರಿ ಕಿಮ್ಮತ್ತು ರಾಜಕ್ರಮ ಕಾಳಮ್ಮ
I am the one of the co-owner, my lord. Unless, my lord, absolute rights has been transferred under as provided under section 109 of the Transfer of Property Act. My lord, he will not get any rights, my lord, and injunction has been granted against the true owner. Am I permitted to pass on this, my lord, the judgment of the apex court in this regard, my lord? Really, I may permitted to.
Yes.
How they have played fraud, my lord. Suit for specific performance filed by the council, who is not got it enrolled by the State Bar Council, my lord. And the council who represent the Kadama, very same council represent in the subsequent suit also in favor of the plaintiff.
Yes.
Head note C, my lord, and one of the item of the joint family property, patta in respect was granted to the defendant for benefit of the family.
Yes.
Suit for partition by the plaintiff number 1 to 4. Concurrent findings of the court below that the plaintiff and defendant would be entitled to 1/5 share. And the findings recorded, my lord, the para 26 and 27 onwards. As described earlier, there was a division of status among the brothers. The defendant and plaintiffs 3 and 4 during the year 1995, or at the time when the defendant paid rupees 20,000 to the plaintiff number 3 and 4 for relinquishment of their interest in the item number 1 and 2 on so and so data. As noticed earlier, appellant had given the application for grant of patta with respect to item number 3 in 1989, and the same was renewed in 1991, during which time there no division of status among the defendant and the plaintiff 3 and 4. Since the grant of item number 3 in the name of the defendant is for the benefit of the family, the trial court and the high court rightly recorded the concurrent findings of the plaintiff are entitled to share in the item number 3. My lord, admittedly, I am also a member of the joint family.
No, your
Daughter-in-law.
daughter-in-law.
Daughter-in-law. She will comes within the definition of family.
Yes, Mr.
And one more judgment, my lord. Under the circumstances, my lord, the Kalama has no right to execute an agreement in favor of the third parties.
What is the suit he has filed?
Specific performance.
No, OS number?
OS, my lord, 16 of 25.
16 of 25.
That was compromised, my lord.
It is filed on 15/1/25.
It is, my lord, it is filed on agreement dated 15/1/25. Filed, my lord, on 18/1/25. On 20th to very first date of hearing itself, my lord, 20th to 25, matter is got settled in the Lok Adalat. Before service of summons order agilla suit ali, advocate appeared.
No, that same advocate who has appeared for.
In favor of the plaintiff in the present suit.
No, that in that plaintiff in OS 60. Same advocate is appearing.
No, plaintiff in OS 16, he is not an advocate. He is not got my lord, enrolled from the Karnataka State Bar Council. After filing complaint, my lord, he absconded. The council who represent Kalama, my lord, very same council has appeared in the subsequent suit.
Subsequent suit for that purchaser.
How do? OS 208 of 25.
Yes.
Declaration suit ali.
Yes. Now we'll hear that. We'll grant injunction. Yes. No, this all this. Yes, I have understood that. Yes. What is that document to show that you are in the position, Mr. RTC shows even 25, 26, it's a Kalama. If Kalama is not there, it has to go to the LRs. Yes. No, Mr. We'll consider that the way in which that suit has decreed. It shows that counsel who is not an counsel who has filed a suit, that itself shows that there is a fraud, Mr. Yes. No, you are claiming any rights on the basis of the OS 60 of 2025. That itself is obtained. That has been filed by the counsel who has not enrolled as an advocate. It is filed on case is filed on
20th one. So 18/1/25.
18/1/25. 20th
to 25 first date of hearing.
Within 15 days, without summons, she came and appeared and settled that matter. We'll see that, we'll hear.
8.5 ಲಕ್ಷ ನಾನು ಕ್ಯಾಶ್ ಅಲ್ಲಿ ಕೊಟ್ಟೆ ಅಂತ ಹೇಳ್ತಾರೆ ಕಾಳಮ್ಮಂಗೆ. When she is suffering from the serious, my lord, the cancer, apart from that, my lord, schizophrenia disease.
Yes, we'll hear. Prima facie, I have convinced that, yes. No, that, how that amount has been paid to that Kalamma? Is it permissible? Is it permissible to pay 18 lakhs rupees cash? 8 lakhs, is it permissible? It is permissible. Everything, every steps, it shows that Mr. something is been happened. No, that's we'll see. We'll see. No, if you are objecting for an status quo, then we'll grant that absolute. Where is your application, Mr. Injunction order?
My lord, ink page number, my lord, the findings, my lord, ink page number 31. Ink page number 31.
Yes, no, therefore, let him produce. Where is that complaint has been lodged and
My lord, I undertakes to furnish that complaint, my lord, before this honorable court.
Yes. How to issue notice? Yes, we'll grant status quo. Don't, yes, parties are directed to maintain status quo in respect of suit scheduled property till next date of hearing. You furnish all these things.
Yes, my lord.
Yes.
Till number 11, HN Vasudevan.
Petitioner, my lord. Defendant's petition, not seeking a direction.
Serial number?
Sir,
11. 11.
You are appearing for first response. Yes.
Short direction to dispose of the petition, my lord, dispose of the suit. The suit is for
what is the stage in the suit now?
My lord.
Evidence. What is suit for?
Partition amongst the family members.
Yes, we'll dispose of.
Please, my lord. It's a 2006 suit. That's other.
Yes. In this writ petition, petitioner sought direction to that trial court to dispose of the suit YS number 3353 of 2022 as expeditiously as possible. Petitioner with the plaintiff filed in a suit, defendant.
First defendant.
Yes, petitioner is a defendant number 1 in YS number 3353 of 2022 as the respondent number 1 herein is a plaintiff has filed in a suit for partition and separate position. On appearance of, on service of summons, defendant has appeared through counsel as filed in a written statement. On the basis of the pleadings of the parties, trial court has framed that issue and matter has been shut down for evidence. Since suit of year 2022 has not.
Right, it was 2006. Later, it was renumbered in 2022.
Suit of year 2006. Since matter was not disposed of, even after 20 years, even after 20 years, therefore, petitioner sought for early disposal of the same. So and so undertake to appear for respondent number 1, plaintiff has also submitted that. Direction may be issued to early disposal of the suit. In view of the above, without expressing any opinion on the merit of the case, the senior civil judge Hoskote is directed to dispose of YS number 3353 of 2022 as expeditiously as possible, not later than 6 months from date of register copy of this order. 8 months from, yes, 8 months.
Cell number 12, Jairaj DS for petitioner, Anusha Prasad.
It's appeared for the petitioner.
Yes.
My application under order 6 rule 17 has been straightaway dismissed on the ground that I cannot claim counterclaim after issues of.
copy ಕೊಟ್ಟಿದ್ದೀರಾ?
Kottidhi. That was the office objection, your, that is.
Yes, what is this matter?
My application under order 6 rule 17 is straightaway dismissed without taking into consideration that I have paid 2 other reliefs to be incorporated in my return statement and not even discussing insofar as that is concerned. Straight away dismisses my application that counterclaim cannot be made after issues of frame.
Yes, that is what
That is what, my lord, your lordships had heard. Therefore,
I
your
said-
lordship provided me some time. I've got another ruling
Yes.
where cross-examination was concluded. Application seeking incorporation of two other paragraphs.
Yes.
And also a counterclaim was made. Insofar as the other two paragraphs, that ought to have been considered by the Honorable Trial Court, which is not.
Yes, what is that?
Your lordships may kindly see para 7. Adrallu kuda Ashok Kumar Kalra's case is referred.
Yes.
Counterclaim is also sought. Two other paragraphs are also sought. Insofar as two other paragraphs, the Honorable Trial Court had allowed the application. High Court had dismissed the application, went up to Supreme Court. Supreme Court allows, permitting the defendants to bring in two other paragraphs.
Two other paragraphs is not a counterclaim.
That is not counterclaim, but insofar as in my case, along with counterclaim, I've also sought two other paragraphs.
Two other paragraph you can permit. Not
That's right.
counterclaim.
That is also my case. I understand.
Yes, where is that your application?
My application, your lordships may kindly see para 8, page 18, annexure A.
Page 18. Yes. What are that two paragraph? Which are the two paragraph you want?
13A, paragraph 18, A and B.
13A, what is that?
13A, the family of the plaintiffs and defendant numbers 1 to 4 belong to the community of Jangamas. Accordingly, the family following the customs and traditions prevailing in the community. The custom and traditions prevailed in the community, that is.
Where is your counterclaim? Which is the paragraph?
Your lordships may kindly see page 20.
Yes.
Wherefore, it is prayed that this honorable court be pleased to pass judgment and decree against the plaintiff by way of a counterclaim in the following manner.
Yes.
To declare that the defendant numbers 3 and 4 are entitled for the rights of Archaka in terms of deed of gift dated 18/2/2020.
Learned counsel for the petitioner submitted that. Petitioner respondent has filed.
Defendant
has filed an application under Order 6, Rule 17 for amendment of written statement. Inclusion of two paragraphs and also sought for counterclaim. Even assuming that if the counterclaim is filed after the issue is framed, is barred under that. Which is the provision?
Order
7,
8,
Rule
Rule
17,
6A.
Order 6?
Order 8, Rule 6A.
Order 8, Rule 6A. But additional two paragraphs he wants to amend. That can be allowed. Without considering this aspect of the matter, trial court has rejected entire application.
Plaintiffs idare. Plaintiffs.
Who is that counsel appearing? If they are
Plaintiffs
there-
gina notice agila.
Yes.
Only the BBMP is a party.
Yes. Submit in view of the above, the stay of further proceedings in OS number 1864 of 2020 pending in the file of 12th Additional City Civil and Section Judge Bangalore till next date of hearing. Issue emergent notice to respondent number. Respondents, yes.
Yes.
Submission is accepted, office objection is. Yes.
May I seek for hand delivery suit nidina nadita idade. I'm grateful.
Yes.
Cell number 13, Ganapati CV for petitioner, Bimbadar M. Gowder.
My lordship, petitioner is the plaintiff before the trial court.
Yes.
The petitioner has filed suit for adverse possession.
Yes.
In that suit, the application was filed under Order 13 and Rule 2, seeking temporary injunction restraining the respondents to obstruct the using of the road located in the social property. That application was rejected by the trial court and
Why?
it is confirmed by the MA court also, my lordship. My lordship, the petitioner has purchased the social property under the unregistered sale deed in the year 1988. My lordship, kindly see the Annex D, page number 34.
Tell it that road has been shown.
Yes, my lordship. Road has been shown.
Then why the trial court is rejected?
But because of my lordship, this document is wrongly considered by the
What is in
trial
existence on
court.
the suit
It is an agreement of sale. This document considered as agreement of sale. Annex D, under the Annex D, the entire sale consideration was received, possession was handed over, and give up the entire right and title to the petitioner, my lordship.
Where is that road in the sketch?
Sketch, my lordship. Sketch, there is no road in the survey sketch, my lord, page number 31 is the document. 32 is the survey sketch.
Hmm.
It is shown as the 11 guntas of, in this 11 guntas, there is a road.
Yes, where is that in that agreement it is mentioned?
Page number 31, my lordship.
Hmm. Who has executed?
The
defendant?
father of the respondent number 2 and wife of the respondent number 1, my lordship.
Hmm. Have you produced any photograph to show that there is a road?
In this case, I am producing, my lordship. Kindly see.
Page 59.
Please, my lordship.
ಎಲ್ಲಿದೆ agreement ಅಲ್ಲಿ?
Agreement.
ಯಾವ್ದು ನಿಮ್ದು ಪ್ರಾಪರ್ಟಿ ಸೇಲ್ ಮಾಡಿರೋದು ಯಾವ್ದು ರೋಡ್ ಪಕ್ಕದಲ್ಲಿ ಇದೆಯಲ್ಲ ಅದ?
No, including road, 11 guntas was sold, my lordship.
ಇದ್ರ ರೋಡ್ ಇಂದ ಆಚೆಗಿರೋದು ಯಾರ್ದು?
ಹೌದು ಸ್ವಾಮಿ.
ಮಧ್ಯದಲ್ಲಿ ರೋಡ್ ಇದೆಯಾ?
It is the 11 guntas to use by the plaintiff to reach his other properties.
ಎಲ್ಲಿ ಓದಿ?
My lordship, Annex D, page number 34, my lordship. 31, my lordship. Is may I read the entire document?
No, relevant ಓದ್ರಿ. ಕುಸ್ಕಿ ಬಾಬ್ದು ಪಂಚಾಯತಿ ತೀರ್ಮಾನವಾಗಿದ್ದು ರಸ್ತೆ ರಿಜಿಸ್ಟರ್.
ನಿಮ್ಮ ಸ್ವಾಧೀನ ಅನುಭವದಲ್ಲಿ ಈ ಹಿಂದಿನದಲ್ಲಿ ಇರುವುದು ಸ್ಪಷ್ಟವಾಗಿದೆ. ನೀವು ಮತ್ತು ಇದಕ್ಕೂ ಮೊದಲು ನಿಮ್ಮ ಹಿಂದಿನವರು ಸದರಿ ಪ್ರದೇಶವನ್ನು ಅನುಭವದಾರರಾಗಿ ಕಣ ಹಿತ್ತಲು ವಗೇರೆ ಮಾಡಿಕೊಂಡಿರುತ್ತೀರಿ. ತೆಂಗಿನ ಮರಗಳು ಸಹ ಇದ್ದು ಅನುಭವದಾರರಾಗಿರುತ್ತೀರಿ. ಆದ್ದರಿಂದ ತಕರಾರಿಗೆ ಅವಕಾಶವಾಗಬೇಕಾದ ಸದುದ್ದೇಶದಿಂದ ನಿಮ್ಮ ಅನುಭವದಲ್ಲಿರುವ ಮೇಲ್ಕಂಡ ಚಕ್ಕುಬಂದಿಯಲ್ಲಿರುವ 11 ಗುಂಟೆ ಪುಷ್ಕಿಯನ್ನು ಸಂಪೂರ್ಣ ಹಕ್ಕಿನೊಂದಿಗೆ ನಿಮಗೂ ಬಿಟ್ಟು ಕೊಟ್ಟಿರುತ್ತೇನೆ. ಈ ಬಾಬತ್ತು ಪಂಚಾಯತಿಯರ ಸಮಕ್ಷಮ ತೀರ್ಮಾನವಾಗಿ ಕೈಗೊಂಡಂತೆ 1375 ರೂಪಾಯಿಗಳನ್ನು ಈ ದಿನ ನಿಮ್ಮಿಂದ ಪಡೆದುಕೊಂಡಿರುತ್ತೇನೆ. ಇನ್ನು ಬರಬೇಕಾದ ಬಾಕಿ ಇರುವುದಿಲ್ಲ. ತುಂಡು ಭೂಮಿ ಕಾಯ್ದೆ ರೀತಿಯ ಕ್ರಯಪತ್ರ ಬರೆಸಿ ರಿಜಿಸ್ಟರ್ ಮಾಡಿಸಿಕೊಡಲು ಅವಕಾಶವಿಲ್ಲದ ಕಾರಣ ಈ ಪತ್ರ ಬರೆದು ಕೊಟ್ಟಿರುತ್ತೇನೆ. ಮತ್ತು ಸದ್ರಿ 11 ಗುಂಟೆ ಪ್ರದೇಶದಲ್ಲಿ ನನಗೆ ಈವರೆಗೆ ಇದ್ದ ಮತ್ತು ನನ್ನ ಪ್ರತಿನಿಧಿಗಳಿಗೆ ಇರಬಹುದಾದ
ರೋಡ್ ಬಗ್ಗೆ ಏನು ಇಲ್ಲಲ್ಲ ಮೆನ್ಷನ್.
There is no road mentioned, my lordship.
ಮತ್ತೆ
because it is a private road. After purchasing the property, they are using this 11 guntas. There is a private road because this is the only property to.
No, see, property which is sold to you. Is it includes that road or not?
It is includes, my lordship.
Where is that boundary? If that boundary, then there should be shows that there is a road in that.
My lordship, kindly in the sketch, it is.
ಎಲ್ಲಿದೆ?
In the survey sketch and this model, as on the date of purchase of the scheduled property, there is no road shown in the property. It is shown as
road ಬೇಡ. ನಿಮ್ ಪ್ರಾಪರ್ಟಿ ಒಳಗಡೆ ನೀವು ರೋಡ್ ಆರ ಮಾಡ್ಕೊಬಹುದು, ನೀವು ಹೈವೇ ನಾರ ಮಾಡ್ಕೊಳ್ಳಿ.
Please.
Whether that place is coming within that boundaries or not, according to the sale deed. That is the issue. ನೀವು ತಗೊಂಡ ಮೇಲೆ ರೋಡ್ ಮಾಡ್ಕೊಂಡಿರಬಹುದು.
Please, my lord.
It is not that public road, it is there.
No, it is a private road.
Private road. First, ನೀವು ಪರ್ಚೇಸ್ ಮಾಡಿದಿರಲ್ಲ 11 ಗುಂಟದಲ್ಲಿ ಅದು ಬರುತ್ತೆ ಅನ್ನೋದು ನೀವು ಎಸ್ಟಾಬ್ಲಿಷ್ ಮಾಡ್ಬೇಕು. Then ಅದ್ರ ಒಳಗಡೆ ನೀವು ರೋಡ್ ಆರ ಮಾಡ್ಕೊಳ್ಳಿ, ಮನೆನಾರ ಕಟ್ಕೊಳ್ಳಿ. Now is that property is not coming within your boundaries. That is what they are.
I am producing that photograph. It is clearly shows there is a road.
No, road ಇದೆ.
Please.
ರೋಡ್ ನಿಮ್ದು 11 ಗುಂಟೆಯಲ್ಲಿ ಇದೆಯೋ ಅಥವಾ ಹೊರಗಿದೆಯಾ ಅನ್ನೋದು ಪ್ರಶ್ನೆ.
That is
that you have to be established. Otherwise, trial court how they will grant, Mr.
Because this is the only property is available to the plaintiff to reach his other properties. For that purpose only it was purchased, your honor, my lordship. Kindly say that this document is wrongly considered by both the courts. It is an agreement of sale, madam.
In the agreement ತಗೊಳ್ಳಿ.
Please, madam.
You have to show that ಈ ರೋಡ್ 11 ಗುಂಟೆ ಒಳಗಡೆ ಬರುತ್ತೆ ಅಂತ. If it is beyond 11 guntas, you have no right.
No right, my lordship. But
ನೀವು 11 ಗುಂಟೆ ಒಳಗಡೆ ನೀವ್ ಏನ್ ಬೇಕಾರ ಮಾಡ್ಕೋಬೇಕಂದ್ರೆ it is your property.
Please, madam.
Unless you show that it is within that 11 guntas, you can't.
But
absolutely there is no schedule. Absolutely there is no schedule. The document is not found as either a sale deed or what has a sale agreement. And what the petitioner claims that he has obtained possession of this document is stamp of this sale. And the original of this document notes are not definitely seen the light of the day, even before the trial court wrote this document is not produced.
Not only road, you are in difficulty to establish 11 guntas.
But my lordship,
my lordship, the property what they are claiming to now purchase from Mr. Virupata is not the property of his wife. It is not his property. And the property of our Indian property and how is the deal with it?
Yes, Mr.
My lordship. I should kindly see.
It is the prayer of the plaintiff before the trial court wrote that to declare himself as the owner of the property by a act of possession. So, admittedly on the date of this decision response. And thereafterwards, he claims for an injunction words in favor of the sponsor, concerning the two owners of the
Absolutely not substitute of order is not maintainable.
Yes. Yes, Mr.
My Lordship, in the annexary page number 33.
What is the finding given by the trial?
Finding given by the trial court is consider this document as the agreement of sale. Agreement of sale does not. Agreement of sale does not confer any right to the parties.
Yes.
Therefore, unable to grant an interim order. Page para number.
See, you are seeking by way of adverse position ಕೇಳೋದಾದ್ರೆ agreement of sale ಹೆಂಗ್ರಿ ಹೇಳಕ್ಕಾಗತ್ತೆ? Your prior itself is inconsistent. ನೀವು either here not there.
Lordship, para number 20 and
stick on to that particular prior for an adverse position. You should not claim that on the basis of that agreement and all. Then you can't claim.
Para number 2021 is the finding given by the trial
No, you
court.
forget about road. I think you will difficult to succeed in the suit itself.
Even though there is no, it can be considered to the entire 11 guntas, because there is no, I am unable to produce any document to show that there is a road. It can be show that by way of appointing surveyor or commissioner, then only,
Yes.
because there is no documents, my Lordship.
In this writ petition.
My Lordship, I make only one submission. Unless this 11 guntas, there is no other way to the plaintiffs to reach his other properties, my Lord. There is the only other, this is the way.
No, you take order from here. There is already an adverse effect from that two courts. One more adverse effect will become to that for in your suit itself, because when you are claiming for an adverse position, you cannot rely, when you are relying on the documents, you have purchased it, you can't seek for an adverse position. Then your title itself is under dispute, then you can't seek for any injunction. Simple method. What you want? You want order?
Please, please.
Thirdly, in this writ petition, petitioner called in question.
My Lordship, I am requesting, kindly have 6th, I will take instruction, otherwise I.
Yes, at the request. 21. 15.
Please.
Yes.
Cell number 40.
I thought let them take an instruction for their interest.
Cell number 14, Virendra Kumar HY.
I am appearing on behalf of the petitioner in this case, my lords. Lords, petitioners were the plaintiffs, my lords, before the trial court. The suit is for partition.
Yes.
That came to be decreed, my lords. Subsequently, my lords, the respondent, contesting respondents who are respondent number 1 to 6, my lords, have preferred, my lords, regular appeal before the first appellate court. Suit for partition, my lords.
Yes, appeal, what has happened?
My lords, appeal is still pending, my lords. It's for steps, my lords, with regard to other respondents, my lords. When such is the case, my lords, they have, my lords, they have pressed, my lords, application, my lords, filed under order 41 rule 5, my lords.
For what?
For, my lords, stay the, my lords, the operation of the judgment passed in OS, my lords. My lords, while passing, my lords, the entire, because, my lords, the petitioners have filed, my lords, the FDP proceedings, and the commissioner warrant has been issued. At that time, my lords, they have pressed this application. Lords, the court, my lords, the first appellate court, my lords, passed, my lords, order, my lords, at page number 105, my lords. The entire operation of the judgment has been stayed, my lord, till disposal of RA, my lords. My grievance is that, my lords, instead of, my lords, the entire operation of the judgment, the drawing up of final decree may be stayed, my lords. That is my only grievance.
Yes, heard. Issue notice. Stay of order dated.
19/12/2025.
19/12/2025, passed by 7th Additional District and Session Judge Tumkur in area number 57 of 2023, and it's made clear that and also directed and also states drawing of final degree proceedings in FTP number. ಎಲ್ಲಿದೆ FTP number?
ಅಯ್ಯದಲ್ಲಿ ಮೆನ್ಷನ್ ಮಾಡಿ.
ಹೇಳಿ FTP.
1 second. FDP 4/2024, my lords.
4/2020-24 pending in the file of
Second Additional Senior Civil Judge Tumkur, my lords.
Senior Civil Judge JMFC Tumkur till next date of it.
Right.
Cell number 15.
Notice in respect of respondent number 6 to 25 may be dispensed with.
Yes, memo kodi. Other respondents is emergent notice. Yes.
Great.
Number 15, Giridhar H for petitioner, Tilak Ittangu.
I appear for the petitioner, my lord.
Yes.
The petitioner is before your lordship against the order passed in respect of IA filed under order 16 rule, sub rule 2 of rule 1.
Suit for?
Suit for specific performance.
You are the plaintiff.
I am the plaintiff.
Application filed under?
Order 16 rule, sub rule 2 of rule 1.
For what?
For summoning the document as well as summon the witness to give evidence of relevant fact, not in fact in the issue.
What is that order passed by the trial court?
Trial court has considered the application and has passed an order stating that the endeavor made by the plaintiff is to bring the evidence on record without pleading.
Now, where is that order?
My lord, order is as per exhibit common order, my lord.
Page 8.
Page 160. Page number 158, my lord. Plaintiff has filed. Shall I? The plaintiff.
Para 7 or the para 7?
Pick up. Reasoning, reasons. I have gone through the record of the case and the same discloses that the present suit is filed by the plaintiff for specific performance of contract. According to the plaintiff, the defendants have executed a sale agreement in his favor on 30/10/2014, thereby agreeing to sell the suit property to him for rupees 7,12,500 by receiving earnest money of rupees 4,12,500 and by undertaking to execute a registered sale deed within 2 years after receiving balance amount of rupees 3 lakh. The defendant have filed their written statement to the plaintiff, thereby denying the claim of the plaintiff. The plaintiff and defendant have led their evidence in their case, in this case, and now the case is posted for further evidence of defendant. At this stage, the plaintiff has filed this application for summoning document and witness from Bank of Maharashtra, Banaswadi branch, Bengaluru. In the present application, the plaintiff has claimed that he has paid a part sum of paid part of sale consideration of rupees 4,12,500 to the defendant and agreed to pay balance sale consideration of rupees 3 lakh under the sale agreement. He has further claimed that the subsequent to the execution of the sale agreement, he has made payment to the defendant number 1 from his savings bank account bearing so and so through 2 checks bearing so and so for rupees 2,40,000 and rupees 2,50,000, both dated 2011-2014, drawn on Bank of Maharashtra, Banaswadi branch, Bangalore. That the said check were issued by him towards part of total sale consideration to the in accordance with the terms of agreement of the said of the sale, and same were duly encashed by the defendant. But during the course of cross-examination, defendant number DW1 has denied of having received the said payment from him. He has also claimed that in view of the said denial, in order to substantiate the payment, it is necessary to summon the documents and witness as sought in the application. However, on the other hand, defendant have claimed that there is no pleading in the plaint by the plaintiff regarding payment of rupees 4,90,000 through the check to them. Therefore, without pleading, evidence cannot be permitted. Hence, it is not necessary to summon the documents and witnesses. Admittedly, where perusal of the plaint filed by the plaintiff revealed that he has merely stated that the total sale consideration agreed between him and the
There is no pleading.
Yes, my lord. There is no pleading with effect to the payment made through the encashment made by the defendant through the check. We are relying upon the balance sale consideration of 3 lakh to be paid for completion of the sale transaction. But the defendant has taken a specific contention.
I will hear. You take notice.
No, may just point out one thing. Now, please see, Lord, in the legal notice at page 101, Lord.
No, I will stay that suit. Will hear that matter. Heard. issue notice, stay of further proceedings in OS number 53 of 2020.
Lord, already evidence is over, my lord. Defendant evidence is
How
over.
the suit, he wants to get it stayed, what to do? Yes. Additional senior civil judge, JMFC, KGF, till next date of hearing. What letter is undertaken to appear? You are appearing for all respondents or only one?
All respond.
Two respondents.
A letter is undertaken.
His own case is that 3 lakhs is balance.
Yes.
Now he says we paid 490 by check, my lord.
Yes.
I don't understand what.
Cell number 16, Sunil Kumar BN.
Yes. Yes.
Good for passive performance. The plaintiff has filed application now under section 151 of CPC to impound the document, madam. That is
Good for
specific performance.
specific performance.
Application under section 151 to impound the document. Instead of filing under section 37 of the Stamp Act, he has filed.
ಆಯ್ತು ಯಾವ್ದ್ರಲ್ಲಾರ ಹಾಕ್ಬೋದು ಅದಕ್ಕೇನಂತ
I
ಏನಾಯ್ತು application?
have filed application.
You have filed an application.
No, plaintiff has filed application. I have filed objection.
Which documents they wants to import?
The agreement dated, sale agreement dated 7/6/1983, madam.
ನೀವು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ರಾ?
No, they have produced, madam. Agreement dated 7/6/1983.
ಆಯ್ತು ಎಲ್ಲಿದೆ ಆರ್ಡರ್ ಎಲ್ಲಿದೆ ತೋರಿಸಿ.
Order at page number 18, my lord. 18.
Plaintiff has filed an application seek an impound of exhibiting under register yet so and so duty penalty thereof. The court suit document is sale agreement is marked without collecting the requisite stamp duty penalty. Do not exhibit agreement as. Oh, yes, it is the duty of the court to impound. That is not registered.
I have filed application, my lordship, objection, saying that instead of sending the document to the DR, my lordship, court can impound the document.
Supreme Court said not court, it has to go to the DR only. That
That's
is the
matter
law.
of 2008, my lordship. Matter is that.
At that same time, it is settled law that wrong quoting the provisions of the law, it's not so and so penalty. CPC is here for order, consequently, sale agreement is here, impound, refer to that concerned DR for calculation. Court cannot calculate, mister. Only correct that after calculation by the DR. That is latest Supreme Court judgment.
Matter belongs to 2008, my lordship.
ಆಯ್ತು,
At this later stage, my lord, they have filed application.
Will direct the trial court to get that report early and dispose of
that.
Yes. Ado Supreme Court judgment. In this writ petition, petitioner called in question order dated 6/1/2025 passed by second additional civil judge JMFC Anekal in OS number 43 of 2008. Thereby, application filed by plaintiff under section 151 of CPC for impounding that exhibit P1 has been allowed and document has been impounded. I impounded the documents and submitted copy to the district register for the purpose of calculation of deficit, stamp duty and penalty. Petitioner is defendant number 12. The respondent number 1 is the plaintiff has filed in a suit for specific performance of the contract. And he has also filed an unregistered sale agreement dated 7/3/1983. Since same is not registered and stamp duty has not been paid, by impugn order, the trial court has impounded the documents and send it to the DR for purpose of calculation and deficit stamp duty and penalty. Only ground urged by the counsel for the petitioner that instead of sending the documents to DR, the court itself can calculate the stamp duty and penalty. Since suit of year 2008,
2008, Maharaj.
2008, it will delay if you are collecting that report from the DR. The Apex Code in 2024 SC 5327 has held that the trial court has to call for a report from the district registrar for calculation of stamp duty and the penalty. The trial court cannot impose the penalty. In view of the above, the trial court is justifying in sending the documents to the district registrar for the purpose of calculation of deficit stamp duty and penalty. There is no error in the judgment, there is no error in the order passed by the trial court. Accordingly, what is the stage in that suit?
Cross appeal.
Writ petition is dismissed since suit of year 2008. The trial court is directed to send a reminder to that district registrar and get a report as expeditiously as possible.
Date be fixed for getting report, Maharaj.
Report court order admal they will fund a report. Yes.
Cell number 17, P. Nataraju.
Yes.
But in this case, on the last occasion, your lordship directed the other side to serve a copy of the petition. I've received a copy, my lord. May be permitted to file my wakalat, my lord, for the
Yes.
only respondent.
Yes.
Plaintiff suit.
Plaintiff suit. Suit for
Suit for partition and separate petition.
partition. Yes.
After filing up the suit, no original dependent died. Lord, the petitioner is the only LR of the deceased dependents. Thereafter, my lord, the proposed respondent has filed an application to come on record on the ground that, my lord, the deceased dependent number 2 has executed a will in his favor. Lord, that application has been allowed.
No inquiry has been conducted.
No inquiry has been conducted. Relief, my lord, the
22(5)
entire pleadings will be changed.
And 22(5) inquiry is required. That's what Supreme Court said.
He has just come on record. He was not a party earlier. The original defendants were defendants 1 and 2. After the death of the second defendant.
On your application,
yes,
inquiry has to be conducted. Then you have to be, that is what 22(5) says. That Apex Court is also said.
That is only an application for impleading, my lord, that's all. He has come on.
Impleading as a assignee or LR, if there is any dispute.
He is a legatee under the will. And the will has been executed by none other than the sister's son, by the sister.
Table in my table it is there. Morning I brought it. Yes, yes. It said it has to be. Now what is that order which has been passed?
But the application has been not on the ground that matters.
Defendant is proposed defendant.
Page
Case ordered to be
36, my
included as
lord.
defendant number. No, he has been ordered to defendant number 3.
Yes, ma'am.
Yes.
It's not come on record as an LR.
Illa, not as an
LR. He is impleaded, that's all.
That is all. Only impleading application is allowed.
Not as an LR.
Not as, but definition, my lord, 36, my lord, page 36.
Means a person who is in the
defined.
no, who is, where is the plaintiff?
My lord, plaint, my lord, is at increase.
Who is dead?
Dependent number 1 and 2. My lord.
Both are dead.
Both are dead.
Then suit is abet.
My lord, yes, my lord.
No, you are the plaintiff.
Yes, my lord.
Whom you have brought on record as an LR.
But there is no LRs to the dependent number 1 and 2.
Then what is the suit for?
Suit for partition and subordination.
If there is no person, what will be happen? Then suit will become a abet. If they are not come on record, it will be abated. There is no respondent.
Correct.
Against whom you are filing in a partition now?
Lord, since there are no LRs, my lord,
ಅಲ್ಲಿಗೆ ಹೋಯ್ತು ಅಲ್ಲಿಗೆ ನೀವೇ ಪೂರ್ತಿ ನೀವೇ ಯಾರು LRs ಇಲ್ಲ ನೀವು ಒಬ್ಬರೇ LRs ನಿಮಗೆ ಪ್ರಾಪರ್ಟಿ ಬರ್ಬೇಕಂತಂದ್ರೆ ಪಾರ್ಟಿಷನ್ ಏನ್ ಬರ್ತಲ್ಲಿ
ಇಲ್ಲ ಬಟ್ ಏನಾಗಿದೆ ಅಂದ್ರೆ ಐಟಮ್ ನಂಬರ್ 3 is the absolute prop.
ನೀವು ವಿಲ್ ಮೇಲೆ ಇದ್ರೆ ನೀವು ಇನ್ನೊಂದು ಸೂಟ್ ಹಾಕಬಹುದು.
ಹೌದು, separate suit ಹಾಕಬಹುದು.
But this suit will not survive now. If you say he cannot come on record, then it will not survive. ಯಾರ ಮುಂದೆ ಸೂಟ್ ನಡೆಸ್ತೀರಾ?
ಯಾರ ಮುಂದೆನೂ ಇರೋದಿಲ್ಲ.
ಮತ್ತೆ ಹೋಯ್ತಲ್ಲ ಸೂಟ್. See, if the defendant is dead, if no LRs is brought on record, it will abate.
And the impleading application is based on the execution of a registered will by the deceased second defendant. Second defendant has executed a will.
Will ಇದೆಯಾ ಇಲ್ಲ ಡಿಸೈಡ್ ಮಾಡ್ಕೊಂಡು ಹೆಂಗ ರೈಟ್ಲಿ ರಾಂಗ್ಲಿ ಅಲೋ ಮಾಡಿದ್ದಾರೆ. ಇವರು ಫೈಂಡ್ ಇಟ್ ಔಟ್ ಅಂಡ್ ಗೆಟ್ ಇಟ್ ದಟ್.
Let there be an inquiry, my lord, on the application.
No. Enquiry ಪ್ರಶ್ನೆ ಅವ್ರದ್ದು ಹೋಯ್ತು ಅಂತಂದ್ರೆ ಸೂಟ್ ಎಲ್ಲಿ ಬರುತ್ತೆ ನಾವು? Well, how that? Now that forget about is that. Please. Now they have dead. Now they have to bring an LRs. Who are that LRs? If there is no LRs, then suit abate. Then his application will not be survive for consideration. He can be impleaded in that pending suit. Suit is not there now. How can he impleaded now? Verify that, Mr.
Please, next week.
At the request of petitioner, read this matter. Yes.
I may be permitted to file wakalat in the registry, my lord.
Yes.
I'll file the wakalat in the registry.
Counter. We have not issued notice at all.
Very well.
Date maybe.
Yes. On 23rd. Yes.
March.
Cell number 18, Jyoti SK.
For the petition.
Yes.
Lord, an application was filed, my lord, a memo was filed, my lord, to substitute the LRs of the second respondent before the court. But during the pendency of the FDP proceedings,
yes,
she executes a gift deed, my lord. Your lordships kindly appreciate page number, my lord, 21. She is my sister. FDP proceedings was initiated pursuant to a decree.
No, who is dead?
The second respondent is dead. In her place, Srivatsava is the second respondent. She executes, my lord, during the pendency of the suit, a gift deed in favor of the petitioner.
In favor of petitioner. Petitioner is a respondent number?
No, petitioner was the original petition, the FDP also.
FDP, you are a petitioner.
I was the petitioner.
Nimige kotru.
Nani kotru. I filed a memo under section 2D of the CPC, my lord, saying by virtue of the gift deed executed, I represent the estate of the deceased, and accepting my memo, my lord, an order was passed by the trial court. Third respondent, who is my brother, after about 2.5 years, my lord, makes an application before the trial court saying, recalling the original order on passed on memo. That order is challenged before the lordships now.
What is that order passed by the trial court?
The lordships kindly appreciate the page.
Your brother was a party in that
FDP proceedings. He was a party.
That time he has not objected that.
He was not objected. He says COVID. Could your lordships kindly appreciate page number 15, my lord? Paragraph number 10 is the only reason assigned.
Yes, read.
He says, whether the gift deed is executed by the second respondent in favor of the petitioner is binding on the legal heirs of the deceased respondent number 2 can be decided only the legal heirs of the second respondent is brought on record. Undisputedly, second respondent is having a share in the property. Whether she has validly gifted her share in favor of the petitioner can be decided only after bringing the legal heirs of the deceased respondent on record. The order dated 19/2/2022 is not a speaking order. Under the circumstances, the court is of the considered opinion that said order needs to be recalled. Hence, passed the affirmative. At a relevant point in time, the third respondent did not even question the validity of the memo filed by me.
No, that substitution can be done it on the memo.
Since there was no, since the legal representative can be come on record only when there is.
No, there have to be application. There cannot be a memo.
Well, if
either legal representative or through will or gift deed, you have to file an application and says that how you have been come on record. It should be under order 22 only. It cannot be on memo.
22 rule 3, my lord, kindly appreciate my memo, my lord. Even I have placed a memo also before the lordships. Page number 20 may kindly be seen. I've given the details of even the gift deed, all details were available.
No, that is true. Is it permissible? Memo cannot be, Mr.
If the parties are already on record, by virtue of the memo, my lord, my understanding in the 22 rules.
No, you are already on, you have to be treated as an LR.
I was already declared as an LR.
You are not seeking to implead
myself. I was already on record as a petitioner. By virtue of the gift deed executed, my lord, I had already become a legal representative of so and so.
No, which is that
section
provision 22? 22?
2D.
2D.
2D of CPC.
2D. Section 2D.
Section 2D.
Section 2D, 22, 2D.
I'm sorry, I stand corrected. I'm sorry. 211, section 211.
Yes.
I may be permitted to read. This is what it says. Legal representative means a person who in law represents the estate of the deceased person and includes any person who intermeddles with the estate of the deceased, and where a party sues or sued in the representative character, the person on whom the estate devolves on the death of the party, so suing or sued. So, my lord, admittedly, there is a registered gift deed in my favor.
No, but order 22, you see.
But even under order 22, if the parties are already on record, I may not have to make an application on 22 rule 3.
Where is that?
Specific wordings is not available in 22 rule 3.
Then no, we are also allowing. I want to know that what is that law on that point.
The lordships forbid me. Only one judgment of the Supreme Court where it says if the how can somebody be brought on record is all the issue involved in last case.
One of the two or defendant dies, the right to sue does not survive against the procedure for case of death or service. No, even then memo is filed.
Please.
Other side is not, no objection, it can be.
He did not even appear.
No, but he has given some reason that it is a COVID. What is the date when that order?
2021, my lord. Even I have produced the
date of order. Date of order.
No, the order is passed on 19/7/2022.
19/7?
2022.
It was a COVID period.
No, it was beyond COVID.
I don't think.
22.
Period.
2021 was a COVID.
No, that Supreme Court has passed an order. There is
I'm not sure on the notification.
Period has been
extended by the Supreme Court.
Yes.
Order. This order is passing 24. My memo is allowed on 22, my lord, but this order is passed on 26 January.
Which one?
The impugned order.
No. When it has been allowed,
please.
If he has not objected, but if it is in a COVID period, there is no option for him to object. Then it requires for reconsideration.
Please.
Otherwise, if he has not objected, then.
The lordships kindly appreciate page number 30, my lord.
No, idral order declare mail. The order dated 21 of this court, order issue notice to respond. Thereafter, death of the respondent reported 21 this court directed petitioner legal.
Paragraph number 9 extract ಮಾಡ್ತಾರೆ.
So and so. Legal as she was validity brought on records.
Your lordships kindly appreciate page number 15, paragraph number 9, my lord.
ಅದರಲ್ಲಿ ಕೋವಿಡ್ ಪೀರಿಯಡ್ ಏನು ಹೇಳಲ್ಲ.
ಏನು ಬರ್ತಿಲ್ಲ ಅದರಲ್ಲಿ. Except in the affidavit, nothing is available.
It is having properly whether she was in valid order in favor of the plaintiff has decided. Adillenri, the COVID period, somebody has given a date.
Limitation to mind.
What are the periods of the COVID Supreme Court?
To my understanding, Lord, the COVID is extended up to February or March 22, not beyond 22. My order is subsequent to
March 22.
also, to my understanding, because that was observed in the one of the
Particular date
arbitration
somebody
case
has
also by
given.
the Honorable Supreme Court. My order is passed subsequently, my lord, is in July 22.
Yes. Third, issue notice stay of further proceedings in FTP number 72 of 2016 pending in the file of first additional city civil and session judge Bangalore till next date of hearing.
May I pursue your lordship, so kindly stay the order, my lord. Unfortunately, I have asked for the stay of the proceeding. Order may kindly be stayed.
If order is stayed,
Let them not take the final draw, let them not draw the final decree.
yes,
Subject to the drawing of the final decree, my lord, the order may kindly be stayed.
stay of the order, Albada. Stay of order dated 21/1/2026 passed in FTP number 72 of 2016 pending in the file of first additional city civil and session judge Bangalore. And also the executive FTP court is directed not to draw final degree till next date of hearing.
Please, my lord, the notice to respondent number 3 and 4 may kindly be dismissed. They are my sisters. They are the legal representative of the original
Give that
petition.
memo.
Please, please.
Yes, others notice, yes.
Granted, your lordship.
Serial number 19, B.S. Prasad for petitioner, P.N. Harish.
Yes,
Mr. Filed a suit for bare injunction. And the matter posted for further evidence of a PW1. He filed an application for appointment of commissioner.
You are the plaintiff or a defendant?
I am for the defendant.
You are the defendant. Suit for?
Bare injunction.
Yes.
And the matter posted for PW1 further evidence. This is not at complete chief examination. On that point of time, my lord, he filed an application to ascertain the boundary. Suit for bare injunction. On that point of time, my lord, suit itself is not maintainable. He himself don't know the boundary of the suit scheduled property. And he filed an application, my lord, kindly see the page number 52, my lord. Page number 52. It's a prayer for permanent injunction. And it's IA, my lord, kindly see page number 92. The purpose of surveying the suit scheduled property to ascertain the boundary of the suit scheduled property and order to submit a commission report on the base memo of instruction so and so.
What is the order of the trial court?
Trial court may not consider allowed the application.
What are the reason? Where is that reason?
Page number 16, annexure A. And the cited on decision, my lord, that the citation is concerned, my lord, is a suit for mandatory injunction. That facts itself is entirely different.
Which one? No, some guidelines has been issued.
On the Shadak Sharappa versus Vijay Lakshmi case, my lord. That guidelines is entirely different.
No. Guidelines is not for only that this thing.
It's a
General
fact.
Guidelines has been issued, Mr.
It's a fact is entirely different in this case.
No. Facts of the case is different.
Yes, my lord.
Other than that, court has issued a guidelines in all aspects in respect of
yes, my lord.
Appointment of the court commissioner.
Yes, my lord. Appointment of the court commissioner, my lord. The court commissioner, my lord, in this case.
No,
and
that in the
earlier we
judgment
filed
it
a suit.
says, even then, if it is helpful for the court to decide, you can find out any boundary. If he has not,
it's if it is
boundary has to be find out on the basis of the documents he has claiming. And also, when you are finding out that commissioner, if any encroachment is there, he will report it.
On that aspect, my lord. I purchased the property.
What you are arguing is right. Earlier it was the case saying that if he don't know specific boundary or he has to prove that boundary and all. But in view of this judgment now that everything is what
I will come to that aspect, my lord. Can you see? Earlier, my lord, my vendor filed a suit as against the defendant. And a scheduled property is concerned, my lord, the decreed in our favor, my vendor favor. And he is claiming a Bagurkum cultivator. I purchased the property through registered sale deed. After that, my lord, Hadbust is also conducted. And thereafter, my lord, is a conversion of the site.
Avaru injunction suit hakidare. Nandu a property, ನೀವು ಎನ್ಕ್ರೋಚ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ ಅಂತ. ಮೊದ್ಲೆಲ್ಲ ಏನು ಅಂತಂದ್ರೆ ಅವರೇ ಪ್ರೂವ್ ಮಾಡ್ಬೇಕು ಎವಿಡೆನ್ಸ್ ಮಾಡಿಯಲ್ಲ ಅಂತ. ಈಗ ಏನ್ ಹೇಳ್ತಾರೆ ಆ ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ಅಂತಂದ್ರೆ ಕಮಿಷನರ್ ಹೋಗ್ಲಿ ಬಿಡಿ ನೋಡ್ಲಿ ಅಳತೆ ಮಾಡ್ಲಿ ನಿಮ್ಮಿಬ್ರು ಎದುರುಗಡೆ, ನೀವು ಅವ್ರದ್ದು ಜಾಗನ ಎನ್ಕ್ರೋಚ್ ಮಾಡಿದಿರಾ ಇಲ್ಲೋ, ಫಸ್ಟ್ ಕಮಿಷನರ್ ಅವ್ರ ಜಾಗ ಯಾವ್ದು ಅಂತ ನೋಡ್ತಾರೆ. ಆನ್ ದ ಬೇಸಿಸ್ ಆಫ್ ದ ಡಾಕ್ಯುಮೆಂಟ್ ಹಿ ಹ್ಯಾಸ್ ಪ್ರೊಡ್ಯೂಸ್ಡ್, ಅವ್ರ ಜಾಗ ಮಾರ್ಕ್ ಮಾಡ್ಕೊಂಡು ಸಿ ಯು ಆರ್ ನಾಟ್ ಡಿನೈಯಿಂಗ್ ಇಸ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್
For that aspect,
ಮಾಡ್ತಾರೆ ಎವಿಡೆನ್ಸ್ ಮಾಡೋದು ಇವೆಲ್ಲ ತಪ್ಪುತ್ತೆ ಅಂತ ಕೋರ್ಟ್ ನವರು ಹೇಳ್ತಾರೆ.
For that aspect, my lord, HUDBUS survey is already conducted. Conversion order is there. On that point of time, my lord, question of measuring my property and the ascertain a boundary doesn't arise.
He is claiming the title on the basis of what?
Bagarukum. That survey number, my lord, is more than 236 acres.
No, he has got that property by grant.
No, it's not at granted. It's only his pinpricker, my lord, because it's wherever the property is alienated and all.
Is your
Lord, kindly see, my lord, there is earlier suit between the vendors of the plaintiff to whom he is claiming against me, and in thus there is a categorical finding saying that by using all sorts of methods they have obtained the body durust. Kindly see, my lord. So there is a serious boundary dispute. Kindly this.
See, if serious boundary dispute, then it can be asked for the ADLR to conduct a survey.
Yes, that is the reason application is filed.
If you are find out that this is your survey number and boundary,
yes,
if somebody is encroached, that can be done it by the commissioner,
please,
not by
that is what, my lord. Kindly see the OS statement, Annexure D.
Which is that title deed of your property.
Lord, I have made an application, several applications for grant of land that is pending consideration.
Land
So
is
far
not
as is not granted. So far as the OD and HUDBUS that has been made, that has been questioned by me before the deputy commissioner.
Land grant ಮಾಡಿಲ್ಲ.
ಹೌದು.
ನಿಮ್ದು
But I am in possession of 2 acres of land.
ನಿಮ್ದು ಸ್ಕೆಚ್ ಇಲ್ಲ. ಹೆಂಗ್ ಹೋಗಿ ಸರ್ವೆ ಮಾಡ್ತಾರೆ ಅವರು?
There is a sketch. There is a sketch. There is a sketch.
Where is that sketch?
Because it is produced in the year 1991 itself, along with the map. There is a sketch, my lord.
ಕಮಿಷನರ್ ನಿಮ್ ಲ್ಯಾಂಡ್ ಇದು ಅಂತ ತೋರಿಸಿದ್ರೆ ಅವ್ರು ನೀವು ಯಾವ ಲ್ಯಾಂಡ್ ಬೇಕಾದ್ರೆ ಹೋಗಿ ತೋರಿಸಬಹುದು ಕಮಿಷನರ್.
It is in my possession, the land is to be measured. It is whatever is in my possession that is to be.
No.
Lord, what has happened?
Properties which is in your possession, you can't seek injunction, Mr.
Lord, only one submission I would like to make.
Hear that. Yes.
Lord, only one submission, my lord. Before, kindly see this Annexure D, my lord. That is the judgment that has been produced admittedly. That is produced by the petitioner themselves.
See,
in
no
that
title deed, you don't know the position, you filed a suit for injunction. Now the commissioner has to go and survey where.
That is, I will explain better. Only 1 minute, you kindly spare with me 1 minute.
Yes.
Kindly see this Annexure D.
Yes.
This is a suit filed by the vendors of the present petitioner.
Yes.
That suit is for declaration and for possession. And in that, my lord, kindly turn to recasted issues at page number 55.
Yes.
That is filed against me only.
Yes.
And in that recasted issues, my lord, recasted issue number 5. Whether the defendant proves that the plaintiffs are obtained the sketch in respect of the land bearing number 7/152 by furnishing false boundary to the ADLR as claimed in para 8 of the return statement.
You forget about them.
That kindly see the answer to this. Kindly see the answer.
No, that's, see, you are before
the court said affirmative. So there is a dispute with regard to the exact location of the property.
Dispute ಇದ್ದಾಗ
yes,
boundaryನೇ ಕರೆಕ್ಟ್ ಇದೆಯಾ ಇಲ್ಲೋ ಅಂತ ಅವರು ಫ್ರಾಡ್ ತಗೊಂಡಿದ್ರೆ ಅವ್ನು ಈ ಕಮಿಷನರ್ ಹೋಗಿ ಏನನ್ನ ಸರ್ವೆ ಮಾಡ್ತಾರೆ?
They have to, because he claims under
ಅದನ್ನೇ ನೀವು ತೋರಿಸಿದ ಲ್ಯಾಂಡ್ನೇ ಸರ್ವೆ ಮಾಡ್ಕೊ ಬರ್ಬೇಕು.
He claims under a grant. He claims under a grant, Millard.
Yes,
he claims under grant.
Yes. Heard. Issue notice. Further proceedings in OS number 397 of 2022.
So appointment of commission application may be stayed, my lord.
Ordered civil judge JMFC Shimoga till next date of hearing. Let us see.
Instead of that order.
No. Tomorrow that if you are unsuccessful,
let them lead evidence, my lord. On that point of time, let them lead evidence.
Our suit, ಅವರೇ urgent ಇಲ್ಲ ನಿಮಗೆ ಯಾಕೆ ಅಷ್ಟು?
ಅಲ್ಲ. Yes. Since from beginning, my lord, that they are the litigation because they are pinprickers. They don't have any title. That's why.
We'll see that whether commissioner.
Order ಮಾತ್ರ stay ಮಾಡಿದ್ರೆ.
Yes.
Serial number 20, Viresh K.
Yes, Mr.
Lords, the respondent number 2 and 3, my lords, has filed a partition suit, my lords, against the petitioner and her father, my lords. The respondent number 2 and 3 are the sister and mother of the petitioner, my lords.
Yes.
My lords, for partition, my lords, and the suit came to be partly decreed, and my lords, court held that, my lords, the respondent number 3 and the petitioner and one more, my lords, father are entitled to get to 1/3 share each, my lords.
ಆಮೇಲೆ ಏನಾಯ್ತು?
Accordingly, my lords, subsequently, my lords, the father of the petitioner, my lords, has executed a registered will, my lords, in favor of the petitioner, my lords, bequeathing his rights over the property, my lords, in favor of the petitioner. Lords, subsequently, my lords, we have filed final decree proceedings, my lords, at final decree proceedings, my lords, claiming 2/3 share in the entire scheduled property. My lords, in meantime, my lords, one of the property, my lords, has been acquired by the NHA, my lords, for Bangalore-Mysuru Expressway, my lords. My lords, for that, my lords, the compensation amount has been deposited before the Sessions Court, my lords, and filed, my lords, petition, my lords, at page number 50, my lords, Annexure C, my lords. My lords, in meantime, my lords, they have filed, my lords, the contesting respondents, my lords, who are sister and mother, has filed, my lords, application, my lords, under section 151, seeking an order, my lords, on legality of the will, my lords, in FDP proceedings, my lords. My lords, my lords, Annexure,
ಆಯ್ತು, ಏನ್ ಆರ್ಡರ್ ಚಾಲೆಂಜ್ ಮಾಡ್ತಿದ್ದೀರಾ ಈಗ?
my lords, please, my lords, Annexure D, my lords, FDP order is there, my lords, application, my lords. They have, my lords, the application has been allowed, my lords, and they have conducting an inquiry, my lords, on that will, my lords. Will, my lords. In meantime, my lords, one more application has been filed, my lords, by the respondents, my lords, in petition, saying that, my lords, a direction, my lords, issuing a direction to produce the probate against me, my lords. That, my lords, that application has been allowed, my lords, at page number 62, my lords. The trial court, my lords, has directed me to produce the probate on the alleged will, my lords. My lords, in that regard, my lords, I have filed, my lords, the subject application, my lords, at Annexure H, my lords, page number 63, my lords, to stay the proceedings till, my lords, the inquiry is concluded in the FDP proceedings, my lords. Because, my lords, the parallel proceedings will not run, my lords, on the same subject matter, my lords. That's why, my lords, I have filed the subject application that came to be rejected by the trial court, my lords, against which, my lords, I am before this honorable court, my lords.
Issue notice, stay of further proceedings in miscellaneous number 30 of 2019, pending in the file of 9th additional district and session judge, Bangalore Rural District, Bangalore, till next date of hearing.
Grateful.
Cell number 21, Girish B. Baladare for petitioner, KB Naveen.
Plaintiff, my lords. Plaintiff filed the suit for seeking permanent injunction, and is the absolute owner of the property by virtue of the partition deed executed between the family members on 14/3/2022. Defendant going to interfere with the peaceful possession and enjoyment of the property, hence filed the make an application, and trial court has granted the ad interim injunction.
So you are the plaintiff.
I am the plaintiff, my lord.
You filed in a suit for
permanent injunction that came to be allowed, and injunction was granted, my lordship. It is in page number.
ಆಯ್ತು, ಡಿಗ್ರಿ ಆಯ್ತಾ?
ಇಲ್ಲ, against after securing the injunction, I have sought for police protection. Police protection also granted.
You have obtained an order on IA.
IA, my
permanent, yes.
Permanent injunction. Thereafter, the defendant preferred a miscellaneous appeal, and in the miscellaneous appeal, application came to be filed under Order 41 Rule 5, and said application is allowed by staying the interim order passed by the trial court.
No, what is that injunction order passed by the trial court?
Trial court, which is in page number 47, my lordship, discussion in para 17.
ಏನು ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ? Defendant agents interfering into the
defendant, their
peaceful
men, agents, servants, and
what is the reason given by that first appellate court?
First appellate court without recording any finding. Para page number 75, para 11, my lords. Page number 75, para 11.
Yes.
Can I read, my lords? Admittedly, the trial court passed an order restraining the defendants, appellants herein from interfering in the peaceful possession and enjoyment of over the future property. The order passed by the trial court is executable in nature And I have already discussed, it is not a proper stage to discuss much on merits of the appeal. The same may be considered after hearing both the sides in due course. It is also a well settled law at the stay proceeding in the facts and circumstances of the case. I am opinion that appellants have made out some reasonable grounds to take the operation and execution of the order as prior in the application. However, suitable condition may be imposed on the appellants to cooperate with the this for speedy disposal of the appeal without assigning any valid reason, without recording any finding. Stay has been granted to the order passed by the trial court. I have produced all the revenue document to show that I am in the owner and possession of the property. And I have exclusive right over property through the registered partition deed.
You maintain status quo.
My lord, one submission, my lord.
Yes.
The next date is 7/4, my lord. Hearing of appeal.
ಅಲ್ಲಿವರೆಗೂ status quo ಇರಲಿ. After consideration of that parties finally passed an order without giving any notice, they have stayed there. Yes. Heard.
My lord, one submission.
We'll make clear. This order will not come in the way of the first appellate court to decide that miscellaneous appeal. Yes. Or you both are agreed, I will say that till disposal of that appeal, parties to maintain status quo.
Yes, my lords.
No, my lord, that is arecanut plants in my property.
I am in possession. They have not read on any documents.
There are three survey have been done by the.
The notice did not require me. They have entered a caveat, my lord.
Yes. Parties are directed to maintain status quo.
Hello, I make one submission, my lord. If they have status quo, then now position lidive anta ಈಗ ಬಂದು ಡಿಸ್ಟರ್ಬ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. Again, they have taken advantage, my lord.
Yes. Pendency of this.
Stay may be granted, my lord. Status quo, it is a confusing order again.
No, my lord. I am in position.
Pendency of this.
Since 1964, there are.
Pendency of this appeal and granting in a status quo will not come in the way of first appellate court to dispose of that miscellaneous appeal 3 of 2025 in accordance with it. Yes. Let them dispose of. Yes.
22.
All are connected matters, my lord.
Yenavu?
Same defendant,
same order, same miscellaneous petition.
Same miscellaneous.
Yes, same. Club ಮಾಡ್ಬಿಟ್ಟು same order. Yes.
Otherwise,
Otherwise, I will direct it to dispose of the main matter.
Keep pending. This matter does not.
Till then, status quo be there. What is the next date?
Next date on 7/4.
7/4. 7/4. On that day, let them finally dispose of.
Yes, my lord.
Yes, Mister Kodi.
There's no problem.
Yes. In this, in all three common order, in this writ petitions, called in question, order dated 26/2/2016 passed by Senior Civil Judge JMFC Terikere, whereby passed an order on IA filed under Order 41 Rule 5 of CPC, state that order passed by what is the date of that order, trial court?
Trial court order is 7/12/2024, my lord.
Passed by the trial court dated
7/12/2024.
7/10/2024.
Page number 50.
Yes, the plaintiff has filed a suit for
permanent
injunction. Along with that plaintiff, he has filed an application under Order 39 Rule 1 and 2 for temporary injunction. After hearing the parties, the trial court has granted a temporary injunction on 7th December 2024, restraining the defendants and their men's agent and servant to interfere with the peaceful possession and enjoyment of the plaintiffs over suit scheduled property, or from dispossessing into the same, or from causing an act of waste and damages over the suit scheduled property, pending disposal of the suit, being agreed by the same, that defendant filed an appeal before first appellate
For that time, I make an application for seeking police protection, my lords. That application came to be allowed, my lords.
Yes, filed an appeal in MEA number 3 of 2025. ಬಾಕಿದೆಲ್ಲ ನಂಬರ್ ಯಾವ್ದಾವ್ದು ಇದಾವ ನಂಬರ್
May 3
3 of 25.
In this case, 3 of 25.
Others, allow
Others, 1, 2 ಅಂತ ಇದೆ.
Yes, filed in MA. The trial court by impugn order has stated that order passed by the trial court being agreed by the same. The plaintiff is before this court. The defendant has filed an appeal challenging that temporary injunction order passed by the trial court under Order 39 Rule 1 and 2. Since the impugn order is only interim order, the first appellate court has not yet passed a final order. In view of the above, the interest of justice, the above writ petition may be disposed of, directing the parties to maintain status quo.
Maintain status quo ಅಂತ ಅಂದ್ರೆ stay may be granted ಮೇಲೆ otherwise.
Accordingly, the writ petition is allowed. The parties are directed to maintain status quo till the disposal of the appeal filed by the defendant pending before senior civil judge
and JMFC.
Senior civil judge first additional.
The senior civil judge and
Civil judge JMFC Tarikere. That first appellate court is directed to dispose of that miscellaneous appeal number so and so as expeditiously as possible. ಯಾವತ್ತಿದೆ?
7/4 ಇದೆ ಸರ್.
Next week, Mala.
7/4 June, July ಗೆ. Yes.
Otherwise, on or before end of the April, my lord.
On or before end of 15th July.
ಇಲ್ಲ ಈ ತಿಂಗಳೇ ಸಮಯ ಈ ತಿಂಗಳೇ
ಆಗಲ್ಲ. On or before end of
next month is holiday, my lord. Vacation.
ಗೋಸ್ಕರನೇ ಅವರು ಡೇಟ್ ಕೊಟ್ಟಿರೋದು. ಅಲ್ಲೆಲ್ಲ ಜುಡಿಷಿಯಲ್ ಆಫೀಸರ್ ಎಲ್ಲ ಚೇಂಜ್ ಆಗೋದಲ್ಲ.
ಈ ತಿಂಗಳು 7th ಇರೋದು.
7th ಇದೆ ಈ ತಿಂಗಳು
7th
address the argument.
7/4 ಇರೋದು.
7/4.
Both are ready to address our arguments. It may be concluded at the end of this month.
Court is directed to dispose of that appeal by end of April. Yes.
Much obliged.
Yes.
All the contentions
of the parties are left out.
Cell number 24, Abhinav Anand K. Cell number 24.
Yes.
For petitioner in this case, my lords. My lord, suit for specific performance of contract and perpetual injunction, my lord. Suit of the plaintiff was decreed on 27/11/2014, my lords. And after that, the defendants were not complied that order, my lords. And then we have filed execution before the trial court. When the stage is posted for cross-examination of OW1, my lords, objector number 1, we have filed IA number 4 under order 3 rules 1 and 2, my lords, for GP application. That application was dismissed by the trial court, my lords. The reason given by the trial court is the IA number 4 is filed during the pendency of the cross of objector number 1, and also if this application is allowed.
No, you have filed an application.
Yes, my lords.
What is that application you have filed?
Under order 3 rules 1 and 2, my lords.
For what?
For GP application, my lords.
That is dismissed.
Yes, my lords. And IA number 5 was filed by the judgment number 1.
Stay.
That was also dismissed, my lords.
Stay of operation of order dated 3/1/2026 passed in IA number 4 in execution petition number 1891 of 2016. Pending in the file of additional city civil and session judge Bangalore till next date of it.
Cell number 25, Yamini Muniraj.
25.
Appearing for the petitioners, my lords.
Yes.
Seeking for mandamus, my lords. Reason being this matter is of 2022, my lords.
22,
my lords. 22.
To suit for?
Where injunction, my lords. We have plaintiff,
what is the
my
stage
lords.
now?
My lords, it is the stage of objections on IA, my lords.
Objection of IA under 39(1) and 2.
Yes, my lords.
You are the plaintiff.
We are the plaintiff, my lords.
You have filed a suit for injunction.
Yes, my lords.
Now that it is stage of
Objections here, my lords. The defendants.
defendant has appeared.
Yes, my lords, they have
Filed in a written
appeared.
statement.
Yes, my lords.
Issue
they've-
is framed.
No, not yet, my lords.
Yes.
My
In
lords,
this writ petition, petitioner sought following relief. Petitioner plaintiff has filed a suit for injunction. After appearance, defendant has filed a written statement. Since the suit of year 2022 written statement, so far no issue has been framed as on today. Since the suit of year 2022, the petitioner, counsel appearing with the petitioner seeking for early disposal of the suit. In view of the above, without expressing any opinion on the merit of the case, the trial court is directed to dispose of the suit OS number 26639 of 2022 as expeditiously as possible, not later than 1 year from date of receipt of a copy of this order, subject to any other stay granted by other court. Yes.
grateful, my lords.
Cell number 26 adjourned, cell number 27 KL Srinivas.
For the petitioner notice. Lords, the petitioners are the defendants number 1 and 2 before the trial court, and the application seeking to file the return statement, my lords, has been rejected as being delayed beyond 120 days, my lords.
ಯಾವತ್ತು suit ಹಾಕಿರೋದು?
Suit was filed on 12/8/25, my lords. 12/8/25.
25 after that. Yeah, ಮತ್ತೆ if law says you cannot file after 120 days.
Lords, that has been challenged in the writ petition, and that has been, the amendment has been stayed, my lords, in
Where is
WP
that?
number 3325 of 26. I have not got the copy on the.
Copy ಕೊಡಿ, stay ಆಗಿರೋದು ಕೊಡಿ. In which number?
WP number 3325 of 26, my lords.
You get that copy, stay ಆಗಿದೆಯಾ? Stay ಮಾಡಿದಾರ. Which number?
3325 of 26.
ಇದಲ್ರಿ, ಆ ನಂಬರ್ ಬರ್ಕೊಡಿ. ಆ ನಂಬರ್ ಬರ್ಕೊಡಿ. ನಾಳೆ ಕಾಪಿ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ.
Please.
This matter tomorrow. Number.
Cell number 28 Madhusudan MN.
Petitioner, my lord.
Yes.
The petitioner has filed an application under order 26 rule 9 for appointment of ADLR as commissioner to ascertain the boundary which is in illegal possession by the defendant. Suit is one for the relief of declaration and for possession. The court has framed the issue number 2 that whether the plaintiff proves that she is entitled for possession of the encroached portion. When that issue court has framed, it is the bounden duty of the court to appoint a commissioner to
Why it is
ascertain the encroachment area.
Order for rejection.
Impound, yes, annexure F, my lord, page. No, without giving any reasons. Impound order at annexure F at page 51. The learned judge simply says that suit for declaration, para tenally.
Stay of further proceedings in OS number 276 of 2016 pending in the file of Principal Senior Civil Judge CJM Tumkur till next date of it.
Please.
Yes.
Much.
Cell number 29 Vinay N.
The
Yes.
petitioner, my lord, is a sister, whereas the plaintiff in the suit, my lord, is the brother.
Yes.
Suit is filed for eviction against the tenant.
Yes.
I have filed a suit for partition against my brother. The property was initially leased out by my father.
In respect of same property.
Same property.
Yes.
So ಅಲ್ಲಿ ಇನ್ನೊಂದು ಸೂಟ್ ಹಾಕಿದ್ದಾರೆ ಎವಿಕ್ಷನ್ ಗೆ, ಅಲ್ಲಿ my application for impleading is allowed. ಈ ಸೂಟ್ ಅಲ್ಲಿ ನನ್ನ impleading application is rejected.
Why?
The court says that I need not be made a party, despite showing that in another matter my pleading is allowed.
Or issue notice. Stay of further proceedings in OS number 2136 of 2024 pending in the file of 9th additional City Civil and Judge JMFC Mysore till next day of it.
Please.
Yes.
Cell number 30 Ramesha TR.
Yes. Yes.
Suit is for a specific performance, my lord. The petitioner is the defendant.
For the defendant.
Yes.
Yes.
We are seeking direction from this honorable court to direct the trial court to dispose of the matter within a specified time frame, my lord. The suit is in the stage of cross-examination of PW1.
2014.
2014, my lord.
Yes. Heard. issue in this petitioner has sought following relief. Plaintiff has filed a suit for special performance of the contract. On service of summons, defendant appear through counsel has filed a written statement. On the basis of the pleadings of the parties, trial court has framed that issue. The evidence is over.
No, my lord. The case was posted for cross-examination of PW1
Matter
on
has been set down for
30/8/2024, my lord.
evidence. The net counsel for the petitioner submit that the suit of year 2014, even after lapse of 12 years, the suit is not disposed of when she sought for early disposal of the suit. In view of the above, without expressing any opinion on the merit of the case, the trial court is directed to dispose of the suit as expeditiously as possible, not later than 10 months from date of receipt of the copy of this order, if there is no stay granted by any court of law in any other proceedings. Yes.
Cell number 31, Abhinag S for petitioner. Chintan
K-Wait is
Chinnappa.
responded
I request for a pass over, my lords. My senior's on his legs.
My lords, I don't have any objection allowing the petition itself because I have informed the court in below in commercial court also, my lords. Kindly see page number 51.
What is that order he has challenged?
My lords, I had filed an application for deletion. The suit is filed for recovery against, my lords, the.
So you are the defendant or a plaintiff?
I'm defendant number 36, my lords.
Suit for?
The suit is for recovery.
Recovery.
My lords, the builder, the developers,
No,
my lords,
that's-
defaulted.
What is that application you have filed?
Please, my lords, I filed an application seeking for deletion under order 1 rule 10, my lords.
Deletion of?
Deletion of my name from the array of parties.
Yes. Trial court is dismissed.
Trial court is
You are the
dismissed.
plaintiff.
Yes, ma'am,
Please.
for the
You have no
plaintiff.
objection to
No,
delete.
let's,
Then why you have made him as in a party then?
My lords, after we made him a party, he has deposited the amount in the escrow account.
Yes.
So I
You have also no objection to delete him.
No, my lords.
Yes, we'll allow that.
Please.
Yes. This writ petition. Petitioner. You are appearing for all two plaintiff.
Respondent 1,
plaintiff.
2, 3, my lords, plaintiffs. Others are
My
respondents.
lords, the
You
others
are
I'm
appearing
seeking
for
for.
all plaintiffs, madam.
All
all
plaintiffs,
plaintiffs.
that is respondent 1, 2, 3.
Yes.
As far as the others I'm seeking for dispensation.
Others is not necessary.
Please.
Plaintiff don't want that.
Please.
Yes. Challenging. Order dated. What is the date of that order?
My lords, the date of the order, my lords, is.
There is 13/2/2026.
Please, 13.
Whereby trial court has rejected that application filed by the plaintiff, the petitioner under order 1 rule 10 for seeking striking down or deleting the petitioner from arrive as a party defendant. Plaintiffs are filed in a suit for recovery of money. The petitioner has been made as defendant number 36.
36.
On service of summons, defendant appeared through till has filed an application.
I'm sorry, I have not received summons, my lords. I learnt of the suit and voluntarily appeared before the honorable
Yes.
court.
Filed an application for deletion of the petitioner as arrived as in a party defendant number 36. The trial court has rejected the same. Learned counsel appearing for the plaintiff, so and so learned counsel appearing for the plaintiff has submitted that the defendant, the plaintiff, the petitioner, defendant number 36 is not a necessary or proper party in the suit. They can be deleted and their application for deletion may be allowed. In view of the above, the writ petition is allowed, order dated, so and so is set aside. The IA number?
IA number 67.
IA number 67 filed by the petitioner under order 1 rule 10 is allowed.
Millards, may I also request they be directed to delete references to the petitioner in the plaint, Millards. That they have, my flat is arrayed in the schedule. If they may delete reference to my flat, Millards, in
No,
the
what is
plaint.
that relief you have sought? You have sought for deleting your
Deletion,
name?
please.
That's all.
Please,
But don't ask further.
please.
Obligation.
Yes.
Great.
Cell number 32, Vinay D. Vasmat.
Appear for the petitioners in this matter. Petitioners are defendant number 2 and 3. Respondent number 1 is the plaintiff.
Yes.
Sued for bare injunction. The respondent number 1 herein filed an application under Order 39, Rule 1 and 2. It was allowed. We challenged it in an MA. MA was dismissed.
What is
The
that?
main contention ಏನು ಅಂದ್ರೆ the property was purchased from joint family nucleus. The husband of the plaintiff is our brother.
Yes.
He made an sale agreement in the year 2002.
That property is a land property. or-
Landed property, my lord.
How
ಮೂರು ಪ್ರಾಪರ್ಟಿ ಇದೆ.
parties are directed to maintain status quo in respect of suit scheduled property till next date of hearing.
I have sought for interim order, operation execution of order passed annexary. ಏನಾಗತ್ತೆ ಅಂದ್ರೆ ಅವ್ರೊಬ್ರೇ ಎಂಜಾಯ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಅದರಲ್ಲಿ ಬರೋದು ಅರಕನಟ್ಟು ಕೊಕನಟ್ಟು ಬೆಳೆದಿದ್ದೆಲ್ಲ ಅವ್ರೊಬ್ರೇ ತಗೊಂಡು ಇದು ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
Two court orders against
Please,
you.
please, my lord.
You are not.
ಅಲ್ಲ
even
ಇನ್ನೊಂದು ಏನಾಗಿದೆ ಅಂದ್ರೆ
entitled for
ಮದರ್ ಆಫ್ ದಿ ಪ್ಲೇಂಟಿಫ್ she has filed a suit for partition excluding these 3 properties saying that it is ಅವಳ್ದು ಅಂತ.
Yes. Yes.
Please.
Status quo. Yes.
33, Janardhan Reddy BJ for petitioner, Hari Krishna Pramod.
I appear for the caveat or respondent.
Yes.
Your Honor, the petitioners or the defendants in suit filed by the first respondent
Yes.
is a partition suit,
Yes.
and she had obtained export ad interim injunction, which came to be vacated on my application.
Yes.
And they challenged before the.
What is that ex parte injunction?
Ex parte injunction not to deal with the property,
Yes, alienation.
not to alienate all the,
Yes.
after various.
That appeal.
And appeal they filed. In the appeal, very first hearing, they filed a memo, the appellant filed a memo requesting the court to dispense with the notice with respect to other respondent, other than respondent 1 and 5 and 6, who are the contested respondent as far as the interim order is concerned. Meantime, the court was of opinion saying that let the notice to be served on all the respondents. And notice was issued, they have taken a hand summons and they returned various memos, even reporting saying that the defendant number 9 and 15 have died before filing the suit.
You are the defendant number?
I am the defendant 1 to 6 we are appearing.
1 to 6. You have not filed any application for vacating.
We filed a vacating, other than dispute illa samit. Under interim order was vacated.
You have filed an application for vacating.
ಹೌದು ನಾವೇ
They have filed an appeal.
ಅದೇನಾಯ್ತು appeal file.
They have filed an appeal.
ಹೌದು.
Notice has been served to you in the appeal.
Appeal, they sought dispensation notice except the contesting respondents.
No, that's what I am asking.
And
That
I was the contesting respondent.
for you, notice has been served.
Notice, I was the caveator, notice was served.
Then you
And-
don't worry about others because they are not before the court. They have not challenged. they
ಇಲ್ಲ
have not
ಆಗಲ್ಲ.
filed-
ಅವರು suit ಅಲ್ಲಿ they are still a parties.
No, it is true. They have not filed IA for vacating.
ಅಲ್ಲ ಅದಿಲ್ಲ dispute
They
ಅದಲ್ಲ.
are- they are accepted that.
They are-
You have been served, is it not? Then you make your case. You don't worry about that.
But
Don't
this
take-
is an application for deletion where I deleted the formal
Allowed.
parties in the appeal. My learned friend takes an objection saying they should not be deleted in the appeal. It is
Now,
an
what
appeal
is that
arising
you are-
out of a 39 1 and 2.
Yes. What is that now you are challenging?
The application came to be allowed. They filed a 1 rule 10. What happens, I just make submissions. Meantime, they filed a memo saying that even.
ಆಯ್ತ್ರಿ ಅವರು ಅಗ್ರಿ ಹೊಡಿದ್ರೆ ಅವ್ರು ಬಂದು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ತಾರೆ ಇಂಪ್ಲೇಟ್ ನೀವು ಆರ್ ಯು ಮಿಸ್ಟರ್
ಅಲ್ಲ suit ಅಲ್ಲಿ they are still parties to me.
ಆಯ್ತ್ರಿ ಸೂಟ್ ಅಲ್ಲಿ
When they are parties to the suit,
you go and argue that appeal is not maintainable, you show that law, you don't take wakalat on them, mister.
Lordship, the.
They are not before the
Supreme
court.
Court is very clear in the appellate stage, the appellate court has no absolute powers to delete the parties to the.
No, who are you to ask? You have not been deleted. You are a party there.
No, I understood, my lord, but they, even according to the
They
appellant.
don't want to come before the court. They don't want any party.
No,
Why
even
do-
according to the appellant, they are interested parties, they are the subsequent purchasers.
The deletion is at my risk. I have sought to delete
They
them in
could
the
have
appeal.
sought, my only submission, instead of deleting, they could have sought for dispensation.
ಅದು ಅವ್ರಿಗೆ ಬಿಟ್ಟಿರೋದ್ರಿ ಅವ್ರದ್ದು ಅಪೀಲ್ ನಿಮಗೆ ಯಾಕೆ ತಲೆ ಬಿಸಿ ಹೇಳ್ರಿ you have been served, you are there, you contest it, mister. Why do you want to others to be worried?
Yes, the court could have been allowed the dispensation, even I said I have no objection.
Yes.
They
yes.
even deleted the deceased the respondents.
Yes.
So,
Yes, in this writ petition, petitioner called in question, order dated 28th February 2026, passed by First Appellate Court in MA number 23 of 2025, whereby IA filed by that appellant under order, appellant plaintiff under order 1 rule 10(2) is allowed. Plaintiff has filed a suit for partition. Along with that plaint, he has filed an application under order 39 rule 1 and 2. The trial court has granted an ex parte injunction order directing the parties to not to alienate the suit scheduled property. On appearance of petitioner, defendant number 13134 5, 6, 7, 8.
7 and 8.
8. Filed an IFR vacating. On their application, the ex parte injunction order has been vacated. Being agreed by the same, the plaintiff has filed an appeal before the First Appellate Court in MA number 23 of 2025. The plaintiff also filed an application under order 1 rule 10(2) for deletion of respondent number 9 to 16 from arrived parties in that appeal. The same is allowed. The respondent number 9 to 16 neither filed any application for vacating that interim order passed by the trial court or have challenged that impugn order. The petitioner who are a party before that appellate court, they have been duly served. They are before this court. Since the person who has been deleted has not challenged, the petitioner has no rights to question the same. There is no error or illegalities. Hence, the writ petition deserved to be dismissed. Accordingly, writ petition is dismissed.
Serial number 13 is connected to this.
Serial number 39.
39 same.
Same, the MA number is 24. This is 23, that is 24. Arising out of the same dispute,
Yes.
different order.
Other MA number on change, disposed of. Yes.
Serial number 54, Srinivasan T.
Yes, Inwar.
Petitioner is the defendant number 1, suit for specific performance. The original plaintiff KH Babu, he died on 21/10/2024. The applicant respondent number 1 claims to have, by virtue of an assignment deed, wants to come on record. The very assignment deed is suspicious. In that regard, the impugned order at page 18 may be looked into.
No, anybody is dead. No, he wants to.
Plaintiff number 1 is dead.
Plaintiff number 1 is dead.
Original plaintiff dies. Within 4 days of executing the assignment deed. And the observation made by the trial court in the impugned order at page 18, paragraph number 4, about 5 lines from the bottom.
Yes.
The assignment deed dated 17/10/2000.
Have you filed any objection?
I have filed my objection.
You have disputed that?
Yes.
No inquiry is conducted?
No inquiry is conducted.
Yes.
In
Where is
similar
that
matter,
application?
this honorable court, in a connected matter, this honorable court had stayed the further proceedings and in respect of the adjoining property, that is.
Yes. Heard.
Notice may be dispensed to respondent number
They are further
2 and 3, my lord.
OS number 637 of 2012, pending in the file of 7th additional senior civil judge, Bangalore Rural District, Bangalore, till next date of hearing.
Notice may be dispensed to respond number 2 and 3. I'm
Memo
filing a
ಕೊಡಿ,
memo.
Yes.
Serial number 35, Krishnappa M for petitioner, Raghunandan MS.
Yes.
Lordship, one submission, Lord. KVT on record counsel or hospitalized ಆಗಿದ್ದಾರೆ. Kindly on Monday or Tuesday.
Yes, Mr.
ಅವ್ರ mild stroke ಆಗಿದೆ.
Is there any, when is the next day suit?
ಇಲ್ಲ ಇದರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ IA for impleading has been rejected. I have filed the IA for impleading that has been rejected.
Now suit, what is the next date in the suit?
Next date 26 April or some such thing.
ಅವ್ರೇನೋ hospitalized ಆಗಿದ್ದಾರಂತಲ್ಲ? Will have it on 6th, 7th or 8th? Please. Yes, 8th.
Serial number 36, BC Venkatesh.
To appear for petitioner. Lord, the petitioners may not impleading applicants before the trial court. Lord, the plaintiff had a suit for declaration against the defendant. Lord, in respect of Lord, in extent of 4 acres of land. Lord, wherein not we have also purchased. But during Lord, suit for declaration. In fact, there is a issue Lord, regarding this issue, saying that not whether the defendant number 1 is proved that the non-gender of necessary parties. In fact, my side it has been confronted through PW1. My means impleading applicants. Lord, when I filed an application for impleading.
When you have purchased?
2009 and 10.
When that defendant is purchased?
No, my lord, defendant through, my lord, I have purchased the, my lord,
through defendant.
Properties from the plaintiff. Plaintiff only sold the property in favor of.
No, then he is seeking a declaration on what basis?
D2 is a developer.
No, declaration on the basis of?
My lord, they claim that, my lord, in fact, I have given the authority to sell the property, and while selling the property.
Plaintiff
is the original owner.
Original owner.
Not he assigned the, my lord, property to the defendant to farm the layout and sold the property.
Same property is sold to you before that.
Please, my lord.
Same property is sold to you before
Please,
that.
My lord.
When
same property was farmed, the same property was, not the layout was farmed.
No,
and
when
it is 9 and 10.
sold.
9 and 10.
No, when it is sold to you.
You are the subsequent purchaser in the layout formation farmed by the defendant.
Layout you are purchaser.
I am the subsequent purchase of the, my lord, plot. Farmed by the defendant number 1. Now, my lord, there was a dispute between, my lord, the sale consideration. They filed a suit for declaration. Where, my lord, in fact, my lord, during cross-examination, during evidence, my lord, my sale deed has been confronted to the witness, plaintiff, and he admitted having, my lord, executed the sale deed in my favor.
ನಿಮ್ಮ vendor builder ಇದಾರಲ್ಲ, he will protect you.
No, defendant 1, my lord. In fact, my lord, there is a issue regarding that.
What is the reason for rejection your application?
ಅದು ಬಹಳ ಹಳೆ since, my lord, it is a old 2012 suit ಹಂಗಾಗಿ impleading application there are one, there is a reference, my lord.
ಆಯ್ತು, ನೀವು ಇಷ್ಟು ದಿನ ಏನ್ ಮಾಡ್ತಿದ್ರಿ?
ಅಲ್ಲ, ನಮ್ಗೆ ಗೊತ್ತೇ ಇಲ್ಲ, ಅದು ಸೂಟ್ ಹಾಕಿರೋದು ಗೊತ್ತಿಲ್ಲ. In fact,
ಗೊತ್ತಾಯ್ತು.
ಅಲ್ಲ, recently, my lord, when they tried to settle it, when the suit for declaration is pending, no, they want to set it, my lord, among the plaintiff and defendant. Then thereafter, my lord, we came to that, my lord.
Defendant is your vendor.
No, my lord, they're the developer.
You have purchased from developer only.
No. No.
That's why I also given that assignment to that bidder.
Lord, plaintiff is the owner. Lord, he entire, my lord, handed over the, my lord, 4 acre land to the defendant. Defendant farmed the lot and sold the property. Accordingly, my lord, plaintiff has sold the property through defendant. Since D1 is a developer, my lord, he sold the property.
ನೀವು ಯಾರಿಂದ ಪರ್ಚೇಸ್ ಮಾಡ್ಕೊಂಡ್ರಿ?
Plaintiff ಇಂದಾನೆ.
Through developer ಅಥವಾ direct plaintiff ಇಂದ?
Developer is only consenting witness. He's only witness to the sale deed.
Heard. Issue notice. Stay of further proceedings in OS number 476 of 2012. Pending in the file of first additional senior civil judge JMFC Ramnagar till next date of hearing. What?
37 disposed of, 38 Bhargav D. Bhatt. 38.
Issue pertains to refund of court fee, my lord. Here I had filed a suit for eviction in the commercial court. The defendant, he appeared, and before he filed his written statement, he filed a section 8 application seeking the matter to be referred to arbitration. Section 8 was allowed. My lord, I sought for refund of the court fee I had paid since the matter was referred to arbitration. The trial court says that mere reference is not sufficient, but it should be settled in arbitration. Only then you're entitled for your court fee. However, my lord, that position is not correct, and I'm relying on the judge coordinating bench.
What is the court fee? How much you have paid?
63,000 was paid before the trial court.
Yes. What is that order yours?
I'm relying on the judgment of the coordinate bench, my lord. Paragraph number 11, they refer to the Madras High Court decision.
Yes. Yes.
Paragraph number 9, my lord. The extracted portion, my lords may find it in internal page number 14.
Yes.
Para number 10. Ali kelgade portion ali highlight ಮಾಡಿರೋದು.
Yes.
From the narration and reproduction of the relevant provision supra, it unfurls and emerges very clearly that the plaintiff would certainly be entitled to refund of court fee when a matter is referred to arbitration even prior to 1/3/2017. But the caveat of the rider is it should have culminated in a settlement. In light of the amendment to section 69A of the Court Fees Act, a reference to arbitration would suffice and it need not actually culminate in a settlement. This is obtained,
What is court fee? Amendment section court fee.
Court fee, my lord, I'm relying on
69A.
section 66, man.
66.
Section 66 of the Court Fees Act, where it says where the court refers to parties to the suit to any one of the modes of settlement of dispute referred to in section 89 of the CPC, and the dispute is settled, 75% now, which is amended to 100%.
Yes.
Of the amount of court fee paid in respect of the claim or claims in the suit shall be ordered to be paid by the court to be refunded to the parties.
Matter also same issue. In this referring, it's also referring to that arbitrator. It has
Yes, my lord. It's referred to the arbitration. In fact, if my lords may see the last paragraph in paragraph number 17,
Yes.
the court in fact directs the state government to consider deleting those words, which says that the matter has to be settled.
To notice that section 66 of the Act defines the word and the refund for that amendment is so. Yes, or this petition. Respondent has no objection because. Yes.
No, my lord, they've not placed any objection before the trial
Sought
court, and I also seek for
challenging that-
dispensation of notice to respondents.
Yes, dispensed. Challenging that order dated 22/1/2025, passed in commercial OS number 936 of 2024, passed by 85 additional city civil and session judge, Bangalore, whereby request of the plaintiff for refund of court fee of rupees 63,900 has been rejected. Plaintiff has filed a suit for
eviction.
Suit for eviction. On appearance of defendant, the matter was referred to arbitration.
They filed section 8, my lord, and that was allowed.
Yes. On appearance, they have filed a section 8 application, section 8 of arbitration and conciliation. Thereafter, matter has been referred to arbitration. Therefore, plaintiff has filed an application for refund of court fee. The similar issue has been considered by this court in WP 9801 of 2025. The relevant paragraph, para 9 in the 17 ವರೆಗೆ extract ಮಾಡಿಸ್ತಾರೆ. In view of the above, order dated so and so, passed by the commercial court is set aside. The concerned court is directed to refund that court fee paid by the plaintiff after due verification. Yes.
One clarification, my lord. The impugned order is both an order on section 8 as well as court fee refund. We are challenging it only with respect to court fee refund.
Only, yes. Order dated so and so set aside only in respect of rejection of refund of court fee.
Yes, ma'am. Please.
Yes.
Serial number 39 disposed of, serial number 40, HR Umadevi.
Applying for petitioner.
Yes.
Petitioner is the defendant number 4 and the plaintiffs are the respondents 1 to 3. The suit was filed by the plaintiffs for partition and separate possession, Your Honor. What happened during the, your lordship may kindly see, though in my written statement, they have taken a specific contention that.
Suit for partition.
Yes, my lord.
What is that order you are challenging now?
Challenging the order of IA number 2 filed under order 14 rule 5 for recasting of issues.
IA number?
IA number 2, recasting of issues, my lord.
You have filed an application.
Yes, my lord.
What is that issues you want?
Issues, why, what the issues I sought for is the whether the plaintiffs prove that they are the daughters of late Jairamaya, whether the plaintiffs further proves that they are in joint possession of the scheduled property, whether the suit is barred for non-joinder of necessary parties, whether the suit is barred by time, and court fee
Yes,
paid
what is that
insufficient.
order passed by the trial?
Order only, it has been allowed in part and rejected my claim, my relief, the recasting of issues, whether the plaintiff proves that they are in joint possession of the scheduled property. Your lordship may kindly come to the plaint. In the relief at page number, they specifically ask for set declaration that the sale deed in my favor is not binding. That itself shows that they are already parted with the
If are not in
possession,
the
my lord.
joint position and also court fee paid insufficient. So far the joint position court fee has. Suit is filed for the relief of partition and the defendant one are said to be a brother and sister of court relies upon the constructive position. See, suit for partition,
Yes, my lord.
presumption is that they are all in that joint position.
Joint possession, if they are continued with, admittedly, it has been sold, the prayer itself, your lordship may kindly come to the prayer in page number
No, is it
22.
your contention that they have sold that property to you?
Yes, my lord, though the plaintiffs, I am denying their relationship with their father because they were not parties. The issue is whether, because that is only the crucial issue, they are not in possession, page number 22, second
notice.
relief itself is that a declaration that sale deed dated.
In OS number 252 of 2023, pending in the file of 7th additional senior civil judge and JMFC Bangalore, Rural District, Bangalore, till next date of it.
Office objection, first time matter, cell number 41, Ananta Padmanabha GN.
In the course of the day, the office objection is very simple objection. I will
Yes, pass over.
Cell number 42, P Nataraju.
Yes.
Office objection. More than one year.
Court fee katidira?
Court fee cut.
Yes. Submission is accepted, office objection is overruled.
Yes. The defendant's petition.
Yes.
The plaintiff filed a suit for recovery of the money.
Yes.
Lord, on the basis of the checks, my lord, the plaintiff, my lord, defendant filed the return statement disputing the signature in the check. Therefore, he has filed an application annexure C, my lord, at page 18, for referring the admitted signature to the handwriting expert. My lord, the respondent has filed the statement of objection at page 22, my lord, contending that the original checks are produced in CC number, my lord, filed on the same checks, my lord. But therefore, my lord, the petitioner has filed an application, annexure E, my lord, order 13, rule 10, let me section, to call for the records in CC number. Exhibit P1 and P2, my lord, marked in exhibit CC number 21, my lord.
Where is that order?
Unfortunately, what happened there, what has happened, my lord, this application was not noted in the order sheet. Therefore, my lord, the trial court rejected the application on the ground that, my lord, the handwriting original records are not in the in this court, my lord. Therefore, the application is rejected.
Issue notice, stay of further proceedings in OS number 79 of 2023, pending in the file of senior civil judge JMFC Kollegala till next date of it.
Cell number 43, Arjun Rao.
Petitioner.
What is that office objection?
There is one or two office objections with respect to, my lord, the non-pay affixing the.
Pass over, complaint.
Will comply. It's only a 2-minute matter.
No, only compliance after that. If office objection, it need not be complied. I can overrule, I will do it.
Yes.
Otherwise, comply. Or there is no urgency, I will grant a time, you comply it and post it for preliminary hearing. Which one you want?
Today. Because your lordship's list is long, I'm just.
Yes, otherwise I will have it tomorrow, you comply it.
Comply with today.
Yes.
Have it tomorrow.
Yes, leave this tomorrow in preliminary hearing list if office objection is complied.
I'll comply it, right?
Yes.
44.
Same.
Yes, same. 43 and 44.
Yes.
45.
Lordship can permit us to take the file, Lord.
Yes, yes, they will give.
Only one request is, Lordship may permit us to add all the parties. All the parties in the suit have not been added.
No, whichever it can be complied, you complied.
Yes,
it can be overruled, you will convince, I will overrule and pass it.
Yes. We'll comply. We'll take the
Yes,
file.
yes, you can take it. Yes.
45.
To appear for the petitioner, my lord.
Yes.
Lord, eviction suit, I have complied with.
Objection.
My lord, only one objection remains to be complied. That may be overruled, my lord.
What is that?
The objection is that co-defendants have not been made a party. Lord, the fact is all the defendants have filed one written statement together.
Yes.
And one counsel is representing all the written statement. My IA has been rejected. I have come before this court.
Yes.
Please, my
Subjection
lord.
is accepted, office objection is overruled. Yes, what is this matter?
My lord, the matter is that the suit is for eviction.
Yes.
The plaintiffs claim that I was a tenant under their father and I'm not paying them rent.
Yes.
I am the defendant. I am contending that I have been in possession since 92 and the father of the plaintiff,
Suit for?
eviction, my lord.
Suit for eviction.
Father of the plaintiff had executed an agreement to sell in my favor, handed over the possession to me, and I have paid the entire sale consideration. I am in possession under 53A of the Transfer of Property Act, my lord. That is my contention. Now, my lord, that original agreement to sell.
What is that application you have filed?
Please, my lord, the application, my lord, you will find that annexure K, page number 88, my lord.
An application under which?
My lord,
provision?
application under order 11 rule 14 of CPC seeking the production of one original partition deed. They have produced the certified copy. It contains the signature of the executor of that agreement to sell.
What is that order?
My lord, order is that I have not explained the ground for, I have not explained the order, my lord. Will find it at page number 95. The trial court has rejected my application saying that I have not explained the purpose for seeking that document. I have clearly explained in my affidavit that I am seeking it because it is required for comparison of signature, my lord, covered by judgment.
95.
95, my lord, please.
Yes. Read.
My lord, this is the
A filed under
Governments are
directed to plaintiff to produce that original registered family partition deed which is registered under. Read para 2.
My lord, the operative portion is 5th para. May I read that, my lord? Or
The objection by the plaintiff. The suit. Para 4 you read.
para 4, please, my lord. The suit is filed for relief of recovery of possession and payment of due rent amount of 7,20,000. It is pleaded in the plaint that M.Y. Puttana during his lifetime let out the suit schedule property for rent in favor of defendant number 1 to 5 on oral rent agreement. However, M.Y. Puttana was the owner of the suit schedule property. M.Y. Puttana was collecting rent amount of the rented premises. M.Y. Puttana partitioned his property among family members on 25/7/2005. The said deed is registered one. As per that partition deed, portion of that property was given to M.Y. Puttana and his wife, who is the first plaintiff. M.Y. Puttana died in road accident. After his death, first plaintiff became the owner of the allotted property. The second plaintiff is the son of the first plaintiff. After death of M.Y. Puttana, his legal heirs approached the defendants and asked to vacate the rented premises for their own purpose. Such a demand was frequently made, but defendant denied to vacate the premises with one or the other pretext. The learned counsel for the defendants argued that production of original registered family partition deed dated 11/8/2005 is very much required to compare the signatures of M.Y. Puttana in the said partition deed, which is similarly found in agreement dated 6/4/1992. My lord, one submission here I would like to make. They have not denied the possession of this agreement. They are very much in possession of this agreement. They are only saying certified copy is produced, we need not produce the original one. My lord, it is settled possession of law that certified copy cannot be used for purpose of comparison of signature, my lord.
Next parabody.
Please, my lord. The dispute of, as such, the counsel for defendant prays to direct the plaintiffs to produce the partition deed. The dispute of signature of M.Y. Puttana can be clarified by collecting other documents which was signed by M.Y. Puttana, for which partition deed of family of the plaintiffs is not required for the defendants.
No, what is that other documents is available?
No other documents are available, my lord. That is my contention. The only way in which I can prove my defense is by comparison of this document, my lord.
Stay of further proceedings in OS number 116 of 2019 pending in the file of senior civil judge Nanjangud till next date appeal. Yes.
Obliged, my lord.
Cell number 46, J.S. Srikante Gowda.
Yes, Mr. Gowda.
Lord, may I pray for hand delivery, my lord.
What
4th
that
is the
office
next
of-
date.
Yes. Defendant number 7 named to be clarified at the petition. Defendant number 16, Sri Ranjay Gowda not made a parties. Amendment plaints be furnished. What is this?
Defendant number 17.
Hmm.
Seven.
7.
Defendant number 7.
Named to be clarified.
Respondent number 10 minute.
Hmm.
He was made as a party to the proceedings.
Yen hesuru tappidiya? Why that clarification? Defendant number 9 name to be clarified.
B.M. Munishami, son of B.M.
Munishama.
B.M. Munwing Tappa.
Defendant number 7.
ಅದು
Seven
ಉಲ್ಟಾ
is-
ಆಗಿದೆ.
Huh?
B.M. ಮುನಿವೆಂಕಟಪ್ಪ ಅನ್ನೋದು ಮೇಲ್ ಬರ್ಬೇಕಾಯ್ತು. ಸನ್ ಆಫ್ ಲೇಟ್ B.M. ಮುನಿಶಾಮಪ್ಪ ಅನ್ನೋದು ಕೆಳಗೆ ಹೋಗ್ಬೇಕಾಯ್ತು. ಅದೊಂದು ಅದಾಗಿದೆ ಅಷ್ಟೇ.
Yes, what is
ಆಮೇಲೆ ಇನ್ನೊಂದು ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಬಂದು
ಕರೆಕ್ಟ್ ಮಾಡಿದೀರಾ ಅದನ್ನ? ನಂಜೇಗೌಡ ನಾಟ್ ಮೇಡ್ ಎ ಪಾರ್ಟಿ. ಹೂ ಇಸ್ ನಂಜೇಗೌಡ?
ನಂಜೇಗೌಡ ಸತ್ತೋಗಿದ್ದಾರೆ. ಡಿಫೆಂಡೆಂಟ್ ನಂಬರ್ 16 ಅವ್ರ ಲೀಗಲ್ ಏರ್ಸ್ ಅವರೇನೆ. ಈಗ ನಾವು ಪೆಟಿಷನರ್ 1 and 2 ಆರ್ ದ ಲೀಗಲ್ ಏರ್ಸ್.
Yes, what is this matter? Yes.
Read the plaintiffs, respondents 1 to 3 herein, they filed suit for partition in the year 2010.
Yes.
And they have not challenged the sale deeds under which we have purchased the property, all the suit schedule properties. Suit for partition.
Yes.
And we have purchased the properties from the then joint family members who have partitioned the properties in the year 1984 itself.
Yes.
And we have purchased in 2005.
Yes.
Even after having the knowledge, they have not challenged. Even the plaint governments indicates the sale of the properties.
Now, what is
In
that order you are-
2025, they have sought for amendment of declaratory relief to challenge these sale deeds.
Yes.
It is after 15 years, they have filed this application. Time board relief, as per Supreme Court judgments, it is not
Application is
permissible.
allowed.
Yes, it is allowed, without even referring to the.
Issue notice. Stay of further proceedings in OS number.
Stay up the order, stay up the order on IA.
No. Amendment. Tomorrow, if writ petition is dismissed, the suit is concluded, then it will be infructuous. Stay of.
Full stay ಮಾಡೋದ್ರಿಂದ.
No.
At least further proceedings in that.
Amendment application stay ಮಾಡ್ಬಿಟ್ಟು ನಿಮ್ ಸೂಟ್ ಸ್ಟೇ ಮಾಡ್ಲಿಲ್ಲ ಅಂತಂದ್ರೆ ಸೂಟ್ ಡಿಗ್ರಿ ಆಯ್ತು ಅಂತ ಇಟ್ಕೊಳ್ಳಿ. ನಾಳೆ ಇವ ರಿಟ್ ಪಿಟಿಷನ್ ಇಸ್ ಡಿಸ್ಮಿಸ್ಡ್. ಅಮೆಂಡ್ಮೆಂಟ್ ಪಿಟಿಷನ್ ಎಲ್ಲಿ ತಗೊಂಡೋಗೋದು ಅವಾಗ? Therefore, suit has to be stayed. Otherwise, yes. OS number 520 of 2010, pending in the file of third additional senior civil judge JMFC. ಯಾವರು? ದೇವನಹಳ್ಳಿ. Till next date of hearing. ಅದು ಹೆಸರು ಸರಿ ಮಾಡಿ. ಆ ಹೆಸರು ಸರಿ ಮಾಡಬೇಕು. ಉಲ್ಟಾ ಆಗಿದೆ ಅದನ್ನ ಸರಿ ಮಾಡಿ.
Those two objections may be overruled. One, I will rectify.
Correct it name.
Yes, correct.
Yes, submission is accepted. Office objection is overruled.
Office objection, second time matter, serial number 47 adjourn with amendment.
Yes.
Serial number 48, Chokka Reddy.
Yes, Mr. What is that office?
Office objection is made. The single writ petition against the IA number 1 and 2 is not maintainable.
Court fee cut is
That is, court fee is paid, made.
Yes, sir.
100 rupees, made.
No. How many IAs are there?
But that is not the IA. Now, ex parte interim order was not granted by the trial court. That order was challenged. 2 IAs filed by the petitioner before trial court. So the IA number 1 is not to alienate the property, not.
ಎರಡು IA ಅಂತ ಅಂದ್ರೆ ನೀವು 200 ರೂಪಾಯಿ ಕೋರ್ಟ್ ಫೀ.
But 2 IAs, we have not seeking the challenging the 2 IAs order. That is the ex parte order we have challenged.
Under the rule, each IA you have to file.
200 rupees paid, minute.
200 is paid.
200 is paid.
You said 100 rupees ಅಂತ ಹೇಳ್ತಿದ್ರು.
But earlier 100 rupees paid. Again objections is right. Thereafter 100 rupees.
What I am asking,
yes,
whether you have paid 200 rupees.
200 rupees paid.
Where is that 100 rupees other court fee?
That is a receipt, my lord. I have paid in online.
Where is that? Yes, we'll come at 2:30.
Yes.
If it is not paid, you paid it and come back.
Yes, please.
Otherwise, you show that receipt.
Yes,
we'll come back to that.
Put up, sir. Okay. Put up, sir. Overruled. 45, 46 ಎಲ್ಲ
serial number 85. Adjourn ಮಾಡಿ stay extension.
Court officer. Court officer.
ಹೇಗೆ ಅಂತ ಹೊಂದಿಲ್ಲ. 12 notice.
Court officer, serial number 73 adjourn ಆಗಿದ್ಯಾ?
40.
Serial number 73.
ಆಗಿದೆ.
Serial number 73 adjourn court officer.
ಆಗಿದೆ ಸರ್, ಆಗಿದೆ ಸರ್.
ಡೇಟ್ ಏನಾದರೂ ಇದೆಯಾ?
ಇಲ್ಲ. ಹೇಳಿ. ಏನು ಅಡ್ಜರ್ನ್ಮೆಂಟ್? ಇಲ್ಲ. ಫೈಲ್ ಇಸ್ಕೋಬೇಕು.
ಇಲ್ಲ ಕರೆಕ್ಟ್ ಆಯ್ತು ಕಣ.
ಇಲ್ಲ.
ಕರೆಕ್ಟ್ ಆಯ್ತು ಲಿಸ್ಟ್ ಅಲ್ಲಿ.
ಹೌದು. ಅದು ಅವ್ರ ಕೋರ್ಟ್, ಇನ್ಚಾರ್ಜ್ ಕೋರ್ಟ್ ಇದೀವಿ ನಾವು.
ಹರೀಶ್ ಕುಮಾರ್ 6 ಕರೆಕ್ಟ್ ಐತೆ.
ಹೊಸ ಪ್ರೊಸೀಜರ್.
R4 ಸರ್ಡ್ ಐತೆ.
ತಿರ್ಗಾ ರೀಪೋಸ್ಟ್ ಆಗಿ
R5 ಆಗಿಲ್ಲ. R4 ಐತೆ, R5 ಆಗಿಲ್ಲ, R7 ಐತೆ, R8 ಐತೆ, R9 ಐತೆ.
ಕರೆಕ್ಟ್ ಆಯ್ತಲ್ಲ ಅಂತ ನಾವು 1 to 3 ಇರೋದು ನಾವು
ಆ ಕೋರ್ಟ್ ಅಲ್ಲಿಗೆ ಕೇಳ್ಕೊಬೇಕು.
ಕರೆಕ್ಟ್ ಆಯ್ತು ಅಂತ ಇಲ್ಲಿರೋದು ಲಿಸ್ಟ್ ಅಲ್ಲಿ.
ಆ ಪ್ರೊಸೀಜರ್ ಗೊತ್ತಿಲ್ಲ, ಅವ್ರಿಗೆ ಹೇಳಿ ಅಂತ ಹೇಳಿದರೆ ಆ ಕೋರ್ಟ್ ಆಫೀಸರ್ಗೆ ಹೇಳಿ. 57 ಇದೆ. ಹಾ ಸಾಹೇಬ್ರು ಇರ್ಬೇಕು ಸರ್, ನನಗೆ ಅಡ್ಜನ್ ಮಾಡಪ್ಪ ಅವರಿಲ್ಲ, ಸಾಹೇಬ್ರು ಬರ್ಬೇಕು. ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಕಂಪ್ಲೈ ಮಾಡಿ ಅಂತ ಅಂದ್ರು ನಿಮ್ಗೆ ಅಷ್ಟೇ. ಅವ್ರು ಮಾಡಿ ಕೊಡ್ತಾರೆ. ನಿಮಗೆ ಕಂಪ್ಲೈನ್ಸ್ ರೆಕಾರ್ಡ್ ಬೇಕು ಅಂದ್ರೆ ಕೇಳಿ ಕೊಡ್ತಾರೆ. ಆಯ್ತು, ಎಷ್ಟು ಸೀರಿಯಸ್?
Fifty-seven serial number.
ಇದೊಂದು ಪೆಂಡಿಂಗ್ ಬ್ರಾಂಚ್ ಕೊಟ್ಬಿಟ್ಟು ಅವ್ರು ಕಂಪ್ಲೈ ಮಾಡ್ತಾರೆ, ಮಾಡಿಸಿದ್ಮೇಲೆ ತಂದ್ಕೊಡಿ ಅಂತ ಹೇಳಿ.
Court officer, sir.
So 57 days. 57.
ಪೆಂಡಿಂಗ್ ಬ್ರಾಂಚ್ಗೆ ಕಂಪ್ಲೈನ್ಸ್ ಮಾಡಕ್ಕೆ ಈಗ ನಾವು ಸ್ಕೂಟನಿ ಕೊಡ್ತೀವಲ್ಲ, ಹಂಗೆ ಪೆಂಡಿಂಗ್ ಬ್ರಾಂಚ್ ಕೊಡಿ ಅಂತ. ಕಂಪ್ಲೈ ಮಾಡಿದ್ರೆ ಕಂಪ್ಲೈನ್ಸ್ ಆಗಿದೆ ಅಂತ ನೋಟ್ ಹಾಕಿ ಕೊಡಕ್ಕೆ, ಇಲ್ಲ ಅಂದ್ರೆ ಇಲ್ಲ ಅಂತ ಕೊಡಕ್ಕೆ. ಬಾಸ್ ಅವರೇ 57 ಇದೆಯಲ್ಲ. ಯಾವುದು ಅಂದ್ರೆ ಎಷ್ಟೊಂದು ಅರ್ಜನ್ ಆಗಿದೆ ನಿಮ್ಗೆ. ನಿಮ್ದು ಎಷ್ಟು ಹೇಳ? ಇದೆ ಇದೆ. ಬಾಸ್ ಅವರೆಲ್ಲ ಸ್ಕೂಟನಿಗೆ ಹೋಗಿದೆ ಸರ್, ಇದೇ ತರ.
Court officer, sir. Serial number 68 ಇದೆಯಾ?
ಎಷ್ಟು?
Serial number 68.
ಇದೆ ಇದೆ.
Okay, sir. Thank you, sir.
ಹಾ 40 ಬಂದೇ ಇಲ್ಲ ಸರ್ ಪಾಸ್ವರ್ಡ್ ಯಾವುದು ಬರ್ಬೇಕು. ಯಾರ ಮುಂದೆ ಡಿಸ್ಪೋಸ್ ಆಗಿದೆ ಯಾರು ಹೇಳಿ? ನೀವು ಮಾಡ್ಬಿಟ್ಟಿವ ನಮಗ್ ಬೆಳಗ್ಗೆ ಎಲ್ಲ ತಕರಾರು, ರೆಕಾರ್ಡ್ ಎಲ್ಲ ತರಿಸಿ ವಾಪಸ್ಸು. ಶ್ರೀಧರ್ ಅದೊಂದು ರಿಜೆಕ್ಟೆಡ್ ಮೆಮೋ ಅವ್ರ ಕೈ ಕೊಟ್ಬಿಡಿ, ನಾಟ್ ರೆಸ್ಪಾನ್ಸ್. ನೋಡ್ಕೊಂಡು ಮೂವ್ ಮಾಡಪ್ಪ. ಎಷ್ಟು ಬ್ರಾಂಚ್ ಅಲ್ಲಿ ಎಷ್ಟು ಜನಕ್ಕೆ ತೊಂದರೆ ಗೊತ್ತಾ? ಇಂಡೆಕ್ಸ್, ಆಮೇಲೆ ಅದು ಡಿಗ್ರಿ ಬ್ರಾಂಚ್ ಎಲ್ಲ ಪಾಪ ಹುಡುಕಿ ಮೆಮೋ ಅಂದ ತಕ್ಷಣ ಎತ್ಕೊಂಡು ಓಡ್ ಬಂದು ಕೋರ್ಟ್ಗೆ ತಮ್ಮ ಅದ್ ನೋಡಿದ್ರೆ ಬೇರೆ ಸರ್. ಮಾಡ್ಬೇಕು ಮಾಡ್ ಅದೇ 24 ಆಗಿರೋದು ನಮ್ಮ ಮುಂದೆ ಯಾಕೆ ಮೂವ್ ಮಾಡ್ತಾರೆ ಅಂತ ನಮಗೂ ಏನೋ ಇದ್ರು ಇರ್ಬೋದೇನೋ, ನಾವು ಕುಂತಿದ್ವೇನೋ ಅಂತ ನಾವು. ಅದೊಂದು ಮಗ್ದುಮ್ ಸಾಹೇಬ್ರದ್ದು ರಿಜೆಕ್ಟೆಡ್ ನಾವು ರಿಜಿಸ್ಟ್ರಿ ಫೈಲ್ ಮಾಡಿ ಸರ್, ಆಗೋಯ್ತು. 42 ಮುಂದಕ್ಕೆ ಕೊಟ್ಟೋಗಿತ್ತು, ಈಗ ಆರ್ಡರ್ ಆಗ್ಬೇಕು. ರೆಕಾರ್ಡು ಇಲ್ಲ, ಸ್ಟೆನೋಗ್ರಾಫರು ಇಲ್ಲ, ಮಾಡಿ. ನಿಮ್ದು ಯಾವ್ದಪ್ಪ ಆ ಥರ ನಾನು ಹೇಳಕ್ಕಾಗಲ್ಲ. ಎಷ್ಟೊಂದು ಜನ ಮೂವ್ ಮಾಡಿದ್ರು. ನಿಮ್ ನಂಬರ್ ಕೊಟ್ರೆ ಹೌದು ಗೊತ್ತಿಲ್ಲ, ನೀವ್ ಹೇಳಿದ್ರೆ ಆ ನಂಬರ್ ತೆಗೆದು ನಾವು ನೋಡ್ಬೋದು. ಹಾ ಅದೇ ಬೇಡ, ಅವ್ರ ಕೈಗೆ ಕೊಟ್ಬಿಟ್ಟು ನಿಮ್ ಪರವಾಗಿ ಅದ್ರ ಕಾಪಿ ಎಲ್ಲ ಎನ್ಕ್ಲೋಸ್ ಮಾಡಿದೀವಿ ನಾವೇ. ಅವ್ರ ಮುಂದೆ ಮೂವ್ ಮಾಡ್ತೀವಿ. ಹಾ ನೋಡಿ ಮೆಮೊ ಬುಕ್ ತಗೊಂಡು ಆ ಥರ ಹಂಗೆ ಹೇಳಿದ್ರೆ ಮೆಮೊ ಬುಕ್ ಕೊಟ್ರೆ ನಿಮಗೂ ಕನ್ಫರ್ಮ್. ಮೆಮೊ ಬುಕ್ ಕೊಡಪ್ಪ ಅವ್ರು. ಇದ್ಯಾವುದು ನಿಮ್ಮ ಹತ್ರನೇ ಇರ್ಲಿ. ಮೆಮೊ ಬಂದಿಲ್ಲ ಅಂದ್ರೆ 4:15 ಕೊಟ್ಟು ಕಳಿಸಿ ಏನ. ಸರಿ ಹ್ಞೂ ಸರಿ ಆಯ್ತು. ಯಾರಿಗಾಗಿರೋದು ಇದು ಕಳಿಸ್ಬಿಡಿ, ಅವ್ರ ಹತ್ರ ಆದ್ರೆ ತಗೋಬೋದು. ಸರಿಯಲ್ಲ ಸರ್, ಅರ್ಜೆನ್ಸಿ ಇದ್ರೆ ಮಾತ್ರ ಮೆಮೊ ಮೂವ್ ಮಾಡ್ಬೇಕು. ಪ್ರೊಸೀಜರ್ ಚೇಂಜ್ ಆಗಿದೆ. ಅರ್ಜೆನ್ಸಿ ಇದ್ರೆ ಆ ಕೋರ್ಟಲ್ಲೇ ಕೇಳ್ತಾರೆ. ನಮ್ಮ ಜ್ಯೂರಿಸ್ಟಿಕ್ಷನ್ ಬರೋದು ಮೆಮೊ ಮೂವ್ ಮಾಡಿದ್ರೆ ಮಾತ್ರ. ಇಷ್ಟೊಂದು blank paper ಇದು 226 ಅಲ್ಲ 227 ಅಲ್ಲ ಇದು 226 ಅಲ್ಲ ನಮಗೆ 227 ಇದಿದೆ ಇದು ಹಿಂಗಿದ್ರೆ 227 ಸಾರಿ 6 ಇಲ್ಲ ಅದು ಬೆಳಗಿನ ತಗೋ ಬೇಡ ಇಲ್ಲ ಥ್ಯಾಂಕ್ ಯು ನಿಮ್ಮ ಹತ್ರ ಒಂದು ಇರುತ್ತಲ್ವಾ
Yes. ಕೊಡಿ.
Serial number 76.
76. Yes. 76. Await service of notice. Interim order extended.
Serial number 62, my lord. Adjournment. Senior is unwell.
You are appearing for?
Petitioner, my lord.
Have you informed other side?
Yes, sir. We have informed.
You have informed?
62.
62 you have informed?
I will inform, sir.
No, you informed and mentioned, madam.
I've asked my colleague to inform. Will inform again, my lords.
Yes, at the request of counsel, learned counsel for the petitioner submits that arguing counsel is not well. Leave this matter. When do you want?
Any date, my next week, any date.
Leave this matter on 27th. Interim order granted earlier is extended till next date of year.
Serial number
Grateful.
72, my lord.
70?
72.
Yes.
That
Awaiting service of
have
notice.
not yet been served, my lord.
Yes. Huh?
Therefore, 7 to 10.
No, what you want? You have any objection? Yes. Awaiting service of notice to R1 to R5. Interim order extended till next. Yes.
Your Lordship, serial number 73.
Yes.
Your Lordship, the petitioner has already taken adjournment in the morning. I appear for respond number 1 and 3. There is urgency in the matter, Your Lordship. A date may be fixed.
No, there is nobody has filed in a wakalat, Mister. 1 and 3.
No, today we have filed memo of appearance, Your Lordships, in the counter. Since
No, memo for appearance is not permitted, Mister. Here you have to
a
file
date may be
wakalat.
fixed, Your Lordships.
Yavatti hogide. Avoid service of notice. You file in a wakalat, then move that matter. Yes.
A date may be fixed, Your Lordships.
No, service is not completed, Mister. File in a wakalat, then you move that matter. Yes.
Serial number 1.
1.
Wherein they've challenged the new amendment of the order. They've gotten the stay on the operation of the amendment. Your Lordship, so that is the substantial question in our matter as well. So can you make the matter?
No, is it a same suit?
Your Lordship, there are two different suits. Our writ petition is also regarding the delay of filing written statement.
Yes.
So can you-
Now that has been stayed by that.
Yes. And
Now-
the next hearing date is 16/4.
Hmm.
So there the operation has been stayed, operation on the new amendments.
Hmm.
Our matter may kindly be connected to that matter.
No, if that issue has to be decided by that other court. Here we are not deciding that. Therefore, question of connecting is not there. Since that is stayed, then
Yes, Your Lordship, then let our matter be pending until the disposal of that
no, you are appearing for whom?
petitioner. I
Yes.
informed the same to the.
Yes, at the request of counsel for the petitioner, leave this matter next week. Let us. Yes. Yes.
That matter is listed on.
I3 ಅದಕ್ಕೂ ಇದಕ್ಕೂ ಸಂಬಂಧ ಇಲ್ಲ ಮೇಡಮ್. Don't worry that. Is there any interim order?
In our, yes,
Yes, interim order granted earlier is extended till next date of hearing. Yes. One not five. 105 for what? Rectification of the office objection. You have complained. The net counsel for the petitioner submits that.
104.
Yes, respondent submits that. Office objection is rectified. Office to verify and proceed. Yes, leave this matter on 16th. Yes. Yes.
Serial number 81. I appear for the petitioner, my lords. For 2 weeks.
81, yes.
Interim order.
What you want, mister?
I request for 2 weeks, sir.
Yes, awaiting service of notice to respondent. Interim order extended till next date of hearing.
Interim order maybe. Great.
My lord, serial number 71.
Yes, what you want?
71, Your Honor.
Hmm.
The other side, writ petitioner mentioned erroneously, I am for respondents. Respondent name, instead of mentioning Soma Sri Devi, Soma Devi he has mentioned. Actually, we came to know that before the trial court, he filed along with memo, interim stay. We have filed wakalat.
What you want, mister?
In this, I have filed for vacating the stay in this honor.
ಹೌದು ಇದೆ ಅಪ್ಲಿಕೇಶನ್ ಇದೆ ಏನಾಗಬೇಕು ಈಗ?
Interim stay has to be vacated, Your Honor.
Wait when the matter is called, mister. Your matter is not yet called.
Please.
Then wait, mister. Yes.
Continuation of list, serial number 48, Chokka Reddy, office objection, second time matter.
You are paid, yes.
Right, the suit for declaration.
Ranking of the parties to be numerically casted. No, yes.
Right, the suit for
Submission is
declaration and
accepted.
permanent injunction.
Office objection is overruled. Suit for?
Declaration permanent injunction, that is the suit property acquired by the husband of the plaintiff under the register sale in 1971. That property was not sold by the after the death of the husband of the plaintiff.
Yes.
That property was sold by the brother's wife of the purchaser. And
What is that application you have filed?
Application not to create third party rights, the defend number 9 and 10 are already entered the agreement in page number 134. That is on 9/4/21.
What has happened to that trial court?
That interim order was not granted, expert interim order was not granted. And matter was posted on 8/6/2026. And there
directed. not to alienate that suit scheduled property till next date of hearing. This order will not come in the way of the trial court to consider that application filed by the plaintiff under Order 39 Rule 1 and 2 in accordance with. Yes. Yes.
Serial number 49, yes, Venkateshwaran.
Yes. Office objection, Mr.
Court fees ಎಲ್ಲ ಕೊಟ್ಟಿದ್ದಕ್ಕ ಫೈಲ್ ಮಾಡಿ
Jurisdiction to be stated. Deficit court fee.
dispensation certificate copies
Provision of law has to be stated in the cost title.
these minor objections
Certified copies to be, you stay cannot be sought at a prior. There should be a supplied application, Mr. Stay.
no ಅದರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ
IA to be clarified at the prior. Stay cannot be sought at the prior.
my lord this suit is for not binding of his document number 4 illegal and non-mandatory provisions agreement was entered in 2015 by respondent number 2 ಇದು page number
No, that there are office objection, will pass over, you comply that. Yes.
okay
Pass over.
Serial number 50, Shilpa Shah for petitioner, B. Natesh Kumar.
Yes. What are the rest of it? IA challenging the single writ particular copy to be served to the caveator. Have you paid the court fee? How much paid court fee you have paid?
We have paid 200 rupees.
200.
Yes, my lord. And my lord, for this, I mean, I'm filing because my lord, there are two IA. IA 2 filed by the decree holder.
No, 200 rupees has paid.
Yes, my lord.
Yes. Yes, what is this matter?
Yes, my lord. Here, my lord, what has happened? Execution petition was, my lord, arbitral award was passed, and arbitral award was never served copy upon the judgment dater. It was not.
What is that arbitral award?
My lord, land was acquired under National Highways Act. It is National Highway Division, not NHI. National Highway Division, my lord, land was acquired. Award passed by SLO. Not being satisfied, respond number 1 challenge before arbitrator.
No, what is that enhancement?
Arbitrator enhanced the compensation, but my lord, right now I'm on something else, my lord. My lord, arbitrator enhanced the compensation. Arbitral award copy was never served upon the.
You are not a party before that arbitral.
No, I was a party, but copy was not. My lord, under the law, there is a requirement of serving copy,
Yes.
and there are several decisions that
what has happened after
it's
that?
from the date of receipt of the certified copy. Now what has happened? Lord, respond number 1 filed execution petition. Once execution petition filed, notice was sent to the NH division.
Yes.
When they received, then only they got to know that there is some arbitral award passed. Then they approached, I mean, they represented before district court Hassan.
You have challenged that.
Through, no, my lord. So that's why, that is what, my lord, we challenged. We challenged once we got to know, we took certified copy, we challenged. Now, as per our high court judgment, division bench judgment, that once it is, because they say this under Arbitration Act, after amendment, that you have to deposit amount and all this. But under the NH Act, there is a rule where they say only if it is not challenged, you have to deposit the amount. So our division bench judgment is that it is not to be, no amount is required to be deposited if arbitral award is under challenge. So now we challenge arbitral award, and same day I went personally to the Hassan court. I filed a petition, arbitration petition challenging arbitral award, and same day filed application for stay in execution, because that day it was listed. We filed execution, I mean application for stay. Now court has decided their IA for attachment of money from RBI, state government's account with RBI, from that to take the money attachment. And we had filed IA on 5th March. We filed IA just the day when we filed arbitration petition. We filed IA for stay on the ground that we have filed arbitration petition, and that's why there is a protection under the law.
No, that execution and that your appeal is in before the same court or different court?
No, same court, my lord. Same my lord, principal district judge Hassan. Both were before same court. And then when matter was taken up on that day, and we submitted before the court that we have filed the arbitration petition. She said it has not come to me. Fine. Matter was then posted to 7th March. So it was now then our arbitration petition kept pending. We had filed on 5th. There is a system, I mean, a procedure that they file, they feed in the system only next day. So 6th this was fed in the system, showing that filed on 6th.
Now what is that order passed by that?
Now we got order, and interestingly, order was passed on execution petition on 17th. Though we filed arbitration petition on 5th and 6th it was fed. It was, notice was issued in the arbitration petition on 18th. I request your lordship to look at the dates. 17th she is passing order, allowing IA of respondent number 1 and rejecting our IA for stay, holding that no arbitration petition has been filed, nothing else. It is not says that.
No, your application in that execution has filed for stay.
Stay. That was on 5th.
5th.
5th
You have
of
filed on
March.
5th. Yes.
Same day we filed, first we filed arbitration petition. Then when matter was taken up, it was IA for stay was filed for IA for stay.
Yes, I understood that.
Stay of
Yes,
execution.
yes. Now what is that order which has been
Yes, my lord.
attached?
My lord, I request your lordship to, my lord, it is annexure A, which is entire order sheet, which starts at page 28. I request your lordship to look at page, my lord, it starts at page 31, it's order on IA number 2 and order number.
Yes, where is that reasoning?
IA number 3, page 41. And I request your lordship to look at result starts at page 44.
Yes,
And I request your lordship to look at page 47.
yes.
This application is filed to stay further proceedings of this case by staying operation and execution of arbitral award dated so and so on the ground that the judgment dated number 1 and 3 have challenged the said award before this court. But no document has been produced along with this application because their procedure is that they don't give the acknowledgement. So we didn't have any acknowledgement that we filed, but it was in same court. She had all the opportunity to find out.
Yes, yes, I understood
Yes,
this one.
but no document has been produced along with this application. Further, as stated in para 6 of the sworn affidavit in the decision rendered in writ appeal number so and so, that is the division bench of our High Court. In the case between National Highway Authority of India versus so and so, the Honorable High Court of Karnataka held that the excess compensation amount determined by the arbitrator has to be deposited upon a particular eventuality if the award has not been challenged by either of the parties.
Yes.
If the said award is
this order
challenged,
passed when?
this order, Milo?
Yes, 17.
It's the 17th March.
17/3/26. When you have filed an arbitration petition?
On 5th of March.
5/3/26.
Yes. And I'm just.
Yes, now that, what is that award passed by that land acquisition officer? What is that amount?
But Milo, I'm just Milo coming to it.
No, I will come to that. First you tell me that, what is that amount?
Yes, Milo.
What is that admitted amount?
What is that? SLO passed award.
SLA pass. Yes.
SLO. Fixed 49. There were dry land and there were wetland.
Yes.
Dry land 49 rupees 42 paisa per square meter, and wetland 54 rupees 36 paisa.
What is that enhancement by that arbitrator?
Enhancement 3 times.
3 times.
Yes.
That one time which you have determined that you have paid.
We have paid this.
That you have.
Yes, that is
only
fine.
that.
There is no dispute.
Only that enhanced amount.
Enhanced amount. And my lord, memo of calculation. My lord, I'm coming to that little later.
Yes.
But memo of calculation filed by the respondent number 1.
Oh, now you have
has
received
not-
that admitted amount you have received. Special land acquisition officer has passed an award fixing some rate that you have not received. Then enhancement we'll see. We'll stay that. We'll stay. Don't attachment and all. Yes, heard. Issue notice. Stay of further proceedings in execution number 278 of 2025 pending in the file of Principal District and Session Judge. Which place? Hassan.
Yes, ma'am.
Hassan till next date of hearing. You are appearing for which respondent? R1. Special land acquisition officer who is appearing? Government or government?
No, that is formal party, my lord. Yes, government may be.
You know, government advocate
Yes,
is
please.
directed to take notice for R2. You file it in that counter.
And my lord, on 27th March, further order has been passed. My lord, when my lord, this caveat was avoided, my lord, that day.
Now, what is that order passed?
But that order is passed that IA so and so filed by order is the amount of rupees so and so, which they have, their memo of calculation is also wrong. We have also filed memo of calculation. Is attached out of principal deposit account of government of Karnataka, Bengaluru branch, RBI consolidated fund.
Now, so far
the
there
office
is
is directed to issue attachment accordingly with the direction to RBI to deposit the attached amount.
Now
So
that-
this also to be stated.
No, that there is a direction to attachment. They have not yet attached.
No.
Now I said that all further proceedings is stayed.
Yes, my lord, but my lord, then, my lord,
27.
Hmm.
my lord, 27, this order has been.
27, 326.
No, stay of further proceedings, it covers everything.
Yes, my lord, but still maybe clarified, my lord. 27, they have filed.
Attachment order possibly RBI varana.
Hmm.
Already passed varana.
What is that past? Now that,
Our principal deposit,
and also
government of Bengaluru, RBI consolidated.
stay of further proceedings and also order dated 25/4/2026.
My lord, it is in pursuant to order dated 17th March, which is under challenge. So
No, no,
on
that is
25th March, this order has been
No, I
passed. So
said
this also should be,
stay of further proceedings.
Yes, my lord.
Including order dated 25/4/2026.
Yes,
is
I'm highly
yes.
obliged. 20, my lord, 27th March, 25 is the next date. 27th March.
27th March.
Yes,
27th March 2026. Yes.
highly
Till
obliged.
next date.
My lord, there are 2 petitions have been listed. Third one, my lord, has not been listed, my lord, so that,
Why?
my lord, end of the list today, my lord.
Yes. Put it.
But identical, my lord, there are 3 identical.
Yes, give that memo. Yes, you are there in the caveator in that matter also.
Yes, my lord, and we have served caveat.
Posting tomorrow.
Yes, tomorrow. Tomorrow. Yes. Yes.
My lord, should not take any action in that matter then, my lord.
No, that, if it is a similar, why that tomorrow we'll have it to 4:30 only.
Yes,
You
my lord.
take,
I will-
give
I
a
will-
memo. We'll
yes,
be there. I will not allow to withdraw that amount. You argue many times. Now, award itself is under challenge. I don't know, very principal district judge, he has a power to see that whether it is filed it or not, it is filed under that 5. Interim order is granted when? 17th.
17th March.
17th.
We filed on 5th.
15 days, district judge can be called that records whether it is filed or not. It's in a public money. Like this order is passing. You argue, we'll hear. Therefore, see, only the question is that whether it is filed or not. If it is filed, then till the disposal of the appeal, there cannot be an execution.
My lord, 18th March, same judge has passed, I mean, issued
Yes,
notice
yes,
in
I have seen
the,
that.
notice in the arbitration petition, but kept it pending till that 17th order is passed, my lord. Obliged. That shows everything.
Says that your honor, you deposit the 50% of the compensation amount. I will ask the stay and I raise the.
No, but see, division bench, this court, the judgment which they are relying, on the other way, if you say, if it is challenged, they cannot deposit anything.
Yes.
That is what the judgment says. Yes, when they have understood this, why can't they have understood others also? Yes.
Highly obliged.
Yes, submission is accepted of subjection is over.
Serial number 51, Shilpa Shah.
Same, my lord.
Same order. Yes.
Office objection, third time matter. Serial number 52.
I seek 2 days time, my lord, may be taken up on Monday.
2 days time is granted to comply of subjection. Please.
Serial number 53, Geeta Devi MP.
For the petitioners, my lord.
What is that?
My lord, the IA is more than 1 IA. Hence, my lord, of separate court fees been paid, my lord, please. It's a common order, my lord. Other office objection has been cleared, my lord.
Yes. Submission is accepted, office subjection is overruled. Yes.
My lord, it's a defendant's appeal, my lord. The petitioner is challenging the order dated 2/3/2024, my lord, on IA number 9, my lord. My lord, what has happened is, my lord, the LRs, the plaintiff number 2 and 14 has been dead, my lord. There are no more. They filed an application to bring the LRs on record, my lord. They didn't appear before the court.
Who is that?
Plaintiff number 2 and 14, my lord, LRs.
No, plaintiff is dead.
Plaintiff number 2 and 14, my lord.
How many plaintiffs? Suit for partition?
No, my lord, it's for declaration, my lord.
No, how many plaintiffs were there?
Totally 14, my lord.
14 plaintiffs.
18, my lord. 18 plaintiffs.
Plaintiff number?
2 and 14, my lord.
Yes, dead.
Then, my lord, they filed an application to bring LRs on record.
Who filed?
Plaintiffs, my lord. Thereafter, my lord, the LRs were not ready to prosecute the case. Notice was served on them. They didn't appear before the court. Thereafter, again, they filed an application to transpose them as defendant number for additional defendants, my lord. My lord, the suit actually has to be abated against the plaintiff number 2 and 14, even when the notice was served.
No, that if some other plaintiffs are on the parties, it will not be abated.
Lord, even the
There is
LRs,
no,
even the LRs came, notice
no,
was
suit
served.
will not abate. Against them, it will abate.
Please, my lord, against them, the suit has to be abated, my lord. But here, my lord, again, the application has been allowed only on the ground that they filed in affidavit say even in the order, your lordship may take order on page number 15, my lord. Page number 19, my lord, the operative portion.
19.
Please, my lord. The finding is at 19, the operative portion is at 20, my lord. Para
Yes.
4, my lord.
Yes.
The LRs of plaintiff number 2 and 14 are not ready to prosecute the suit. As such, he wanted to transpose them as defendant since the suit for declaration, the presence of LRs number 2 and 14 is very much necessary. Lord, already the notice has been served on them, but they didn't prosecute the case, the LRs. Now, my lord, the other plaintiffs have filed an application to transpose them as additional defendants, my lord.
Who?
Other plaintiff, my lord.
No, that plaintiff number 2
and 14 LRs are not ready to prosecute the case, my lord. Notice was served on them.
ಆಯ್ತು ಅವ್ರು ಹೋದ್ರೆ ಇನ್ನು 13 ಜನ ಇದಾರಲ್ಲ ಅವರು.
My lord, my submission is only regards to the suit may be abated against the LRs of plaintiff number, sorry, to plaintiff number 2 and 14.
No, suit is plaintiff number 2 and 14 is, no, LRs has not been brought on record.
They brought on record, but they were not ready to prosecute the case, my lord. Notice was served on them.
No, have they brought on record?
Please.
They have
Please,
made as
that
a
is
party.
the IA, my lord. Your lordship may see at page 18. IA is
No, if they have brought on record to prosecute or not, it is left to them, mister. They cannot be.
Thereafter, my lord, again, application for transposing them as additional defendant has been allowed, my lord. That is my submission. I'm not regarding the bringing LRs of record, my lord. IA number 9, my lord.
Yes. Where is that order?
Your lordship may take next page, my lord. 20. Operative portion.
Impleaded as 24, impleaded at defendant number 4. What is that reason? The LRs of the 2 and 4 not ready.
That
to
reason is
prosecute
that
the suit.
para 4, my lord.
Wanted to transpose them as a defendant since it is a suit for declaration. The presence of the LRs of the 22 and 4 is very much necessary. Therefore, oh yes, it is permissible. Is it not permissible? They can be transposed.
My lord, my submission before your lordship is that when the
Instead
LRs
of they have been filed an application to implead as a respondent, they can be transposed unless they have objected.
Even they are not objected, my lord, they are not.
If they are not objected, they can be transposed.
My lord, even they are not prosecuting the case.
ಅದಕ್ಕೋಸ್ಕರನೇ ಅವ್ರು ಪ್ರಾಸಿಕ್ಯೂಟ್ ಮಾಡ್ತಿಲ್ಲ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಅವ್ರನ್ನ ಡಿಫೆಂಡೆಂಟ್ ಮಾಡಿದ್ದಾರೆ. Nothing wrong in that.
Lord, maybe taken up tomorrow, my lord. I'll.
Yes.
Office objection may be overruled, my lord.
Yes. Office objection is overruled. Leave this matter next week.
Office objection 4th time, serial number 54, Prasad PS.
Yes, what is that? Yes, court fee, office objection comply.
Court fee paid, my lord.
How much?
100 rupees paid.
No, each IAS you have to 100 rupees. Yes, when do you want?
7th.
Yes, leave this matter on 7th. Yes. Other office objection you comply on that day. Yes.
Hearing interlocutory application matter, serial number 55, Udita Ramesh, Banu Ravinder for petitioner, Maharaj Jain.
Yes.
Filed an application for vacating stay.
Yes.
It's a very short
Yes, what is
issue,
it?
my lord.
Yes.
There is a suit, my lord, which has been filed by us with respect to a partnership firm called
Yes.
Anukiran Enterprises.
Yes.
We were the partners to that partnership firm. There were 3 partners, my lord. If your lordship kindly takes the cause title
Yes.
of the suit at page 19.
Yes.
There was one, my lord, Sharda, my lord, got that? Page
Yes,
19.
yes, yes.
Sharda Katare, who, my lord, is passed away.
Yes.
The legal heirs are here. Then, my lord, the respondents are one Lakshmi Bai Katare,
Yes.
who is another partner.
Yes.
And then, my lord, another Lakshmi Bai Ganapati Katare. At number 2,
They are the defendants.
they are the defendants.
Yes.
The Lakshmi Bai Ganapati Katare has passed away.
Yes.
Lakshmi Bai M Katare is alive.
Yes.
And my mother has passed away.
Yes.
My wife and mother has passed away.
Yes.
The issue arose, my lord, with respect to certain properties of this partnership firm,
Yes.
which was acquired, my lord, and thereafter there's a proceeding pending in the civil court to determine as to who's entitled to the compensation. There also we have appeared.
Yes.
We then realized that the property of the partnership firm is sought to be taken over by the others
Yes.
who want to try and make it their own property and claim the entire compensation.
Yes.
But now the partnership is of the year 66.
Yes.
Therefore, my lord, the documents were not easily available.
Yes.
And therefore, we were able to procure a copy of a partnership deed, not at page 40. We filed an application under section 65 to lead secondary evidence.
Yes.
The document, my lord, which we wanted to produce
is, my lord, unfortunately not there in the writ petition.
Yes.
If your lordships be kind. That's what I'm saying. Since you have been kind enough, I'm asking
Yes.
the court to take the objection statement because, my lord, for some reason they had not produced the
Yes.
document before your lordships.
Yes.
But my learned friend, my lord, out of his kindness, has placed it on record.
Yes.
The document, my lord, your lordships will find, but he has not page numbered it and given it to us.
18, running page 18.
Is the
Subject to correction.
deed of partnership?
Deed of partnership. Andrallu illa, page number I'm guessing. 18. 18 ಇದೆ.
Yes, deed of partnership.
Deed of partnership.
Yes.
This, my lord, according to us, is the deed of partnership.
Yes.
But my lord may kindly say, I'll show straight away what the problem is. If my lord kindly comes to the 21, I think. This, my lord,
Yes.
is a typed copy
Yes.
of a document.
Yes.
If my lord kindly sees at the bottom,
Yes.
it is certified as a copy of the deed as available in our records and as filed with the income tax officer, assistant 8,
Yes.
Circle 2, Bangalore, for registration of the firm for assessment year 7071.
Yes.
And the chartered accountant has certified it.
Yes.
Therefore, my lord, this is not the original. It is not even a photocopy because photocopiers were not available at that point in time.
Yes.
And therefore, my lord, this is certified as a true copy. But in my respectful submission, I want to make a slightly different submission, my lord. Although our application is to treat it as secondary evidence, in my view, my lord, secondary evidence has to be established as a matter of oral evidence because oral evidence has to be laid on the document
Yes.
and it has to be established. I'm satisfied, my lord, if this application is treated as an application for production of the document because production and marking are two different things.
Yes.
It is only when the document is marked,
Yes.
is a question of whether it can be taken on record, stamping, all those questions can be gone into.
Yes.
Therefore, my lord, although my application is for treating it as secondary evidence,
Yes.
I'm satisfied, my lord, if this application is treated as an application of production of the document.
Yes.
And my lord, the court passed an order on production. And my lord, how it has, whether it has probative value, whether it is acceptable, not acceptable, is all a matter ultimately, my lord, at the time of marking of the document, which becomes relevant.
Now that your application is dismissed.
Yes.
Now we will say that we will permit it to file an application for production of additional documents. Let them consider in accordance with law.
Yes.
Without influencing any observation, let it be considered in accordance with law. Yes.
Provisions of CPC, my lords. There should be some provision. Production of doc. If your lordship
Or
sees the
18 to
order,
17.
order spells out the
Yes.
same document, 65 order is the same thing. Even if he produces, if it has not been able to mark.
Then it's okay.
Lords, the
Production
question
and
is-
marking are two different things.
No, I am also not saying it is maintainable. I will permit it to file an application if law permits. Let him file it.
Because now
You
the-
can object it.
Under the court's order, my lord, the order, court says it is a typed copy. It is not even a photocopy.
Can't
It
be,
is
there is
nobody,
no
somebody
photocopy.
says I have certified it. It is neither a copy from the original nor a photocopy. So somebody wants to produce it.
I can produce any document.
For production of documents, is it be certified?
No.
At least a photocopy, some document. My lord, this he says,
Yes.
this is not a partnership deed. Somebody says,
No, it can be created by anybody.
anybody, some CA sitting in Chennai says, I have seen it in the records. And he says, I have
He'll have
typed
to
it.
lead evidence to prove it.
No, I
He'll
am
have to
also
lead
not
evidence to prove
allowing
it.
that. I will say permit him to do it. You object it. Let us see whether that is such an application is before.
No, I only
But
want-
again, my lords, he can't come under 65 because already for marking it is already rejected.
Not for marking, this is for production.
No, that's why.
No,
my
then he
lord-
can't come and say, no,
Now, my learned friend can't say tomorrow after producing it, once it is allowed to be produced, that he will again mark it.
No,
I will
we are
mark
not
it.
allowing to produce. We'll say that let him file an application. Let the court decide.
No,
If
it's not
I say
that.
That's all.
produce,
No,
then
no.
next steps will be allowed for him to marking and all.
Marking, adukku
I just say this, Lord, under the law, I'll place the authorities before your lordship. Why I'm saying this?
Yes.
The courts have said there's no requirement to file an application for production of secondary evidence.
Yes.
The law is that you must produce the document and then you must, as a matter of oral evidence, prove the existence of the document, whether it's primary evidence or secondary evidence. So the lordship kindly see that judgment. Why I'm saying this is this is the reason.
Therefore, I'm not deciding all this.
No, I'm not asking your lordship to decide because my learned friend has raised this objection now. It becomes necessary for me to point out what the issue is.
Yes.
Please see para 6, my lord.
Yes.
A party to the proceedings is not expected to file any application requesting the court to permit him to lead secondary evidence. All that is expected of him is to step into the witness box and lead evidence setting out the circumstances under which he is unable to produce the primary evidence. If the court is satisfied from such evidence that a case is made out for production of secondary evidence, it can permit the party to adduce secondary evidence subject to section 63 and 65 of the Act. However, when such permission is granted to the court to the party by the court to lead secondary evidence, it is open to the opposite party to object to production of such secondary evidence, in which event the court has to mark the document subject to objections, decide the objections at the time of final disposal of the suit on merits. This is the procedure, which is why I said I'll make an application, produce it. At the time of marking, all the objections can be taken into consideration and then finally decided. That is the procedure prescribed by this honorable court.
Please see the judgments which we will produce, my lords. Now the Supreme Court judgments on 63, 65.
Yes.
We have given the synopsis only, my lords. The first judgment itself sets out the scope of secondary evidence and, my lords, we have culled out the relevant paras.
Yes.
Something to be treated as secondary evidence also should be something emanating from the original document.
Yes.
My lords, if my learned friend says, I will produce, it is for the court, that's all.
No,
But
no.
to say, mark it subject to objection, you can't.
No, that is.
Why?
That's
Lords,
the law.
that is
No,
a-
no, I'm not saying all this now. Now we will say that we'll dispose of.
My learned friend is in my
Marking
respectful submission is
subject to
wrong.
objections, my lords, I have not come.
That is.
Of course, it is marking subject to objection is the only way in which marking is done, except for two conditions.
Lords, then
When
we
there's
will
an
decide,
objection,
your lordships
One
can
minute.
decide this on merits itself. My learned friend says, I'll get it marked. Today the application has been rejected. His application under 63, 65. That can end there.
It couldn't have been.
We'll argue.
Secondary evidence is rejected. If the party
Primary.
wants to file it as an additional documents, if law permits, let him do it.
That's all.
That's what I say that.
No, of course, one thing I must clarify, my lord. Today, my learned friend is saying, I then can't mark it. If it is produced, I'll be entitled to mark it.
I'm not saying that you can't mark it. You can make a submission before the court, court will decide.
Decide.
Same law judgment you can produce before the court and decide, because that is not the issue before me.
No, I don't want, my lord, this order to come in the way
No, no,
of the
I'm-
court. This order, not your lordship's order, but the order that has been passed by the learned judge to come in the way of
I will
the.
say that
Yes.
deciding that application without influencing it in accordance with law. If law permits, you can do it.
That's all.
That of course we can do, my lord.
He will object it. Yes, there will. This writ petition. Petitioner called in question. Order dated
31/7/23.
31/7/2023, whereby application filed under section 65 of Evidence Act has been rejected. The net senior counsel appearing for the petitioner has submitted that the writ petition may be disposed of, permitting the petitioner to produce that document, file an application for production of additional documents. In view of the above, without expressing any opinion on the merit of the case, the writ petition is disposed of. If law permits, petitioner can file an application for production of additional documents. The trial court is directed to decide that application in accordance with law, without influencing any observation made in the impugn order. Yes.
Please.
Application.
All pending applications are disposed. Yeah. Serial number?
Serial number 55.
Yes, memo filed for retirement is allowed. Yes.
Serial number 56. Manjunath case for
Lord,
petitioner.
I am for
KV
the
Narasimha.
petitioner defendant, my lord.
Yes.
My lord,
Yes.
the admitted fact before your lordship is that the petitioner before your lordship are the defendants in the trial court.
Yes.
The respondent before your lordship is the plaintiff in that case.
Yes.
He filed a suit for permanent injunction
Yes.
against all the defendants. The defendants are none other than the brothers.
Yes.
That is an admitted fact. An admitted fact is further that I have filed my written statement admittedly on (25 to 2017).
Yes.
The issues were framed while filing the written statement on 25 to 2017 is an admitted fact. On filing 25 to 2007, I have also filed counterclaim along with my written statement. After filing my written statement, issues were framed, the evidence were recorded, and the matter was at the time of argument, when it is at the head turning stage, the plaintiff has come out with an application to permit him to file a written statement to my counterclaim after a gap of 6 years and 3 months. This is the admitted fact before your lordship. My lord will be pleased to find Order 8 Rules 6G provides for filing written statement to the counterclaim well within 30 days, or if the court permits, 120 days. May I just request your lordship to kindly permit me to read Order 8 Rule 6G.
Wait.
I think your lordship got
Rule.
Order 8 Rule 6G.
Yes, FG, yes.
Rules relating to written statement to apply. The rules relating to a written statement by a defendant shall apply to a written statement filed in answer to a counterclaim. So this is very, very clear before your lordship. That means to say, whatever the law contemplates to file written statement to the plaintiff also applies to the written statement to be filed for the counterclaim also.
In answer to the counterclaim. Yes.
My lord, here, admittedly, after the matter has reached the head turning stage.
Now, when you have filed a counterclaim?
I filed on the same date, on 25th February 2017, when I filed my written statement.
Where is that written statement?
Before your lordship, at page 32, ink page 32, at annexure E.
No, time limits for filing a written statement. Order 8.
No, I am in time, my lord. So far as my portion is concerned, I am not in.
No, mister. Now, when you have filed a counterclaim, his reply is written statement now.
Yes. He has to file.
I understood. Where is that time limits for filing a written statement? Order 8, Rule 6.
That's what it says. That's what I read. Order 6, Order 8, Rule 6G.
I 3 time limits Order 8, Rule 6.
120 days, if not 30 days.
I 3, which is the provision, mister? I know that.
That's what I said, below. Order 8, Rule 6G.
No, mister. Order 8, Rule 6G says that it has to be treated as written statement.
No. What it says, the same rule applied to written statement to be filed on counterclaim. Yes, my lord. The written statement has to be filed for counterclaim well before framing of issues. That is the position of law.
A rule
yes, your lordship will be, I am guided by the 2 judgments of the apex court. I'm sorry. Yes, I'm sorry. 2022 online Supreme Court cases 642. May I just pass on, my lord?
No, see, your counterclaim. He has to file a written statement.
Please.
Within 120 days.
Yes.
Adiyalli 120 days I want to rule. Rule 8, Order 8, Rule 6.
Order 8, Rule 6.
ಅದನ್ನ ಅವಾಗ್ಲಿಂದ ಹೇಳ್ತಾ ಇದೀನಿ ತೋರ್ಸಪ್ಪ ಅಂತ ಹೇಳಿದ್ರೆ ನನ್ನ ಜಡ್ಜ್ಮೆಂಟ್ ಓದಿ ಅದನ್ನ ಒಂದ್ಸರಿ.
My lord, ತಮ್ಮ ಹತ್ರದಲ್ಲ ಕೊಟ್ಟಿದ್ದೀನಿ
ಅಲ್ರಿ Order 8, Rule 6 ಓದ್ರಿ ಸ್ವಲ್ಪ.
Order 8, Rule 6. ಇದೆ ನೋಡಿ. Particulars of set off to be given in written statement. I think your lordship would please to find sub rule 3, I think. The rules relating to a written statement by a defendant apply to a written statement in answer to a claim of set off.
I judgment could, yes.
My lord, air online 2022 Supreme Court 642. One copy ಕೊಟ್ಟಿದ್ದೀನಿ ನೋಡಿ.
Yes.
My lord, in the head note itself, your lordship please to find. I think I marked it.
Yes.
Counterclaim filed although after nearly 13 years after filing of written statement, But before framing of issues, to avoid multiple proceedings and delay is permissible. Before framing of issues, you also will find. Here is a case where framing of issues have already been done. Parties have let in evidence. The matter has already gone for final argument, head-turning stage. At the stage, this application came to be filed after a gap of 6 years and 3 months. That's my case before your lordship.
Where is this application?
My lord, your lordship will please to find his application for permission at ink page 18, annexure B. And IN number 11 was filed by my learned friend at ink page 18, annexure B. Ali nodre, I have filed my objection to that annexure C.
ನಾವು ಮೇಲ್ಕಂಡ ಅರ್ಜಿ ಜೊತೆಗೆ ಪ್ರಮಾಣ ಪತ್ರ ಕೇಳಿರುವ ಕಾರಣಗಳಿಂದ ನ್ಯಾಯಾಲಯ ಇಮೇಲ್
Without asking for condonation of delay, the simple application came to be filed.
No, he is seeking
My lord,
file
may
a
make
return
one-
statement to the counterclaim.
My lord, may I make one submission, my lord. My learned friend is making submission that at the stage of arguments, my lord had filed a return statement, return statement to the counterclaim. My lord, I would correct it, my lord. It was at the stage of after chief examination of defendant number 2 to 5. My lord, at the stage of cross examination.
No,
of
when
2
the
to 5
counterclaim is made.
My lord, counterclaim was made, my lord, at the after completing the chief examination of
No.
plaintiff, my lord, it was filed on, my lord, 25 to 2017.
I'm sorry, let him not confuse. Your lordship will please to
It was,
find.
my lord, it was IA under section 151 filed, my lord, it was condoned and the return statement was taken on record. My lord, after, my lord, evidence was commenced. My lord,
Where
I'm
is that
sorry.
order sheet?
My lord, I have order sheet, my lord, I'll produce it. The
My lord-
entire order sheet has not been produced, my learned friend.
Kindly see the date of filing the application by different plaintiff annexure B, IN number 11 on 23/5/2023.
Where is that impugn order, Mr.
My lord, include at annexure A at page 11. At page 11.
Yes.
The learned judge doesn't even whisper about my filing my filing counter under order 8 rule 6G, which contemplates that the return statement, whatever the rules made available for filing return statement to the plaintiff, also made applicable to the return statement to be filed on counterclaim. Same rule is made applicable. So that being the case, learned judge has not even gone through my objection, my lord. Annexure C may kindly be seen in page 21.
You read that order.
Yes, my lord.
Yes, Mr. When that he has filed a return statement with counterclaim.
My lord, it was on
2017.
Yes. In 25 to 2017. Yes, my lord.
When
At
you have
para
filed
11.
objection now.
My lord, objection, my lord, it was filed on 25 to 2017.
25?
My lord, I produced the order sheet, my lord.
2017, he said after 6 years.
Yes, his application itself is before your lordship. Annexure C, annexure B.
Yes, my lord, 23/5/2023.
23.
Yes, my lord.
What you say about the delay of that, this thing?
My lord, what?
6 years.
My lord, with respect to it, my lord,
Yes, you have to file a return statement within 120 days.
my lord, that pertains to, my lord, the judgment which has been cited. My lord, I don't have the copy. Whatever my learned friend
Not
has.
judgment, Mr.
I understood. It was
Rule which is applicable to you when the plaintiff is filed. What is the rule applicable for return statement?
It applies
When
to.
counterclaim is claimed, same principle is applicable. That's what that. It is not that he has to file after that issues and all. That will not applicable. Only thing is that within 120 days you have to file it. Otherwise, you have to give a proper reason to satisfy the court. Is it that reason has been given? Nothing has been given by the trial court to allow your application.
My lord, my lord, with regard to, I don't have.
You verify that
I'll
judgment which he has.
produce a citation with respect to it, my lord, to consider it liberal.
Yes, at the request of counsel for the respondent. Read this matter of 2 weeks.
My lord, maybe a date may fix, my lord, will
27th, yes.
It not may kindly be extended, my lord.
Remand or extended till next date of it.
Oblige.
For 57, A. Chandrachud for petitioner, Manohar N.
Now for the respondent letter,
Yes.
I filed a suit before the trial court. Suit for injunction and declaration of the judgment is not binding on me. And my learned friend, the respondent has filed an application order 11.
Suit for?
Suit for injunction and declaration of the judgment. Earlier judgment is not binding on me.
Yes.
The defendants have filed an application and.
ಆಯ್ತು ಅವ್ರದ್ದು petition ಅಲ್ಲ, you argue.
ಅಲ್ಲ, ಅದು vacating stay.
ಆಯ್ತು, ಇದ್ರಲ್ಲಿ ಏನು?
Please.
What, nothing is there in that GMCPC for hearing once and off. Yes.
Please.
What is?
The suit filed by the plaintiffs for their injunction was earlier instituted in OS number 1370 of 2007, Your Lordship.
2007.
2007. Your
Filed by,
Lordship,
filed by whom?
filed by the son of the plaintiff.
For what?
Same injunction.
Yes.
Declaration and injunction. Your Lordship is pleased to take annexure F, page number 57.
Yes.
Mahesh, son of Venkatappa. Venkatappa is the brother present plaintiff, Your Honor. Next page, Your Lordship will find what is the nature of the suit. Page number 58.
Yes.
This suit came to be dismissed, Your Honor.
Yes.
Against which RFA was preferred.
Yes.
RFA was dismissed. Later on, after all these particular things have attained finality,
Now, what is the declaration he has sought his son?
declare that the suit schedule property is the absolute owner.
Yes.
To that effect, if Your Lordship is pleased to take
No,
ink
it
page.
has been confirmed by that RFA. Now that father is filed.
Yes.
Now
My
what
Lord, I will injunction also is decided in that particular suit another care. If Your Lordship is pleased to take ink page number 61, one of the issues, ink page number 61, internal page number 5 of the judgment.
Yes.
Your Lordship finds issue number 1, Your Honor.
Yes.
Whether the plaintiff proves that the absolute owner and title in possession of the suit schedule property. Issue number 2, this is with regard to injunction, interference. Whether the plaintiff proves that interference of the defendant.
ಆಯ್ತು, ಎಲ್ಲ ನೆಗೆಟಿವ್ ಮಾಡಿದ್ದಾರೆ. ಆಯ್ತು.
ಎಲ್ಲ ನೆಗೆಟಿವ್ ಮಾಡಿದ್ದಾರೆ. ಇದಕ್ಕೆ to assist this, that section 11 is maintainable ಅನ್ನೋದಕ್ಕೆ.
ಅಲ್ಲ, ಆಯ್ತು, now what is that order you are challenging?
ಅಲ್ಲ, section 11 I had filed a section 11 application for res judicata.
Yes.
The suit is already decided between the same parties.
Now what is that order passed by the trial court?
Court has rejected that application.
Why?
ಅದ್ರ ಹಳೆ ಸೂಟ್ ನಲ್ಲಿ how this particular suit is covered under that judgment ಅನ್ನೋದಕ್ಕೆ may I draw your trouble your lordships to take to.
Whether court said that it is question of facts and law, it has to be tried.
ಆತರ ಏನು ಹೇಳಿಲ್ಲ.
Then they have decided that it's.
ಅಲ್ಲ, ಇಂಪ್ಯೂಂಡ್ ಆರ್ಡರ್ ನಲ್ಲೇನೆ ಸೆಕ್ಷನ್ 10 ಅಪ್ಲಿಕಬಲ್ ಆಗುತ್ತೆ ಅಂತ ಅವ್ರು ಹೇಳಿರೋದಕ್ಕೆ ಕೋರ್ಟ್ ಹೇಳಿರೋದಕ್ಕೆ ಪೇಜ್ ನಂಬರ್ 23 ಆಫ್ ದಿ ಪೇಪರ್ ಬುಕ್ ಮೇಲೆ.
ಆಯ್ತು, let him decide as an issue.
ಅಲ್ಲ, ಇಶ್ಯೂ ಅಲ್ಲ.
Court has dismissed that it doesn't.
This is the earlier suit was filed by my son without arraigning me. He is trying to establish that I am the owner of the property. It is absolutely, it is court has decided. So how can it possible? So accordingly, it is
my
dismissed.
contention is we are the purchasers of the
He was
property.
not at all.
58, Your Honor.
When I am the when I am alive, how can my son is try to file an suit for declaration of my ownership?
No, you are claiming ownership on basis of what?
His father.
My father's property.
There as a grandson.
Wait, mister. Now you are a father. I am asking you, mister.
Yes.
What is your title on that property?
I have a title of the. I have not filed an application. Now present suit, I filed injunction, and this judgment is not binding on me. That's it.
No, that now the suit for injunction.
Yes.
Now that what is your title?
I have a title. My father's property.
Sources of title is.
Yes, my father, from my father.
By ancestral property.
Yes.
Now that what is the claim of your son?
My son has filed a suit for declaration of ownership.
No,
without my arrayed
I
party.
am asking that to seek any declaration, there should be some title on what basis he has claimed.
That's what is Malanda. It is absolutely court has decided. No, you are not a ownership. You are not established the ownership. So therefore, rightly he has rejected the suit.
No, ಅದು ಗೊತ್ತಾಯ್ತ್ರಿ.
ಹೌದು.
ಅವನ್ ಟೈಟಲ್ ನನಗೆ ಹೆಂಗ್ ಬಂತು ಪ್ರಾಪರ್ಟಿ ಅಂತ ಹೇಳಿದಾನೆ.
He has not said anything before the trial court.
ಅದನ್ನ ನಾನು
That
ತೋರಿಸ್ತೀನಿ.
is surprisingly, he has filed a suit without my made a party.
That
And,
how can be a res judicata
yes.
for him to file a
It is
suit for
not at all
injunction?
coming. That's my contention.
For injunction, he is seeking that I am in the possession of the
Yes.
property. That has to be decided.
That injunction is decided in the previous
No,
suit.
that should, his son is not in the position.
ಇವಾಗ ನಾನು I will just read out for your lordship's trouble what section 11 says.
Yes.
ಮತ್ತೆ impugned order ನಲ್ಲಿ ನೆನೆ where the court has admitted that it is res judicata attract ಆಗತ್ತೆ ಅಂತಾನು ಹೇಳಿದ್ದಾರೆ. May I trouble your lordship to take page number 23, my lord.
Yes. Yes.
ಕೆಳಗಡೆಯಿಂದ 9th line, my lord.
Yes.
ಕೆಳಗಡೆಯಿಂದ your lordship gets admittedly.
Yes.
Admittedly, in the case on hand also, plaintiff claims his title and possession under his father, Mutta and Naga.
Yes.
Even in OS number 1370 of 2007, plaintiff therein, who is the son of the plaintiff herein, was claiming title and possession under Mutta and Naga.
Yes.
Taking into consideration this aspect, definitely the principles of res judicata would apply. Court comes to the conclusion.
ಅಲ್ಲ, ಮುಂದೆ ಬನ್ನಿ.
Sir, ನಾನು ಮುಗಿಸ್ತೀನಿ ಇರಿ sir. Court has come to the conclusion, it applies.
No, is it the finding that properties is not belongs to the Mutta and Langa?
Yes.
That earlier suit.
Yes. ಅಲ್ಲ ಅವ್ರದ್ದೇನೇನೆ ನಮಗ್ ಮಾರ್ಬಿಟ್ಟಿದ್ದಾರೆ.
ಅದು ಬಿಟ್ರಿ earlier suit ಅಲ್ಲಿ that his son has claimed.
ಹೌದು.
See, we are acquiring the property through Mutta and Naga.
Yes.
The grant.
Is it that finding that Mutta and Naga has no title over the property? They
No.
have a
Yes.
title over
Yes.
the property.
Mutta and Naga have sold it to the present appellants before this honorable court by virtue of a document, registered document in the year 1958. So we have, by virtue of that 1958 document, we are in possession. It is completely developed.
No, but he is not seeking for a declaration.
Injunction is also decided, anta is my question.
Injunction is for his son.
Yes.
You can take a defense saying that
Yes.
unless he has no title, he cannot seek for an
Yes.
injunction. That is for the merit.
Yes.
To rejecting the suit will not come.
Lord,
Judicata will not be applicable.
Okay, but
I will just next read out the
Don't
court.
have any title, cannot entitle for an injunction. Because Mutta and Naga himself has sold to you. He claiming under them.
The lordship is title follows possession.
Yes, that is for you to argue in that main matter. Can it be rejected on res judicata?
Yes, my lord. Res judicata ಹೆಂಗ್ attract ಆಗುತ್ತೆ ಅನ್ನೋದನ್ನೇ I am just showing. Next page, ink page number 24.
Yes.
ಅಲ್ಲ, but
Of course,
Yes.
of course, as discussed, ಕೆಳಗಡೆಯಿಂದ ತಿರ್ಗಾ 9ನೇ line. Of course, your lordship gets that.
ಯಾವ್ದ್ರಲ್ಲಿ?
Page number 24 ನಲ್ಲಿ.
Yes. No, you continue that reading there.
Yes, my lord.
Res
ನಾನು ಓದೇ
judicata
ಬಿಡ್ತೀನಿ.
applies, but the main objection of.
But the main objection of the plaintiff herein that when he is alive, his son cannot file. ಇದೊಂದೇ ಅವ್ರ contention ಇರೋದು. His son cannot file as he is not inherited the property during his lifetime. In this aspect, it requires full-fledged trial. The said aspect cannot be decided without full-fledged trial. The judgment relied by the learned counsel for the plaintiff, Santosh Kumar sir referred, Supra.
No, they said it requires for an issue to be framed and decided by that evidence. It is not threshold rejected, Mr.
ಅದಕ್ಕೆ may I trouble your lordship to take CPC, my lord.
Yes. No, you take the judgment even in respect of res judicata. It can be an issue. It cannot be decided for rejection of the plaint.
ಅಲ್ಲ rejection of the plaint ಅಂತಂದ್ರೆ res judicata is where
ನೀವು-
when res judicata applies if there is a bar.
No, see, therefore, when you raise then a res judicata, it will be an issue.
maybe
Party
for-
has to be adduced that evidence. Court has to see that whether earlier petition pleadings and the present is the same. It amounts to res judicata. It cannot be threshold rejected.
May I read section 11 and leave it at that, my lord.
Yes.
I will read section 11 and leave it to your lordships to decide.
No, that is section 11. There is no dispute.
ಅದನ್ನೇ ನಾನು ಹೇಳ್ತಾ ಇರೋದು ಇಲ್ಲಿ
Can
up to high court it is decided.
No, can that suit be dismissed
Yes, my lord.
without trial on that issue?
Yes, when the
Give that judgment.
ಅಲ್ಲ issue judgment ಏಂತಕ್ಕೆ CPC says.
What it says?
May I read section 11, my lord?
Yes.
If an identical issue is already decided between the same parties and with respect to the same property,
Yes.
wasting of precious time by virtue of when it is decided up to high court. High court ವರ್ಗೂ ಬಂದಿದ್ದಾರೆ.
Yes.
High court ವರ್ಗೂ it is a settled principle.
Yes.
Now, section 11.
Yes.
No court shall try any suit or issue in which matter directly and substantially in issue has been directly and substantially in issue in a former suit between the same parties or between, this I will emphasize,
Yes.
or between parties under whom they or any of them claim litigating under the same title. ಇಲ್ಲಿ ನಾಗ ಮತ್ತೆ ಮುತ್ತ ಒರಿಜಿನಲ್ ಓನರ್,
Yes.
ಅಲ್ಲಿ ಮೊಮ್ಮಗ ಮಹೇಶ had come.
Yes.
He loses his right up to High Court. Now if the father cannot erupt and say injunction has to be granted to me. That is why I said section 11 squarely applies. I don't need a judgment to sustain myself, Your Honor. CPC is very clear.
No, Mr. This facts has to be decided.
I will leave it to your
Threshold
lordship.
or this thing.
I will leave it to your lordship, man.
Yes, thoroughly. Thoroughly. In this writ petition,
My only submission,
you are clear that you are leave it to me, don't argue further.
my lord,
Yes.
that was not my words, my lord.
I said there are a judgment saying that if it is a mixed question of facts in that res judicata also, it has to be tried as an issue. You given a judgment, you said that section.
No, no,
itself is
I
clear.
will just assist.
That section itself clear.
I will
Answer.
assist, my lord. I will assist with the
Answer
proper.
that.
I will assist.
Yes. When do you want? Don't say that I will answer. If you want, I will answer that. No,
I was not on that intention, my lord.
See, I have also come across, I think he is not assisting. I know that. He has not brought any judgment also. There may be a judgment. Either it has to be tried as a preliminary issue because question of facts will be involved. Threshold cannot be dismissed.
Why I did not bring any judgment was, as per my understanding, CPC was very clear.
What CPC says, it can be dismissed. It says that it is not maintainable.
Rejected anta ಹೇಳುತ್ತೆ.
Then it has to be decided by the court whether it is a res judicata has to be decided by the court.
ಅಲ್ಲ rejected
Just-
ಅಂತ.
No, they have to see whether that same issue, same party, same land issue has been decided by the trial court. That has to be decided.
ನಾನು ಅದಕ್ಕೆ ಆ ಜಡ್ಜ್ಮೆಂಟ್ ತಮ್ಮ ಕೊಟ್ಟೆ ನಾನು ಹಾಕಿದ್ದೀನಿ.
You see that judgment is there.
ನಾನು
Otherwise, if
come
you
back.
say, leave it to me, I will pass an order.
ಇಲ್ಲ ಇಲ್ಲ.
Yes.
That was not my intention of expression, my lord.
Yes,
My
yes.
question was that why I did not come back with judgments was,
Lawyers has to be assisted the court. You have to be decide, but if you leave it to me, I am the judge, I will not bother, I know how to decide also. Yes,
my intention,
yes, we'll see that. No, in fact, he has to come and say that this is the judgment. By silence itself shows that he has no answer, but my order should not be wrong, therefore I said that.
I will assist your lordship. I'll leave citations on your lordship which can be considered.
Yes. When do you want? When do you want?
23rd or 24th.
Yes, 23rd.
Cell number 58, Varun S. for petitioner, connected matter, Swaroop S.
My lords, I appear for the petitioner. I appear for the petitioner, my lords, in these matters. My lords, I have received a copy of the vacate stay application, my lords. I intend to place a few citations for my lords' kind reference on this issue, my lords. The issue raised by in this present matter, my lords, is as to whether deposits given by a family member to a family business, does it qualify as commercial dispute to bring it within jurisdiction of commercial courts, my lords? 7 Rule 10 came to be rejected, my lords. Thereafter, my lords were pleased to grant a stay of the proceedings. Of course, my lords, only after a period of 1 year, the respondents.
Yes, what is your matter, Mr.? Yes.
Please, my lords. Present matter, my lords, the suit relates to a recovery suit filed by the plaintiffs, wherein they are seeking recovery of certain deposits that have been sent to a family, lent to a family business, my lords. They are, their case is that this family loan lent to a family business constitutes a commercial suit for recovery of money, my lords.
Yes, what is that
May I
order
make
you are
one
challenging?
submission, my lords, if my lords are kindly. My lords, in
Yes,
this matter, my lords, there is a stay in operation. Please, my lords.
Yes, yes.
Yeah, the
No, when
impugned
stay
order, my lords,
operating, you-
I'll just point out, of course, may I also please. Please, my lords, all I'm seeking, my lords, is vacate stay have been served with a copy. I intend to place some judgments for my lords' kind reference. Various high courts have also placed past judgments in this regard.
For
my
over
lords.
1 year,
May
this
please
case in
be-
operation. It's a commercial
may-
suit. Suit is of the
They have only moved it now in end of February, my lords.
No,
I-
let us see. Let us see.
Certainly, after
If it is required, I will grant the time. Let us see that if he is assisted properly, then it's not necessary. Yes, what
Kindly,
is it?
my lords, the reliefs are at page number 28.
Yes.
This is a
No,
suit.
What is that application he has filed?
Application is at, my lords, page number 35, my lords. 7 Rule 10 application has been filed. The short point between the parties is that this is a family business.
Yes.
And as an HUF, I have invested certain amounts into the business.
No, yes, why he has wants to return the,
My lords, he's saying his contention is that the amounts which are deposited, that does not amount to a commercial transaction. Now, this is a business. The respondent number 1 is the entity to which I made the deposits. Now,
yes,
this
what are the transactions?
transactions, my lords, kindly see page number in the plaint, my lords, I've pointed out.
Yes.
For over a period of about 8 years, I made certain deposits of money.
Yes.
And certain amounts of interest were also paid earlier.
Yes.
After certain time, I was thrown out of the family
Yes.
business. I have come out and I filed a recovery suit against the partnership firm,
Yes.
to which I was formerly a partner.
Yes.
Then I've made deposits worth of about 60 lakhs, and
Yes.
I'm also claiming interest of about 34 lakhs.
Yes.
This is the sum and substance of my suit.
No, where is
The
that
short contention,
impugned order?
impugned order, my lords, is at page number 77. Relevant portion, your honors will find it at page .2, impugned order, internal page 30, because multiple IS were disposed on the same
Yes.
order.
Yes.
One small submission, my lords.
Yes.
These defendants who have filed the 7 Rule 10 application were impleaded subsequently. The defendant number 1 to 3 had already filed a similar application earlier. That application came to be rejected. That order had attained finality. After being impleaded, they filed a similar application. So the Honorable Court has in fact extracted, identical contentions were raised even by the defendant number 1 to 3. And the order has also been extracted. They have relied on certain citations. All
Yes,
has been
Mr.
answered.
Why it is not in a commercial dispute? Yes, Mr.
Please, my lords. My lords, in this present matter, please, my lords. May I seek that I be given question, my lords, be there. First, my lords, at next week, I'll explain
Monday.
Some broad decisions of the time.
Monday, Mr. Monday, there is no further adjournment. Yes.
One
Very
small
well,
submission on my part, my lords. I am okay to either contest the matter before the commercial court or before the regular court, my lords. The stay has come in the way because it's a recovery suit. I have no money.
No. Because of you consent, we can't say that it is a commercial. If
I
it is a
understand.
commercial
I
suit,
understand.
you have to be
Just to
decided.
cut the short point.
Yes. You argue that.
I absolutely am ready.
Otherwise,
Silence.
my order will be precedent to other cases. Also.
I understand.
Consent will not be taken.
I understand. Monday,
Yes.
lad.
May I
Monday,
seek
I'm ready.
Tuesday, subject to my lords,
Tuesday.
subject to my lords, convenience. I say Tuesday, my lords.
Interim order to be extended.
Yes, interim order extended. Yes.
Cell number 59, a Govindaraya Kamath for petitioner, Srinivasa.
Petitioner
Sorry.
is the plaintiff, my lord. In this
Yes,
case,
yes.
My lords, interim order may kindly be extended.
Yes, interim
I'm
order
sorry, my
extended.
lords. 58, my lords. I'm very sorry.
Yes, both.
Grateful, my lords.
57.
Grateful.
Yes. Yes, Mr.
my lord, ಇದರಲ್ಲಿ ಆಫೀಸ್
I'm
ಅಬ್ಜೆಕ್ಷನ್
grateful.
ಏನಂತ
I'm
ಹೇಳಿದ್ರೆ, again, my impleading application before the trial court was rejected. Therefore, I am before this court.
Yes.
ಅವ್ರ ಪಾರ್ಟಿ ಮಾಡಿಲ್ಲ ಅಂತೇಳಿ, that's the office objection they are saying before this court.
Whom we have not made a party.
The impleading proposed defendants ಇದಾರಲ್ಲ, ಅವ್ರಿಗೆ ಪಾರ್ಟಿ ನಂದು ಏನೇ ಅಲ್ಲೂ ಆಗಿಲ್ಲ. So I could not implead them before this honorable court.
Yes. What is this matter? Yes.
Yeah.
Ready.
The case of this petitioner, my lord, petitioner has filed a suit for declaration and possession in the year 2009.
Yes. You are the plaintiff.
I am the plaintiff, my lord.
Yes.
Page number 26, my lord, is the suit schedule property. Suit schedule.
Question.
26.
Yes.
26 also, me. Schedule A. 26.
Yes.
The plaint schedule says survey number 28/3
Yes.
is 1.2 acres.
Yes. Now that what is that order you are challenging?
ಇಲ್ಲ, ಒಂದೇ ಸ್ವಾಮಿ, 1.2 acres is the land.
Yes.
During the pendency,
Yes.
now come to page number 28, my lord.
Yes.
At the RTC. For the same schedule, now the holding of the third defendant
Yes.
is only 6.8 guntas.
Yes.
My suit schedule claim is 1.28 acres. He has alienated during the pendency. I wanted to implead them. That has been rejected. The person who purchased during the pendency of the suit, I am impleading them.
No, you have filed in a suit for
Possession and declaration.
declaration and possession.
Yeah, third
You are-
defendant alienates the property.
You are the owner of 2 acres, 1 acre.
1.28 acres.
1.2 acre.
ಹೌದು.
In that part of that property has been sold.
Yes, my lord. Now, if the suit is allowed, I am entitled only 6 guntas. The present holding. Remaining has been with the proposed defendants.
Why the trial court rejected?
They are already on record ಅಂತ ಹೇಳ್ತಾರೆ. They are not on record. I have produced the copy before this court.
Where is that impugn order?
Impugn order page number 45, my lord.
Yes.
Yeah. Adali, para number 11 ಅಲ್ಲಿ middle Swami. And that the proposed defendant number 4 is none other than the brother of third defendant who is also demised, and his LRs, namely defendant number 3A and 3E, are already on record.
No, that.
Therefore, the burden cast upon the plaintiff.
Defendant number 4 is none other than that brother. No, you want to implead defendant number 4.
Also.
He is dead now.
Also, yeah. During the pendency of my IA number 30, he passed away. That IA was not allowed. Therefore, I filed IA number 31 to propose defendants LR ತಗೊಂಡು ಬಂದೆ 31.
LRs ಯಾರು?
Proposed defendant 4 ದು LRs in 31.
No, LRs is 3A and 3E are the LRs.
No, 4 years. 4 was the proposed defendant in IA number 30. It was not allowed, pending ittu. ಆ stage ಅಲ್ಲಿ this proposed defendant number 4 passes away. Therefore, I filed one more IA to bring proposed defendant 4's LRs on record.
ಯಾರು ಅವರು LRs ಯಾರು ಅಂತ ಕೇಳ್ತಾರೆ.
There is wife and son.
No, they are already on records.
ಇಲ್ಲ.
ಮತ್ತೆ they said LRs, namely defendant number 3 and 3 are already on record.
No, they are not on record. That is wrong, sir.
3A, 3 are not that LRs of defendant.
No. 4 is entirely different.
Yes, Mr.
Page number 24.
24.
The second prior that received is declare that the sale be dated 16/5/1972 and 5/5/1967 executed by Ganvenkappa in favor of D2 and D3 are non less than void. Well, D2 and D3 must have contested the matter. The matter was at the stage of arguments. At that stage, he files an application. Now, please see what he states in the application.
Perpetual injunction whereby restraining that 1, 2, 3 from interfering into the plaintiff's peaceful possession. What to say about that injunction? Injunction is sought for entire extent. But the persons, see, you 2 and 3 is not in the possession of entire extent because part you have sold it. Where is that?
Page number 30, my lord, is the affidavit.
Yes. Yes.
Please see what they say, my lord. Paragraph number 2. Page number 30.
30.
Affidavit accompanying the application.
Yes.
What they say in para 2 is, I submit that the proposed defendant number 4 and 6 are brothers of defendant number 3, and proposed defendant number 5 and 7 are the spouse of proposed defendant number 4 and 6 respectively. I submit that the plaintiffs are the absolute owners of item number 3, so and so. The proposed defendants colluded with the revenue officers and have changed the car into their name. The plaintiffs came to know about 2 weeks ago, hence they are the necessary parties.
ನೀವೇನು ಅವ್ರು ಮಾರಿದ್ದಾರೆ ಅಂತ ಏನು ಹೇಳೇ ಇಲ್ಲಲ್ಲ ಇಲ್ಲಿ. Where is that pleading, Mr.
Page number 28 was furnished, my lord. RTC.
RTC ಆಯ್ತ್ರಿ.
ಅದು RTC ಹಾಕಿದ್ರು.
They have purchased that property.
And partition ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ ಸ್ವಾಮಿ. Brothers partition ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ.
Should be not in the pleading, Mr. Nothing is there in that pleading. How court can be expected? You know that you are that family members, you are that owner of the property. How court will know that, Mr. Nothing is there in the pleading. Therefore, court said that.
But this RTC was furnished, my lord. During the argument, it was highlighted. Written arguments hakila. So written during the arguments, it has been brought to the knowledge of the court by showing the RTC.
They are shown that they are in the possession.
Yes.
Consequently,
no, possession, injunction cannot be granted. See, they may say that you have an injunction only against you. There is no injunction against me. They will not. Again, he has to file one more suit.
Also.
No. Impleading, amendment, awalla to avoid multiplicity of proceedings. ಅದಕ್ಕೋಸ್ಕರ ಮತ್ತೊಂದು ಸೂಟ್ ಮಾಡಿ ಮತ್ತೊಬ್ರು ಜಡ್ಜ್ ಕೂತ್ಕೊಂಡು ಅದಕ್ಕೆ ಎವಿಡೆನ್ಸ್ ಮಾಡಿ ಇಂಪ್ಲೀಡಿಂಗ್ ನಥಿಂಗ್ ವಿಲ್ ಹ್ಯಾಪನ್. ಇಂಪ್ಲೀಡಿಂಗ್
I appear for D2A. My suit is stalled and hence my lord I have moved the application. Now again the impleading application applicants will have to be heard.
No, we have to say that we'll send it back to the trial court to reconsider that.
Yes, ma'am.
No, they must
Yes, ma'am.
and then file a better.
Yeah. We will file before the, let it be remanded, my lord.
No, we'll remand it. Then with the permission to produce additional document to show that. Yes, avaga ಅವ್ರನ್ನ ಅಲ್ಲಿ ಪಾರ್ಟಿ ಮಾಡಿದ್ರು. Otherwise I can't allow your application because they are not, who said that they cannot be made a party, mister? They should be party here. If you convince the court, I can allow that application here itself. ಹೊಸ ಅದು ಏನೇನೋ ರೂಲ್ ಮಾಡ್ಕೊಂತೀರಾ ನೀವು. Yes. In this writ petition, petitioner called in question, order dated 3/12/2024, passed by 24th Additional City Civil and Session Judge, Bangalore. ಏನಿದು ಆರ್ಬಿಟ್ರೇಷನ್ ಅಪೀಲ್ ಅಲ್ಲ, OI ಅಂತ ಹಾಕಿದಿರಲ್ಲ ಏನ್ ಮತ್ತೆ OS ರೀ, OI ಅಂತ ಆಗಿದೆಯಲ್ಲ, OS number 3158 of 2008, whereby application filed by the plaintiff under Order 1 Rule 10 or impleading proposed respondent has been rejected. Plaintiff has filed a suit for declaration. During the pendency of the suit, plaintiff has filed an application under Order 1 Rule 10(2) of CPC to implead proposed respondent as respondent number 4 to 7. Since the plaintiff has not produced any document to show that the proposed respondents are related to the litigation in OS number 3158 of 2009, the trial court has dismissed that application. Learned counsel appearing for the petitioner submitted that the plaintiff has sufficient material to show that the proposed respondent are in the possession of the property. There is revenue record stands in name. If this court grant one more opportunity, they will file a separate application with all necessary documents. In view of the above, the impugn order so and so is set aside. In view of the above writ petition is disposed of, reserving liberty to the petitioner plaintiff to file fresh application under Order 1 Rule 10(2) of CPC, enclosing all necessary documents. If such application is filed, trial court is directed to consider the same in accordance with law without influencing any observation made in the impugn order. Yes.
Much
All pending applications are disposed.
Sale number 60, Vivekananda as per
I appear for the petitioner, my lords.
Yes.
Lords, this application under Order 18 Rule 17 was rejected, my lords, where I had filed an application for recall of the witness, plaintiff witness W1, PW1, my lords. That was rejected. Lords, may kindly appreciate the suit for specific performance. Adrali Swami, if I may just submit, the suit, the agreement sought for specific performance is dated 4th August 2009, which is not registered. There is a prior agreement, my lords, and we deny the sale agreement which they want to seek for specific performance.
Yes.
My lords, prior to that, my lords, on 13/12/2002, my lords, there is an agreement in respect of 2 acres to 2 guntas, my lords.
Yes.
The agreement was for development of the property, and my lords, as per that agreement, I had agreed to sell the properties on his developing the property. That is plaintiff and the defendant number 2. They are in collusion with each other. I am the defendant number 1, my lords. They were supposed to develop the property and they were supposed to sell it for a minimum of 600 rupees, my lords. Ashte prashne irodu swami. The matter was posted for final hearing. At that point in time, they filed an application for recall, marked the document, that is 2002 agreement. They marked that agreement. Then I put questions regarding that properties which were sold less than 600 rupees. Or properties less than 600. Let's subsequently ask for production of documents. He produces only 3 documents where there are 15 documents. He says, the plaintiff says, I have paid 10 lakhs advance in 2009.
Yes.
That, and the sale agreement is dated 2000. It is my submission that I have not given him any consideration, and according to him, 2002 agreement is still in force in the cross-examination brought out. Raj, all that I've asked is, I be permitted, I have produced the document, certified copies to I have asked for recalling for cross-examination on this point. The Honorable Trial Court dismisses the application on the ground that there is nothing in my written statement to substantiate that defense. I cannot go beyond my written statement. My humble submission is that is the ground for dismissal. If I may, my submission is I have brought it out very clearly in my written statement. If I may just draw your lordship's attention to the written statement at page number 37, Milads.
Yes.
Milads, para 4, Milads,
Yes.
page number 38.
Yes.
The further allegations that on 19/12/2002, the first defendant entered into an agreement with the second defendant for the development and sale of the said property is a matter of record. The terms of the agreement of 2002 are not settled, and the plaintiff and the second defendant have committed various mischief and fraud based on the said registered agreement, and there is still dispute in regard to the settlement of the said agreement. The plaintiff and the second defendant are called upon to prove the said allegations. The plaintiff and the second defendant are the partners of the mischief in filing the suit and joining hands by making second defendant as a party to support this case. Para 5, the para 6, if I may directly draw.
Yes.
The allegations in para 3 of the plain that on 4/8/2009, the defendant and the plaintiff entered into an agreement of sale in respect of site number 4 of suit schedule property is hereby specifically denied. The plaintiff is put to strict proof of the existence of the subject site, the execution of the agreement, and the payment of the sale consideration in respect of the subject site and consideration agreed. The first defendant emphatically denied the execution of the agreement as alleged in para 3 of the plain. That's para 7, if I may draw your lordship's attention. Page 39.
Yes.
The allegation in para 3 that a sum of rupees 5 lakh was paid by the plaintiff to the defendant towards advance consideration in respect of suit schedule property is hereby specifically denied. The amount paid rupees 5 lakhs is nothing to do with the alleged transaction, and no amount was received as advance sale consideration of the schedule site by the defendant number 1. The allegations of further advance towards sale of schedule site is hereby emphatically denied. The said amount were not received towards the alleged sale transaction. The said amounts were paid towards the amount due and
Where is
payable
that-
by the
where
plaintiff.
is that impugned order?
Milads, the impugned order, Milads, is at page number 17, Milads. The relevant paragraph, Milads.
Para 9 would be.
Para 9, Milads.
Yes.
Yes, Milad, correct. However, as rightly averred by in the objections of plaintiff's side, absolutely there is no plea with regard to the aforesaid aspect in the written statement of defendant number 1 with regard to liability and responsibility of the parties under the development of the said above said sites as per development agreements. The defendant number 1 has filed his written statement by way of total denial, and absolutely no counterclaim is claimed by the defendant number 1 in respect of deficit sale price of above sites. But I'm not asking counterclaim. I'm telling the consideration that he claims to have been paid by me is not paid. It is towards the transaction relating to 2002. Hagaga, I'm cross-examining him on this point. So counterclaim prashne barala Swami.
See, you have already taken that contention
Yes, Milads.
that the evidence is already over. You could have cross-examined that first time
Illa
itself.
Swami, arguments main mail hodaga, they come and produce 2002 agreement, Milads. I cross-examine he recently, 2004 only Swami. He comes and produces 2002 agreement. It's an admitted document.
No.
I cross-examine him on that and
No,
I ask him
2000
question.
2002 agreement.
Yes, Milads.
What is that specific performance of the contract?
Specific performance, he's asking of 2009, Milads. 2
2009.
acres, 2 guntas, 2002 agreements.
There is no pleading in respect of 2002 in that plaintiff.
Ide Swami.
Plaintiff idea.
Plaintellu ide. Our affidavit ide, but he doesn't produce it. After the matter is posted for arguments on main,
Yes.
he comes and produces 2002 agreement. So I question him.
That application, that documents is accepted.
Yes, Milads, that document is accepted. He
Then-
produced.
Yes, Mr. Then he has an opportunity for
Sorry,
cross-examination.
there is it is a suit for specific performance of 2009 agreement.
Yes.
The written statement, the contention of the written statement is not in respect of 2002 agreement. There is something about 2002 agreement, it is stated. Yes, there is an agreement, 2002 agreement with regard to the development that we are supposed to develop it. We have developed it, and there was under the development agreement, there is a term with regard to the manner in which it has to be sold. We have sold it. That is completely different than that of 2009 agreement. He does not produce the 2009 agreement. I have produced the 2009 agreement along with my statement of objection. Kindly see that.
No, he wants to cross-examine in
No.
respect of 2002 agreement.
2002 agreement is not a matter in issue before the court.
No,
The
then-
issue before the court is only this. Kindly check the issues.
Now, why you have produced 2002 agreement then? In that arguments? Where is that documents he has produced?
He has produced and marked as exhibit.
Then
he has himself produced and marked it as exhibit.
when it has been marked?
It was marked recently, my lords. He recalled recently, marked it as exhibit,
then he
and
has
I
to-
cross-examined on that document, my lords. For further cross-examination, I want.
After I recalled him and produced the document, he has fully cross-examined him on
When?
13/12/2023. Kindly
13
see the order sheet.
13/12?
13/12/2023.
When he wants to further cross-examination?
He wants now, kindly see the application that has been filed.
When?
Now, application is filed on 29/2024, wherein he says that in the cross-examination, I have given some vague reply. That is the reason why I want him to be recalled. That court has said that, and he also says that with regard to the difference in price for which under the development agreement sites have been sold, on those things also I have to put a question. That is
2002 documents, pleadings and all is there earlier. You are cross-examined. He wants to further cross-examine it to fill up the lacuna.
No lacuna, my
yes,
lords.
that
My
is what
humble
he says in the application. We are
That's-
not may kindly see the application.
Yes.
That's the reason the court has said that. Court has in para number 9.
Yes.
This is what the court has said. In the absence of any specific plea that the plaintiff and the defendant had agreed to make good any loss in respect of site sold under price of 600 per square feet, defendant number 1 cannot be permitted to cross-examine PW1 on the said aspect, much less in respect of such sale deeds produced by him. Admittedly, the suit is for specific promise of the agreement
is
dated
not
2009.
Pleading
And
is
defendant
there.
number 1 cannot be permitted to go
Pleading-
beyond the scope of the written statement to cross-examine PW1.
Pleading is there.
Pleading is only with regard to the entering into agreement with regard 2002 agreement, development agreement. There is no other
No,
pleading with regard
Where is
to,
your application for recalling that?
please, my lord, that is
That's,
there at page number
Page number 55, my lords.
55. Kindly see the application. Affidavit is there at page number 56. I submit that the plaintiff has recalled himself and produced some documents and submitted himself for further evidence when the case was posted for arguments. At that point of time,
Is it that at the time of argument you have produced that?
yes, I have produced it at the time of argument. Full evidence of both the parties were completed. It is thereafter I recalled him and I recalled my witness and produced the document.
He
He has
not-
cross-examined.
Cross-examine
He
after
has
that.
cross-examined at 20, that is on
that's-
December 2023.
After
Yes.
allowing to produce, he has cross-examined.
Yes.
Then
And
what-
One day one
and
submissions.
here he says that, can you see the next sentence? At that point of time, plaintiff PW1 was cross-examined by my counsel. It is evident that the PW1 was evasively replying when questions were posed to him regarding the number of sites that were sold below 600 per square feet, and very evidently PW1 was avoiding answers on point of number of sites and were sold for price of rupees 600 per square feet. I submit that the details were subsequently sought by way of notice under Order 12 Rule 8.
Either he is avoiding answer ಅಂತಂದ್ರೆ you have to cross-examine then that search.
Then
After
and
that
there itself.
can you do
ಇಲ್ಲ
it?
ನಾನು ಡಾಕ್ಯುಮೆಂಟ್ಸ್ 12 ರೂಲ್ 8 ಅಲ್ಲಿ ಕೇಳಿದೀನಿ ಸ್ವಾಮಿ. ಅವರು
And-
4 ಡಾಕ್ಯುಮೆಂಟ್
and
ಪ್ರೊಡ್ಯೂಸ್
it is not-
ಮಾಡಿದ್ದಾರೆ. Then I
He has not put up the
copy
defense.
application. I am producing further. I have produced further documents
You'll
for the
automatically
purpose of
see.
cross-examining on those documents, which is a part of 2002 document. I seek for cross-examination. ಈಗ ಏನಾಗುತ್ತೆ ಸ್ವಾಮಿ? All these documents which are the sale deeds are properties where the property is sold less than 600 rupees. He is required to make good that 600 rupees. ಅದಕ್ಕೋಸ್ಕರ ಅವ್ರು ಕೊಟ್ಟಿರುವಂತದ್ದು ಅಮೌಂಟ್ ಸ್ವಾಮಿ 10 ಲಕ್ಷ ಅವರು. It has nothing to do with this.
No,
That
after,
becomes
after he has recalled that evidence,
ಹೌದು ಸ್ವಾಮಿ.
then you have cross-examined.
I have cross-examined.
When it is closed? That is on 13,
10,
12.
13/12/2023.
13/12/2023.
Then
That's-
29 to 2024, he has filed an application within 2 months.
No,
No, the
he
problem
filed the
is-
application after 9 months. After 9 months, he filed the application.
Order 12 rule 8
29,
ಹಾಕ್ತೀನಿ. Order 12 rule
2024.
8 ಹಾಕ್ತೀನಿ ಸ್ವಾಮಿ. I obtain certified copies. I file application for production of documents.
He produced document, Order 12 Rule 8 application, he files. 3-4 hearing dates after I filed the objection, 3-4 hearing dates.
But see,
After
when
that,
you
he withdraws it.
After
And then he
no,
makes
this
this
is
application.
all. See, after you have concluded that you have recalled it.
Yes.
You have produced that.
Yes.
After that, immediately he has to he has
He
to
has
cross-examine.
cross-examined him.
Cross-examine, but relevant documents he cannot get it. That she
No.
wants done.
No, in the, no.
If you allow to further cross-examination, what
Reason,
prejudicial cost?
Your Honor, kindly see, the defense that has been put forth by him in the written statement is only denial of 2009 agreement and receipt of the part consideration. Nothing else is stated about 2002 agreement, the difference in the value payable, etc. as by way of damages or anything. His case is mere denial of.
You have pleaded about the 2002 in the plaint.
In the plaint, I have stated about 2002.
Where is that?
That a copy of the plaint I have produced. It is produced at page number 27. Page number 27. Para 2. I have stated that first defendant was the owner in possession and enjoyment of the property bearing survey number 1/1 and 44, Chikkamaranahalli, village so and so, totally measuring 2 acres 12 guntas. On December 13, 2002, it had agreed into an agreement with the second defendant and the plaintiff for the sale of the said property unto them. Later on December.
What is your reply in that written statement in this?
That's my submission.
That is the reply, page number, para number
Swami,
4, what he has read. Para number 4, what he has read.
Para number 4, page number 38, Swami. The further allegations that 19/12/2002, the first defendant entered into an agreement with the second defendant for the development of the said property is a matter of record. The terms of the agreement of 2002 are not settled. Settlement in Agila, Swami. That is where, and the plaintiff and the second defendant have committed various mischief and fraud based on the said registered agreement, and there is still dispute in regard to the settlement of the said agreement. Lord, there is a clear position.
There, insofar as 2009 agreement is concerned, it is an independent contract between the parties. That is what I have stated before the court.
There are 2 agreements.
Yes.
He has denied both. He has made an allegation.
No, he has not denied both.
Yes.
He admitted 2002 agreement. He has denied only 2009 agreement.
No, he said
the specific performance is in respect of
committed various
2009.
mischief and fraud based upon the said registered agreement.
2002 agreement.
There is still dispute regarding that settlement of that said agreement. He has disputed also.
That may be. I have produced the copy of the agreement of 2002.
No, if it is allowed to cross-examine, it is not that new facts.
Your Lakshmi, kindly see the agreement that has been produced along with my statement of objections. 2009 agreement. It is totally an independent contract. It is no way connected with 2002 agreement.
Yes.
It was an independent contract entered into between the plaintiff and the defendant, that is the respondent before your lordship.
Yes.
Kindly see the agreement copy. I have produced page number 6.
Yes.
Nikhil
Now,
constructions
finding of the trial court that there is no pleading is not correct. There
Yes,
is a pleading.
there is no pleading insofar as the matter on which he would like to cross-examine me and recall the witness.
Yes.
In the application, what he says is, in the application, kindly see once again the application. He says that ಅದರೊಳಗೆ 600 rupeesಗಿಂತ ಕಮ್ಮಿಗೆ ಮಾರಾಟ ಮಾಡಿಬಿಟ್ಟಿದ್ದಾರೆ, ಅದರದ್ದು ಡಿಫರೆನ್ಸ್ amount ಎಲ್ಲ ನನಗೆ ಕೊಡಬೇಕಾಗಿತ್ತು, ಅದರ with regard to those details I would like to elicit. That is something different. That he has not produced, he has not filed any case suit insofar as that agreement is concerned. He has not sought for damages insofar that is concerned. There is no counterclaim in respect of that agreement. If there is any shortcoming in that agreement, he had to have made a separate claim with regard to that, either by making a separate counterclaim in this very suit. He has not filed any separate suit. This suit is only for specific promise of the present agreement, nothing else.
First defendant entered into an agreement with the development.
It is for that reason the court specifically says, kindly see next paragraph also. Further, the trial of this case already concluded and the matter was set down for arguments. Moreover, more than 12 years old, and at this stage application are allowed, it will amount to reopening of the trial of the case without justifiable reason. The previous sentence may kindly be seen. Much less the I cannot be permitted to cross-examine PW on the said aspect, much less in respect of such sale deeds produced by him. Admittedly, the suit is for specific performance of the agreement dated 4/9/2009, and the defendant number 1 cannot be permitted to go beyond the scope of the written statement to cross-examine PW1.
No, see,
there is no other
kindly
issue.
appreciate.
How it will helpful to you?
No,
It is
I
not
have
for specific
ಸೇಲ್
purpose.
ಅಗ್ರಿಮೆಂಟ್ ಕನ್ಸಿಡರೇಷನ್ ಕೊಡ್ತೀನಿ ಅಂತ ಹೇಳ್ತಾರೆ ಸ್ವಾಮಿ 10 ಲಕ್ಷ. ಈ 10 ಲಕ್ಷ ಕೊಡೋ ಪ್ರಶ್ನೆನೇ ಬರಲ್ಲ ಸ್ವಾಮಿ. ಮೈ ಹಂಬಲ್ ಸಬ್ಮಿಷನ್ ಇಸ್ ದಿಸ್. 10 lakhs I have not paid towards the 2009 agreement. That is a deficit which he is required to pay in respect of properties which are sold less than 600.
That on 4/8 he has entered into a contract with the defendant to purchase property so and so. Is on whether the
It's only
plaintiff
on
proved
these
that he
issues
was
evidence
always
has
been
been
a ready
ready.
and willing. No, now that what will be that benefit for you to proving that 2002?
Milaj, my humble submission is
It is
this.
only a specific performance. He has to prove that there is an agreement on 4/8/2009 and the payment, and whether is ready and willingness. How it will help us to Mr.
My humble submission is
This
he
is nothing
claims.
but-
Illa Swami, one nimisham.
Why?
Lordship may kindly appreciate. He says that this agreement, in fact, it is produced. It is very clearly brought out. Each site shall be sold at 600 rupees. If there is less than 600 rupees, he will make good for me. Milaj, I'm not making a counter claim. I'm not claiming that money. A sale consideration advance in 10 lakhs kottidini anta heltidare Swami, adu nanu kottilla. That payment, Milaj, that he was liable to pay by virtue of the fact that those properties are sold less than 600 rupees. There is no reason for me to pay the money. The Lordship may kindly appreciate.
No, see
So
how
he-
that transaction will helpful to you, Mr.
No, Swami Idralli, if I may just draw your Lordship's attention to the agreement of sale. Agreement of sale which he has marked as exhibit P48. Iವಾಗ recent ಆಗಿ mark ಮಾಡಿ Swami. Page number 44 ಅಲ್ಲಿ ಇದೆ Swami of the petition.
Where is that 2002 agreement?
2002 agreement is at page number 44, Milaj. Very clear where 600
44 ಅಲ್ಲಿ ಎಲ್ಲಿದೆ?
44 ಅಲ್ಲಿ Swami, agreement of sale. This agreement of sale, if your Lordship has got it.
This is between whom?
Between the plaintiff and defendant number 1, if I may submit. Defendant number 1 and defendant number 2. It is between all the three parties.
No, not all the three parties. There are only one party, Millard. The other party has not signed the agreement.
This is between that defendant number 1 and plaintiff.
Defendant number 1, defendant number 2 and plaintiff Swami. Your Lordship may kindly see page number 46.
That again 2009 one more agreement.
That is a fabricated document. My
I
humble
have filed
submission
it
is.
along with the statement of objections, my vacating stay application. I have produced the certified copy of it.
No, that there
Page-
is an agreement in 2002. Why again the 2009 one more agreement?
No.
Exactly, that question
is-
was posed.
1 minute. 2002 agreement, it is only for joint development. This agreement is for sale of one of the sites from therein,
No,
from the owner.
You read that 2002 agreement. It is for an agreement for sale. It is not joint development. See that annexure D.
It is a nomenclature as a agreement of sale.
Then where is the?
ಅದ್ರೊಳಗೆ none, it is not for sale of me, it is sale for third parties. That is what the, may just,
If I may just draw your Lordship's attention to page number 48 Swami. Adralli, now this agreement witnesseth as follows. Para 1. Bottom from paragraph 1, that the vendor shall sell and the purchaser shall purchase all that piece and parcel of the scheduled property duly converted from agricultural to residential use, being the scheduled property for a consideration of rupees 600 per every square feet of site area, free from all encumbrances, third party claims, list, lien and other claims of whatsoever nature, subject to the terms and conditions of the agreement. The purchaser has made payment of so and so. So if I may just draw your Lordship's attention to a scenario where the.
No, after this agreement,
Also.
then you are saying that 2009 agreement is a fabricated.
It is a fabricated document. I have not given him, he has not paid me 10 lakhs as he claims. Shortfall or Kortiro Swami. Adanna, he's saying as though he's given me advance.
Yes, Mr.
And I am required to cross-examine on this document
Agreement.
and the other document to
It
show
a
that this is the
subsequent
position.
agreement. It has been signed by him. In each and every page, there is a signature. And the consideration, what has been paid under this agreement is also mentioned. And the consideration has been paid by check.
He has denied this 2009.
Yes.
To prove that earlier there was an agreement, it is necessary for him to cross-examine.
No, 2000 agreement.
Then it will
No,
not cause any
what
prejudice to you.
specific
Yes.
performance of 2002 agreement is not filed. Suit is filed only for 2009 agreement, under which only one site is sought to be sold.
See, you have paid some money. You are claiming that that money is for 2009 agreement. He wants to show that it is for 2002
agreement.
No, that he has already cross-examined.
When you are paying that money.
No,
by
that he
cash
has
or a
already
check,
cross.
You will not mention on that it is on pursuant to that agreement. Unless there is any return. To prove that he wants to say that 2002 agreement is necessary.
This 2009 agreement may kindly be seen. It is not in respect of 2000.
Examination in respect of 2002 it will not cause any prejudice to you. Why do you worry? If
No,
it is-
ultimately, it is not 2002 agreement that is
Your
required.
case, the trial court is only held that the suit of is year 2012. We'll
No.
fix the date on that day without any taking in adjournment.
May I just make one submission. 2002 agreement is in respect of only a small portion, site measuring for
Even
site.
small, it is in respect of the part of the suit scheduled property. He wants to show that there is already an agreement in 2002. These are all the consideration. These are all the amount due that you have paid. For that you have created
No,
2009. And
this agreement separate consideration is fixed. This is for this site, the total consideration is 60,40,784.
Entire agreement itself.
Yes, entire agreement has to be read. Kindly see the agreement. It is the independent contract. It is not a subservient contract to.
The date on that day, you will has to be cross-examined and finish that evidence. Yes. Which is that next date it is fixed. It is only a PW1, you have to be cross-examined.
What?
Yes, Mr. Bhatt.
4th April. Sorry.
We'll fix on that day. Without taking any further adjournment, you have to cross-examine.
4th April, day after
Yes,
tomorrow.
on that day, your PW1 has to be present, Mr. Yes. In this writ petition, petitioner has called in question, order dated 28/11/2024, passed in OS number 5522 of 2012, on the file of 61st Additional City Civil and Session Judge, Bangalore, whereby IA number 20 and 21 filed by the defendant petitioner under order 18 rules
17.
ಅಲ್ಲ ಇದನ್ನ ಬೈ ವೇ ಆಫ್ ಕನ್ಸೆಷನ್ ಮಾಡಿಬಿಟ್ಟು ಟೈಮ್ ಫಿಕ್ಸ್ ಮಾಡಿ ವಿತಿನ್ ಟೈಮ್ ಮ್ಯಾಟರ್ ಮೇ ಬಿ ಡಿಸ್ಪೋಸ್ ಆಫ್.
Yes, yes. Now after evidence, it's an argument.
Only argument only.
Yes, yes.
That's the reason why within 3 months we can, matter can be
Yes,
disposed of.
IA has been rejected. Plaintiff has filed a suit for specific performance of the contract dated. What is the date?
Dated 4/8/2009, Swami.
4/8/2009. On the service of summons, defendant appeared through counsel and filed a return statement. The trial court has framed 4 issues on the basis of the pleadings. Thereafter, parties has adduced their evidence. The plaintiff has examined PW1. His evidence has been closed on 13/12/2023. Thereafter, 29/2/2024, the petitioner has filed an application IA number 2021 under order 18 rule 17 for further cross-examination of PW1 for recalling and further cross-examination of PW1. Since the defendant has pleaded in respect of agreement dated 2002, he wants to cross-examine in these aspects. Therefore, the trial court, without considering this aspect of the matter, error in dismissing that application. In the interest of justice, the writ petition is allowed. Order dated so and so is set aside, subject to condition. The petitioner IA filed under IA 2021. Yes, it is
2021.
allowed, subject to condition that on the next date of hearing, defendant petitioner, without taking any further adjournment, has to further cross-examine PW1. With that condition, writ petition is allowed. Order dated so and so is gone.
My humble submission.
PW1 is directed to
4th ಗಿದೆ Swami. I will be prepared. Probably if the ಯಾಕಂದ್ರೆ order ಅಲ್ಲಿ reach ಆಗಲ್ಲ. ಇಲ್ಲಿಂದ order reach ಆಗಲ್ಲ ಅಲ್ಲಿ.
ಬೇಡ ನೀವೇ ಇಬ್ರು.
We will orally make a submission and we'll go ahead.
4th witness will be present.
Yes, and the learned counsel appearing for the plaintiff has submitted that on next date of hearing on 4th, PW1 will be present. The defendant plaintiff is directed to cross-examine the PW1 without taking any further amendment, adjournment. With that observation, writ petition is disposed.
The matter may.
And the trial court is directed to Yes. Suit of his year
2011, my lord.
12.
Trial court is directed to dispose of the suit as expeditiously as possible, not later than 5 months from date of register of copy.
Please.
Yes.
Much obliged.
Application.
All pending applications are disposed.
Cell number 61, Vivek S for petitioner, Balagangadhar GS.
Yes. Yes, Mr.
This application under 6 Rule 17 came to be rejected, my lords. It was rejected primarily on the ground that it was filed belatedly, my lords. That's the only ground for rejection of the suit for permanent injunction.
Suit for permanent injunction. What is the stage when you have filed an application?
At the stage of
Arguments on
arguments, my
merits.
lords.
Arguments on merits.
Arguments on merits. Yes. What is the reason for delay, Mr.? Why you have filed belated stage? And what you want to amend?
Only they wanted to amend the prayer, my lords.
By
converting, by seeking the relief of declaration and possession, my lords.
Suit for?
Suit for permanent injunction.
Permanent injunction. Now you want to be converted as in a declaration.
Declaration
Why?
and
Why? What is the reason for?
and alternative relief of possession, my lords. Because defendants, they have denied the title of
Then
the
when they have denied your title?
in the written statement and during the course of
They have filed
cross-examination.
a written statement.
Written statement in the year 2014 itself, my lords.
2014. Then what are you doing for another 10 years to take the defense, Mr.?
But for just adjudication of the matter, this amendment
Mr.
is
It is
necessary, my
their
lords.
suit will allow with imposing the cost.
No, my lord, the problem is,
If it has proceedings, even you are denied, he has to file
my lord,
there may be a delay.
my lord, I am well aware that your lordship may kindly appreciate my arguments may be in amendment application limited. But here why I am opposing, my lord, the reason is denied. Kindly peruse, my lord, the additional written statement at Annexure D, page 35 filed by me.
Page 35.
35,000.
Yes.
My lord, plaintiff died.
Yes.
LRs were brought on record, my lord. And Annexure D, page 35 may kindly be perused.
Yes.
My lord, third line. LRs of the plaintiff number 1 has no right, title or
Page
position.
35.
35.
Annexure D.
D. ಅದರಲ್ಲಿ ತಾವು ಫಸ್ಟ್ ಪ್ಯಾರ ಅದರಲ್ಲಿ ಥರ್ಡ್ ಲೈನ್ ತಾವು
Third
ನೋಡ್ಬೋದು.
line. Yes.
LRs of the plaintiff number 1 has no right, title or possession of the suit property. My lord, date is in the year 2017. Now, my lord, this application is filed, my lord, after the conclusion of the, when it was posted for arguments, date is 18/12/24. The trial court, my lord, considered my objections and rejects, my lord, rightly relying upon the judgment of the Honorable Supreme Court in Revjit decision. My lord, where, my lord, it has been categorically held that, my lord, if it is barred by limitation, my lord, to avoid that aspect, my lord.
No,
Kindly,
that I think Supreme Court said
please,
application to be allowed,
please.
but that should be an issue has to be decided whether suit is barred or not.
No, my lord.
Rest all it
Here,
has to be
yes, here, your lordship may kindly appreciate.
Yes.
This was considered by the trial court, my lord.
2000.
In all the matters, my lord, the amendment is to be allowed. No, my lord, this is there. But the question here is, my lord, when it comes to, my lord, the my lord, head note,
Yes.
second line ಅಲ್ಲಿ ತಾವು ನೋಡೋದು para 63, 69 ಅಲ್ಲಿ.
No, that is true. If it is barred by
Yes.
limitation, it is not maintainable.
ಅಲ್ಲ ಇಲ್ಲಿ ಒಂದೇ ಒಂದು ಲೈನ್ ಸ್ವಾಮಿ. As a general rule, the court should decline amendments if a fresh suit on the amended claims would be barred by limitation on the date of application. ನಾನು ಅದಕ್ಕೆ ಪ್ರಾರ್ಥನೆ ಮಾಡಿದ್ದೆ. 17ರಲ್ಲಿ ಅದಕ್ಕೂ ಮುಂಚೆ ಡಿನೇ ಮಾಡಿದ್ವಿ. Now, my lord, the question is, my lord, 24 after a lapse of more than 10 years file ಆದ್ಮೇಲೆ ಹಾಕಿದ್ದಾರೆ. Now my prayer is this, my lord, may not survive for consideration.
Yes,
There may
what
be
you say about delay?
issue may be framed in that regard, my lords.
ಎಲ್ಲಿದೆ ಆ ತರ? ನಾನೇನೋ ಹೇಳ್ದೆ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ನೀವು ಸುಮ್ಮನೆ ಹೇಳ್ತಿದ್ರಿ. Where is that judgment on that point?
May be taken up tomorrow, my lords. I'll furnish the judgment.
You should be
judgment
ready,
on that
Mr.
point.
It is settled law that what is barred under that limitation cannot be made available by amendments.
But here, our suit for restoration of possession, my lords, limitation period is 12 years, my lords.
No, now it's declaration.
3 years.
By denying the title.
Even otherwise, my lord, one more I may be permitted to submit. Doctrine of relation back ಕೊಟ್ರುನು ಬರೋದಿಲ್ಲ. 85 ಅಲ್ಲಿ ನಾನು ಪೊಸಿಷನ್ ಬಂದಿದ್ದೀನಿ. My position is from 85. That is the document marked.
Yes.
Now, my lord, if 14 ನಲ್ಲಿ ಆದ್ಮೇಲೆ 17 ನಲ್ಲಿ ಡಿನೇ ಮಾಡಿದ್ದೀನಿ. Article 54 and may come.
ಅದೆಲ್ಲ ನಾನು ಒಂದು recent judgment ನೋಡ್ದಂಗಿದೆ.
Please.
What they say,
please,
if suit is barred, it should be an issue and Suit has to be dismissed after trial. I think it is not amendment ಅಂತ ಎಲ್ಲೋ ಇದು 2009 ಅದು 22 23 ಅಲ್ಲಿ ಎಲ್ಲ ಇದ್ದಂಗಿದೆ. Yes.
14.
Article 14.
Yes. Limitation.
It broadly says question of material fact and question of law.
Yes. That
My lord, if the court comes to a conclusion that by exercising powers under 711,
yes,
if my lord, the bar under law cannot be decided, because limitation would necessarily be, my lord, a question of fact and law.
Yes.
If court comes to such a conclusion that an ouster judgment cannot be given by exercising 711, then my lord, if an issue has to be framed, the law point will be dealt under that. Precisely, my lord, Article 17 deals, Article 14 deals with it.
Yes, same for amendment also.
But the problem for me is this, my lord.
Somewhere I think there are a judgment.
But ಅದು ರೇವಜಿತ್ ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ಅದೊಂದು ಪಾಯಿಂಟ್ ಹೇಳ್ತಾರೆ.
Time or not was a disputed question.
Yes.
Of facts, and therefore the prior of the amendment could not be rejected, and in that circumstance the issue of the limitation can be made as an issue in the suit itself. Please, that is what that.
True, my lord. Now my apprehension is this, my lord. If doctrine of relation back is applied in the specific case, my lord, I will be, may not be.
2003 itself is there.
ಇದು ಲೇಟೆಸ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ 2009 ರೇವಜಿತ್ ನಾನು ಕೊಟ್ಟಿದ್ದೀನಿ.
2001.
ನೇಚರ್ ಆಫ್ ದ ಸೂಟ್ ಚೇಂಜ್ ಆಗುತ್ತೆ ಅಂತ ಅಷ್ಟೇ ನನ್ನ ಪ್ರಾರ್ಥನೆ.
What is that nature of suit? Prior, no, when the injunction suit is,
they want to change it as a
title is denied. Law is that he has to file for a suit for,
yes,
because avoiding the multiplicity, he has to amend that line.
My lord, that amendment, it should be cautious, and my lord, if 2024 in the amendment relation back 14 go bitre,
Yes.
I may not be able to substantiate.
No. Limitation point will be there.
No, my lord. No, my lord, that will be a cakewalk because
Yes.
your lordship may kindly appreciate in another judgment, my lord, the Honorable Supreme Court held that, my lord,
Yes.
that is in Sampath Kumar's case, your lordship may kindly appreciate in the necessary amendment, if it is necessary, my lord, the doctrine of relation back may not be, it cannot be. Sir.
No, there are a judgment which says it cannot be decided on that point.
No, my lord. Doctrine of relation back, my prayer is this, my lord. Suit is of the year 14. If they convert the same into that aspect, virtually, my lord, section 3 of the Limitation Act and my defense will be out.
Producing 2009, it is 2008. Latest judgment is also there, we'll see.
Please. But here,
2024 or 22 ಇದೆ. 24 they said.
My lord.
Whether this judgment has been referred or not.
That I have to consider.
22 ಒಂದಿದೆ.
My lord, amendments, my lord, I know that, my lord, I may be tomorrow, I may be in the shoes of my learned friend. But only apprehension is, my lord, the rider may be put to this extent, my lord. From the date of application, it may be.
That's what that amendment will be.
Not from the date of suit.
Yes, that will make it clear.
ಅದನ್ನ ತಾವು ಕನ್ಸಿಡರ್ ಮಾಡಿದ್ರೆ ನಾನು ಐ ವಿಲ್ ಬಿ ಈಸಿ ಫಾರ್ ಮೀ ಫಾರ್ ಬಿಕಾಸ್ ಒಂದೇ ಸಾರಿ ಅವರು ಆರ್ಟಿಕಲ್ 58 54 ಎರಡು
allowing that amendment will come into that effect from the date of application is filed.
My lord, my objections may kindly be noted.
Will
please, because the parties.
Yes. In this writ petition, petitioner called in question, order dated 15th January 2025, passed on IA number 1 of 2024 in OS number 112 of 2014 by Civil Judge JMFC Koratigere, whereby IA number 1 of 2024 filed by the petitioner plaintiff under Order 6 Rule 17 is rejected. Plaintiff has filed a suit for bare injunction. On service of summons, defendant appear through counsel has filed a written statement. When they have filed a written statement?
20th-10-2014, my lord.
20th-10-2014.
Please.
After lapse of, and they have denied the title of the petitioner. After lapse of more than 10 years.
Please.
The application has been filed.
Fag end of the trial.
When that application is filed?
My lord, it is on
18/12/2024.
18/12/24.
18/12/2024 at the fag end of the proceedings, seeking an amendment of prior for declaration and possession.
The same came to be rejected. Learned counsel appearing for the respondent has submitted that. The amendment sought by the plaintiff for declaration is barred by limitation. Therefore, it cannot be allowed at this stage after lapse of 10 years. To substance his case, he is also relied on judgment of Apex Court in 2009-10 SEC 84. Learned counsel appearing for the petitioner has submitted that the amendment application can be allowed from the date of application has been filed, and limitation is concerned that may be considered as an issue of limitation can be made as an issue in the suit itself. Since the application is filed in the year 2024 on 18/12/2024 for amendment of the prior, that can be allowed subject to condition that amendment has to be treated from the date of application has been filed, that is on 18/12/2024, and also a trial court is directed to frame that issue in respect of issue of limitation. With that observation, the writ petition is allowed. The IA 1 of 2024 filed under Order 6 Rule 17 is allowed.
Somewhat it is volatile.
Delay prior, when that amendment would be enabled the court to point to consideration the dispute would be influenced. So when the amendment merely sought to be introduced in the additional or new approach without prejudice the time barred cause of action attempts will be made allowed. So the amendment sought for commencement of the court is known. So there is the suit no any of that we have said.
Please. My lord, am I permitted to file additional return statement?
Yes.
And, with regard to other as maintainability limitation, I may permitted to take defense.
Yes, our respondent is also permitted to file an additional return statement if required. Yes.
Necessary. This.
If necessary. Yes.
Necessary.
Permitted to file an additional return statement. Yes.
Limitation, my lord, from the date of application.
Yes, I said.
Please.
With that condition only it is allowed.
Yes, ma'am. That may kindly be observed in the final portion.
Yes.
Please.
Yeah, IA is allowed, subject to condition that application for amendment has been allowed from the date the application has been filed.
Much.
Yes. All pending applications are disposed of.
Please.
Dispensed.
Please.
Lord,
You go
till
through
number 62, my lord, without informing me, my lord, adjournment has been.
this judgment somewhere it is also there 2000. Yes, Mr.
Serial number 62, my lord, without informing me, adjournment has been taken. Some urgency is there. I have
Serial
filed
number?
maternity application, at least date may be given.
60?
62.
62 council and hospital sir. Hospital
Date, at least date may be given.
council is not well until but time.
Date may be, at least date. 27 long I tell, in early date.
Early date 23rd. Yes.
Please.
23rd. Yes.
Seal number 63, Vandana PL for petitioner.
Yes.
EA for vacating stay is filed, they have not filed objection to the application.
Yes.
And now please, my lord.
Could be disposed of. Lord, the
Please.
question is
Ready, I will.
Very, very short question.
very short
My
question,
lord.
Lord. May I just propose it?
Yes.
Lord, the executing court has issued a warrant of arrest and process against an individual. An individual, my lord, against whom there is an order of admission and a moratorium imposed by NCLT in an insolvency bankruptcy proceeding.
Yes.
Now, my lord, the law is very clear that your lordships may kindly see, my lord, the order of admission passed by the NCLT. May I just pass on, my lord, to the IBC? Kindly, my lord, see. Lord, before I take your lordships to the IBC, may I just take your lordships to, my lord, page number 40.
Yes.
Lord, precisely the order of admission is against Vasudevan Satyamurthy. Lord, against whom the process is issued.
Page.
Page, my lord, 40, it starts at.
No, what is the decree?
The decree, my lord, is payment for payment of certain, my lord, monies to the.
1 crore 83 lakhs. Now present payable is 2.4. No,
Let him complete. Yes. Where is that decree?
The my lord, decree is not there before the court because the question is as simple as this.
Yes.
I am not, my lord, opposing the decree. I am opposing only, my lord, the process issued against an individual against whom, my lord, in respect of whom there is an order of admission by the NCLT. Law prohibits any, my lord, legal proceedings against him cannot proceed. Kindly, my lord, see page number 40. This is the order of NCLT. The relevant portion, my lord, is on page number 41. Kindly, my lord, go to paragraph number 7. Paragraph number 6, my lord.
Page number?
Page number 41, 41.
Yes.
The interim moratorium
No,
under
that
section.
page 41, this is something else. City Civil Judge, Bangalore, then order. Annexure D.
Annexure D, my lord. Yes, precisely Annexure D.
No, which case you are referring?
My lord, I am referring to, my lord.
There are other cases also today. Now this is 190.
ಬೇರೆ ಮೂರು cases ಇದೆ ಅದು my lord that are not.
No, now that 19077 of 2025.
Please.
On that page 40, this is the
execution petition.
Execution petition.
Yes.
Now you seeing that page para 6, no para 6 here. Para 6.
Maybe, my lord, the page numbers, I apologize, my lord, the page numbers are perhaps varying. If your lordships may kindly have. I'm sorry, my lord. Yes, there are page numbers, variation of page numbers. My lords may kindly have this order of admission passed by the NCLT.
Yes.
Which is on page number 45.
Yes.
Hope your lordships are in it, well. Page number 45.
Yes.
Order of NCLT. Kindly go to, my lord, page number 46.
Yes.
Paragraph number 6. The interim moratorium under section 91 1A of the Insolvency and Bankruptcy Code 2016 has been commenced on the date of filing of this application by the financial creditor and will cease to have an effect on the date of admission. During such interim moratorium period, any legal action or any proceeding pending in respect of any debt shall be deemed to have been stayed, and the creditors of the debtor shall not initiate any legal action or proceedings in respect of any debt. The resolution professional is directed to serve a copy of this report on the personal guarantor. Now, my lords may kindly go to, my lord, section 101.
No, this dispute is not between.
In fact, that is where, my lord, even the learned, my lord, the trial judge has, my lord, mistaken. In fact, my lord, IBC is very clear.
In all,
anything, my lord, IBC going to the court, anybody can be a whistleblower. It's just like a complaint. One nimsha, sir. Please, sir, I have.
No, when a wrong.
The law is well settled on that. Would you not interject, please, till I complete? If I am wrong on law, I'll be judged on that. Please.
Yes.
So IBC, my lord, is a parasol legislation which makes provision. If, my lord, God forbid, my lord, I should not be facing it. My lord, if I have some 100 creditors, my lord, against me, I've taken loans from some 100 creditors. Not every 100 has to go to the court. One creditor may go against me. One creditor may go against me, invoking, my lord, the provisions of IBC. And that one creditor's application, if admitted, and, my lord, the insolvency proceeding starts, it is applicable to all the creditors, because all the creditors, then they will have to file their claims only before the insolvency resolution professional.
Yes.
Therefore, my lord, what section 101, your lordships may kindly have, my lord, the IBC which I have passed on. Please have, my lord, 101.
Yes, 101.
Yes. Yes. When an application is admitted under section 100, a moratorium shall commence in relation to all debts and shall cease to have effect and end of period of 180 days beginning on the date of admission of the application, etc. During the moratorium period, any pending legal action or proceeding in respect of any debt shall be deemed to have been stayed.
No, this was extracted here. Interim order is extracted.
There is, my lord, a misunderstanding of law that the IBC proceedings against me is only by that IDBI bank, not applicable. My lord, that is a myopic way of, my lord, understanding the law.
No.
That the IBC
No,
is.
you have any judgment on this?
There were several, my lord. Kindly have it tomorrow, my lord. I'll produce
No,
it.
before which? my
Several.
lord?
Now,
Several, not one.
Only
or
one question, my lord. Page number 40. Your the writ petition compilation. That my learned friend is not bringing to the notice of this court.
Yes.
Execution petition ಅಲ್ಲಿ judgment debtor is ozone urbana infra developers private
ಅವ್ರ ಮೇಲೆ ಹೋಗ್ಲಿ, ನಮ್ಗೆ ಏನ್ ತೊಂದ್ರೆ ಇಲ್ಲ.
No, let me complete. Decree, the ozone is the defendant. They are the judgment debtors. They have suffered the decree. Now, my lords, what my senior counsel wants to contend is one of its director, you Satyamurthy, this person, Vasudevan Satyamurthy. My learned friend wants to say ವಾಸುದೇವನ್ ಸತ್ಯಮೂರ್ತಿ ಅವ್ರು ಬೇರೆ ಯಾವುದೋ ಮ್ಯಾಟರ್ ನಲ್ಲಿ ಬೇರೆ ಯಾರಿಗೋ ಕೊಲ್ಯಾಟ್ರಲ್ ಕೊಟ್ಟಾಗ ಅವ್ರ ಮೇಲೆ ಮಾರಟೋರಿಯಂ ಇದ್ರೆ how on earth I fail to understand.
That is the law.
That is not the law.
Judgment,
That is
not
not
one or two. There are hundreds of judgments on this.
See, this judgment debtor companies, you can go against the company.
Yes.
Not
That's exactly.
Can be proceedings against
That's
me.
exactly, my lord. He happens to be, my lords, the sitting there as a general manager.
Who?
They say this Vasudevan Satyamurthy. I am not executing against Satyamurthy at all.
Arrest warrant is issued against me. That's
No,
what
I
I'm
help
questioning.
let him say that I am not the general manager. I can proceed against
Can
the
I not
company
say that?
only against the general manager of the company.
No, what is that law on that Insolvency Act says?
Insolvency Act ನಲ್ಲಿ ಹೇಳೋದೇನಿದ್ರೆ
Even if there is see, general manager or a director
Managing
of any
director,
company,
anything, my lord.
he cannot be. Is it that interpretation of the law that
that my lords,
he protected from all
Yes, my
this
lord.
thing?
Yes.
my lords, if I beg to differ, we will clarify on this point. My lords, the only person against whom decrees have been passed, if it is to be said against Vasudevan Satyamurthy, decrees of various decrees are passed, and one of the creditor, my lords, if he approaches say NCLT, my lords, moratorium in respect of one of
Asking that this Vasudevan is protected in all aspects.
Yes, my lord.
No,
That's
my
what
lord.
is the law.
That's not the law.
Judgment.
ಅದೇ ಇದೆ, ನಾಳೆ ಕೊಡ್ತೀನಿ. Kindly, my lord, have it
the other
tomorrow.
side, my lord, senior
Kindly
counsel
have
he
it
wants.
tomorrow, my lord. I'll clear the, instead of, my lord,
Yes,
instead
that's
of,
what
my
I
lord.
see. Law is there.
Yes,
Interpreting
the
that
law
I
is
want
well
judgment.
said.
That's all.
Not even a 138 case can go on. Mohan
Yes, my
Raj's
lord.
judgment, the Honorable Supreme Court, not one or two, my lord. There are hundreds of judgment. I'll produce at least one or two.
I'll bow down to whatever the ruling my other senior counsel would submit. This question is raised by the other side, my lord senior counsel. Let my senior counsel satisfy this honorable court by producing
Not, my lord,
appropriate.
I don't want. Kindly, my lord, have it tomorrow, my lord.
That is what now that only that interpretation.
That's
all.
it. No need of interpreting, my lord. It's been interpreted already.
Yes. No. Yes. Tomorrow.
Cell number 64, SV Prakash for petitioner, Ramesh K.R.
In this matter, my lord, I am appearing for the respondent.
2:30, tomorrow at 2:30 this matter.
My lord,
We don't know whether this matter will reach or not, my lord.
All are in the same problem. All advocates, parties before me. My
Allah,
court
idu-
is same problem. Therefore, I am not giving any preference. Whenever it is reached, their luck.
my lord, I will request.
I am also not that sitting at getting at 3:30 and all. I am making my effort to till 5:30. Can't help otherwise than that.
My lord, I will request, my lord, tomorrow. I will request.
Tomorrow, yes.
Please, interim, please.
Yes, leave this matter tomorrow.
Oblige.
Cell number 65, Kalyan R for petitioner, connected
I
matter.
appear for the response.
My lords, I pay for short accommodation, my lord. Senior has inconvenience.
My lord, suits are of the year 2011, my lord.
Yes.
At the stage of final arguments, my lord, they have filed an application seeking framing of additional issues.
That's 2 weeks, my lord. Senior has personal inconvenience.
No, that's when vacating. What is that problem? If there is some serious problem, you can accommodate. Otherwise, therefore, now I have changed my list pattern. Immediately after that preliminary hearing, I posted vacating. Wherever that interim order taken, that ex parte and all, see that parties appear, they will be given opportunity for vacating.
Please, my lord.
Otherwise, the problem will. Now that my second part is that vacating. Yes.
My lord, senior
A
has.
liberal in granting an interim order, but we'll also this thing other side is also given a justice to vacating. Yes.
That's next week, my lord. Any date. Senior
Yes,
has.
madam.
personal
What is that
inconvenience.
problem?
My lord,
He has
suit
personal
is, my lord, of the year 2011. petitioners, my lord, are the plaintiffs. When the matter is posted for the final hearing, my lord, at that stage, they have filed an application seeking framing of additional issues. If my lords, there are 3
No,
petitions. my
that
lord.
anyhow, they are the plaintiff.
Please, my lords.
Their suit is stayed.
My lords, but there is an interim order operating, my lord, in the
What is
suit
that interim order?
we shall not alienate the suit shall be property till the disposal of the suit.
Alienation. You can-
2011, my lord, is the suit, my lord.
Yes,
That's
when
the
do you want?
convenience,
No,
my
it's
lord.
next week, any day.
Any
Yes, at the
shortest
request of
days
counsel for the
possible, my lords.
petitioner. As a last chance, is this matter on 8th?
So
Yes.
great.
Cell number 66 adjourned, cell number 67, Deshpande Amit Anand for petitioner, VP Kulkarni.
I have filed application for vacating stay. My lord, the facts of the case are.
Yes.
One submission, interim order may be extended.
Yes, interim order extend. Yes.
My lord, vacating application copy serve ಮಾಡಿಲ್ಲ madam. Vacating application.
Copy?
Not sir.
Not serve.
Madam, you kindly see. My lord, they are served in the March, my lord, in December.
Yes.
Misplaced.
Yes, madam, they have sent it through post.
Post, register post.
Misplaced ಆಗಿದೆ my lord.
I have sent it register post.
Misplace ಆಗಿದೆ ಅಂತ ಹೇಳಿ ಸರ್ವೆ ಮಾಡಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ರು.
ಅಲ್ಲ ನಮ್ದು ಕಲಿಗ್
Come back, see immediately that if it is not served. No, see, there may be a chances of misplacing in that office, but it should be, once it is served, your submission should be submissive.
I have sent it to register post, my lord.
Yes, now that acknowledgement is there in that office copy.
I will check.
My lord, they.
If you want,
2
they will
weeks,
give,
my lord.
what is this matter? Not
My lord,
2 weeks.
there are 2 suits have been filed, one by me and the other suit is filed by the other side.
Yes.
My lord, I have filed a suit for a recovery of the amount against the, my lord, the company and 2 directors. Company and 2 directors have filed another suit against my father and my brother on the, because they were the directors company alleging they have mismanaged and there is sustained a loss. I was not a part of the company. I am not concerned with the company. Now they, my lord, a suit application has been filed for clubbing my suit along with their suit. That has been rejected on the ground that number of frivolous applications were filed earlier. This is nothing but under application, frivolous application. That is the finding of the court.
Yes, madam. Now, what is that stay granted here?
What is the stay of further proceedings of my suit?
Clubbing application ಅದು ರಿಜೆಕ್ಟ್ ಆಗಿತ್ತು my
No,
lord.
that other suit is not stayed.
No, other suit is not stayed, my lord. My suit is stayed now.
How can that? It should be stayed, both the suits.
My lord, rejoinder ಆಗ್ತೀವಿ my lord ಅದಕ್ಕೆ.
Rejoinder ಏನಿದೆ?
Rejoined, what is, I don't understand. What is the rejoinder? I am not arguing on the merits of, I am arguing the merits of the case.
GMCPC li objection ಆಗ್ತೀವಿ writ ಗೆ.
My lord, this is the tactics they adopted. Kindly see
My
the
lord,
implement
ನಮ್ಮ
order.
senior ಇಲ್ಲ.
Learned judge says, my lord, this is delaying tactics application.
My lord, 2
And hence,
weeks,
my lord, he has rightly rejected. Now the seeking
are-
adjournment is also, my lord, delaying tactics.
No, there are 2 petition.
Yes.
Yes, what is that another one?
ಒಂದು ನಾವು ಫೈಲ್ ಮಾಡಿದ್ವಿ my lord 1158. In
Yes.
another one
At the request
304
of counsel
ಅಲ್ಲಿ
for the
clubbing
petitioner as a
application.
last chance. Is this matter on 7th?
My lord, the 7th, I will be, my lord.
Seventh,
9th, my lord.
9th, yes, 9th, as a last chance.
Senior ಇರಲ್ಲ my lord 9th 18th my lord.
My lord, the
18th.
No.
vacation ಹತ್ರ ಬರುತ್ತೆ ಮತ್ತೆ ಇದಾಗೋದೇ ಇಲ್ಲ.
Lord senior ಇರಲ್ಲ.
I am seriously.
That is not the ground for taking an interim order.
ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಕೇಸ್ ಇದೆ ಅಲ್ಲಿ ಹೋಗ್ತಾ ಇದ್ದಾರೆ.
Yes, you engage some other counsel. Yes, not 2 weeks. You will be there for 2 weeks in the Supreme Court. You will have it then 6th or 7th. Monday.
Yes, 6th, my lord.
18th illa.
18th.
No, then we will not extend that interim order.
Yes, ma'am.
Yes, either
Interim
next
order.
week. Huh?
Interim order.
Interim order will be extended only till 9th. If you are ready, argue, otherwise will not extend.
But-
Yes.
On 9th, madam.
Yes, 9th. Interim order extended till next date of hearing.
Serial number 68, Archana KM for petitioner.
I appear for the respondent.
Kapiyan.
For the petitioner, my lords.
Yes.
My lords, the brief facts is such that the respondent files a suit for recovery of money, my lords,
Yes.
on 14/6/2019, my lords.
Yes.
The suit comes to be decreed ex parte on 4/2/2020, my lords. 14/6/2019, my lords, and
Yes.
4/2/2020 ex parte decree agata.
Yes.
Then an execution is filed by them, my lords, by the respondent on 24/3/2021. In
Yes.
their execution petition, my lords, there is proclamation of sale ಮತ್ತೆ auction ge agate. That's when after the court bailiff goes and visits the property, he realizes that there is a PG which has been running and the petitioner is not there. That comes to the notice of the Honorable Trial Court, and then, my lords, the notice is issued.
Yes.
As that is when the PG whom I have rented out, my lords, they give me the information. I immediately file my wakalat in the execution petition and I file miscellaneous petition.
For
In
what?
the miscellaneous petition for my lords, one for condonation of delay agi, ಇನ್ನೊಂದು execution petition na stay ಮಾಡ್ಲಿಕ್ಕೆ IA 1, 2 and 3 I file, my lords.
Yes.
In the miscellaneous petition, IA number 1, 2 and 3 are dismissed, before which I'm before your lordships.
Yes, where is that order?
Page 21, my lords. Order on IA 1, 2 and 3. Page 21. Annexure A.
Yes.
The heading is very clear, my lords. Order on IA 1, 2, 3. The petitioner has filed IA 1 under section 5 of the Limitation Act to condone the delay in filing the petition, and then IA 2 to stay the proceedings in execution petition 564/21.
IA filed under which provision?
And
IA 2.
IA 2, my lords, has filed
151.
151.
151, my lords.
Yes.
And then IA 3, my lords, to dispense.
Yes, why it is dismissed? Which IAs are allowed?
My lords, all the
All the
IAs
IAs.
are
Rejected.
rejected.
Yes.
Before which, my lords, my learned friend has filed an objection stating that this writ petition is
Now
not.
you read from page 22 on perusal of the records.
On perusal of the records, it's forthcoming that the respondent, B.N. Ramaswamy, has filed a suit against the present petitioner in OS 4232/2019 for recovery of money with interest. The summons was issued to the defendant, who is the petitioner herein, through RPAD. The same was returned as not claimed. Hence, the service was held sufficient. This itself shows that the defendant was having knowledge of the suit filed by the plaintiff against him for recovery of money in OS 4232/2019. The said suit came to be decreed on 4/2/2020. After the present, petitioner has not challenged the said judgment and decree in any appeal or filed any miscellaneous petition within stipulated period of time permitted under law. But when execution petition 564 of 2021 has been filed against the present petitioner, who is this petition came to be filed for setting aside the ex parte decree in OS 4232. This itself shows that to avoid the realization of the decretal amount, the present petitioner has moved this present petition. Along with the petition, he has also filed IA number 1 under section 5 of Limitation Act to condone the delay in preferring the miscellaneous petition. As already discussed above, the suit in OS number 4232 of 2019 has been disposed of on 4.
I thought after 5 years, then
May I take
it is
your-
not served to you.
No, my lords. May I take your lordships, my lords?
Yes.
OS ಅವರು file ಮಾಡಿದ್ದಾರೆ. May I take your lordships to page
Where is
number-
that order sheet?
My lords. Your lordship may kindly see the page 77. If your lordship could kindly see for a moment. ಅದು OS file ಮಾಡಿದ್ದಾರೆ ಸರ್. ಎರಡು ಅಡ್ರೆಸ್ ಹಾಕಿದ್ದಾರೆ ಡಿಪೆಂಡೆಂಟ್ಗೆ.
77.
Your lordships got it, my lord.
Page?
Page 77 annexure D. ಎರಡು ಅಡ್ರೆಸ್ ಹಾಕಿದ್ದಾರೆ ಸರ್. ಒಂದು ವಲ್ಲಭ್ ನಗರ ಕೋಣನಕುಂಟೆ, also at 122.
Yes.
And the date of filing of the suit is 14/6/2019, my lord.
Yes.
And the day the trial court holds that the service is sufficient is 9/10/2019, my lords. Now your lordships might kindly come to annexure B, page 25. For a moment. That is a registered lease deed, my lords.
Yes.
Not registered.
18/4/2018, my lords. That day, the address is number 31 3rd Cross, Srinivasa Layout, Konankunte. This is the lease deed which is dated 18/4/2018, my lords. As on the date of petition.
Sir, unregistered lease deed.
Plaintiff is the owner of the property.
Yes, ma'am.
Now suit for ejectment.
Recovery of
No,
money.
my lord's defendant is the owner of the property.
No,
The
here.
defendant is the owner. Defendant is the owner of the property.
The petitioner herein is the owner of the property, my lords.
No, petitioner is the owner.
Please.
Yes,
The
yes,
defendant, the petitioner.
yes.
So, my lords, as on the date of that petition and also the day that the court held that the service is sufficient, I was not on that property which is mentioned as I showed to your lordship.
No, see, you have entered in a lease agreement.
ಇದು ನಾನು ಲೀಸ್ ಅಗ್ರಿಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದೀನಿ ಸ್ವಾಮಿ, ಫಸ್ಟ್ ಫ್ಲೋರ್ ಕೊಟ್ಟಿದ್ದೀನಿ. Your lordship may kindly see the schedule at page 27. I am residing at that property, my lords, not on the property which they have mentioned in the OS suit. I have not even been served with the copy.
Where is that plaint?
Page 77, my lords.
Who is the plaintiff?
But may I submit?
Yes, plaintiff is the tenant.
No, my lords. My lords, plaintiff and defendant had entered into an agreement of sale in the year 2016, my lords. 24/6/2016 is the agreement of sale, which I have produced along with my vacating. 24/6/2016.
Agreement of sale.
Please, my lords.
Yes.
If my lords comes to page number 13 of my vacating stay, my lords, the
No, I am asking that where is the plaint?
plaint is page number 77 of the
77,
petition.
my lords. Annexure D. ನಂದು ಎರಡೇ ಪಾಯಿಂಟ್ ಸ್ವಾಮಿ. ಆ ಎರಡು ಅಡ್ರೆಸ್ ಅಲ್ಲೂ ಇರ್ಲಿಲ್ಲ ಅಂತ.
Wait, madam.
Please.
Suit is filed on 14/6/2019.
14/6/2019.
That you have executed an agreement of sale.
Please.
Defendant is hereby directed to pay sum of rupees to that along with that interest at principal amount within same date and so on so. Hereby directed to pay the sum of rupees. No, you are, what is that consideration amount?
It was 50 lakhs, my lords. 10 lakhs was the sale consideration, advance sale consideration amount which was received.
10 lakhs. 10
10
lakhs you
lakhs
have
was
paid.
received.
10 lakhs has been,
10 lakhs I have paid to the petitioner.
you have
Please.
seek for an return of that amount with that
Please,
interest.
please, my lords.
Yes.
My lords, kindly see, my lords,
Now that
the
you see
schedule.
that, now you see that on that agreement. What is that address shown in that agreement?
The address, my lords, comes to page number 13, my lords.
30.
1/3 of
Son of
their,
number 44, 3rd cross, Vallabhanagar, Konan Kunte cross, Bangalore 62. Page number 13 of my IFR vacating.
13.
13.
Yes.
The address which is given by the petitioner is the address which is shown in the plaintiff.
which is in the year 2016.
Thereafter you have changed your address.
I'm not being
And
served with
also,
the
Malaj,
copy.
the second
my-
address that is given is the suit schedule property, Malaj. The property for which sale agreement is entered into. So that is his permanent address, Malaj.
Where?
The suit schedule property is at page number 22, Malaj,
Where she is residing.
where she is residing.
You are resident of
Who
that
knows,
address,
Malaj?
madam.
They are created.
You are residing in that Jainagara 7th block.
My lords, I have leased that also, that premises also. I'm not
2008.
residing.
You are not
In
residing.
2018 only, I've kindly have a look at annexure
No,
C,
that-
my lords.
What is that law says?
Malaj, kindly see,
It
Malaj.
has to be
kindly
heard where they are
page-
residing or that whichever address you have this thing.
Page 29 notice.
Yes.
That's the lease date. with
Yes,
respect
that's
to-
what you are showing.
Malaj,
Yes.
before we go into merits, Malaj, the one point that I have.
No, that what is the trial court said? Notice is refused.
Malaj, notice is returned unclaimed, my lords. My lords, I have produced the order sheet at page number 12, my lords, of my vacating stay.
Unclaimed means what? Refused.
Illa Swami.
Unserved, not claimed, not claimed.
Not claimed means what?
Not claimed ಅಂದ್ರೆ ಅವ್ರು ತಗೊಂಡಿಲ್ಲ.
Refused. Then.
Refused ಅಂತ.
That means to say they are in that address.
My lords,
Should be
they are
there.
not.
If that refused, that means they are in that residing that address.
Please, my lords.
But the address shows that they are not residing there.
My lords, that is the first time in the year 2025 they have produced some unregistered lease deeds, my lords.
May I take your lordships to page
My lords,
109
even
for a
in
moment?
fact, in the year 2021,
No,
my lords,
when-
even in the execution petition, my lords, it is served personally, my lords. Even then, they don't come before the court. In the year 2025, my lords, when the proclamation of
come
sale
to that
happens.
delay and later, whether he was residing in that address or not is the, see,
May I take?
refused means one should be present there and he has to refuse.
My lords, it is served
Is it
through
that,
RPA.
no, we'll get that records, what is that written?
Page 12 ಅಲ್ಲಿ produce ಮಾಡಿದ್ದಾರೆ order sheet.
I produced
the
No.
intent called
No,
out.
postal acknowledgement says what? We'll
We'll
secure that original records.
My lords, may I make one submission, my lords? The order impugned in this writ petition is one passed under Order 9, Rule 13, my lords. They have an alternate remedy of appeal under Order 43, Rule 1D, my lords. This writ petition itself it is not.
No, it is passed under which provision?
Under Order 9, Rule 13, my lords.
Then appeal is there.
My lords, this is only to bypass the appeal. The
If your
present
lordship
petition is filed,
kindly
my
see,
lords.
I just read out to your lordships at page 21. Order, clear heading ಬರ್ದಿದ್ದಾರೆ.
No, where is
Order
your
on
application? Where is your application?
My application is at page 1.
The reason discussed above, the plaintiff is filed Order 9, Rule 13 is hereby dismissed.
Kindly.
No, application under Order 9, Rule 13, there is an appeal.
My lords, I am challenging the order which has been passed under Section 5 of Limitation Act. My application or Section 5 of Limitation Act has been dismissed. I am before your lordships challenging that,
Madam,
my lord.
Consequentially, your miscellaneous
That's a
petitions.
consequence. My lords.
No, you have to go to that. No.
The lordship-
I am relying upon one Supreme Court.
See, if the appeal is dismissed and delay, as well as appeal, then.
As well as appeal, illas.
No, that is what that Order 9, Rule 13 means what? It is dismissal means your miscellaneous petition is dismissed. Yes.
Your lordship for a
That's-
moment.
No, this is.
Come to
Yes.
109 page, my lords.
Yes. Consequently, dismiss that other applications also. Yes.
So I'm relying upon one honorable Supreme Court judgment, my lords, which clearly says once your Section 5 is dismissed, consequently Order 9, Rule 13 is dismissed, only appeal is maintainable.
Yes.
And you cannot invoke writ jurisdiction or revision jurisdiction.
Yes, where is that?
Paragraph number 15, my lords. In this case, revision petition was filed, my lords. And it was entertained, and then that order was taken to Honorable Supreme Court. So Honorable Supreme Court clears the positions.
Yes.
Paragraph number 15, my lords. Page
Yes.
number 3.
Yes.
Against the order passed under Order 9, Rule 13 of CPC, rejecting an application for seeking setting aside the decree passed ex parte, an appeal is provided. When an application is filed seeking condonation of delay for seeking setting aside an ex parte decree, and the same is dismissed, and consequently the petition is also dismissed, the appeal under Order 43, Rule 1D is maintainable. Thus, an appeal only against the
is not
refusal
raised
to
any
set aside
objection.
ex parte decree is maintainable.
Office is not raised any objection.
Office has not raised, and the office objections raised by raised is also not cleared, my lords. This is coming up for the 5th time.
Yes.
Your lordship may kindly have it tomorrow, my lords.
No,
I
madam.
just received this.
No, this is settled. Yes, even then the judgment is not there, appeal has to be filed. The dismissal of the application is a consequence.
My lords, if Section 5 application was allowed, they would have filed writ petition only under that, my lords.
For that,
Order clearly says.
Section 5 application is allowed, your miscellaneous petition will be entertained, then the application only has to be challenged.
Please, my lords, your heading is very clear on that, my lords.
You are not
Order
seeing
on-
heading, madam, you are seeing that provision of law. Yes. In this writ petition, petitioner called in question.
Lordship may kindly have it tomorrow, my lords.
For what, madam? Yes. Challenging order passed on Order 9. Order 9, Rule 13. Consequently, IA filed under Section 5 of the Limitation Act. Since application filed under Order 9, Rule 13 is dismissed, the remedy available for the parties is to file an appeal under Order 43, Rule 1D. The writ petition is not maintainable. In view of the above, the writ petition is dismissed, reserving liberty to the petitioner to approach appropriate legal form. Yes.
That's interim order may kindly be. It may say that interim order granted.
Obliged.
Yes. You should be very. She should not have catch the point, madam. She should have asked that interim order may be continued another two weeks.
No,
Yes. Yes.
Lordship,
You should be very careful in that when you are making a submission. Yes.
I would have definitely.
Yes.
She was.
But anyhow, you have not sought She should have been very clever in that as to,
No, my lord, it is
yes, finish.
interim
Yes.
order may be
No,
extended.
it's
my
over,
lord.
it's
Until I
over.
file the.
No, don't take anything from the court and make a submission.
My
I
lord,
just
she was
educating
making
the youngsters.
submission, I would.
You
I
should be very
couldn't-
careful when making when it is dismissed, madam. Yes,
I would have made the submission, your lordship may kindly consider. I will,
yes. You
Still
are
number
not
six.
asked.
order may be extended, my lords.
Yes, interim order
Until
granted
I-
by this court will extend it for a further period of 2 weeks. I expected this. You are not short. I closed it. You have opened it. Take that benefit.
No, my lords,
Yes.
again they'll come and say.
You should be advocate should be very careful when making a submission, anything. Yes. Interim order granted this court. She has a benefit of that interim order. I'm about to grant, but she has not asked. I stopped it. You have made submission to open the court for this. Yes. Granted, continue for a further period of 2 weeks. It is made clear that if appeal is filed, appellate court has to decide that any application is filed for a stay independently without influencing any interim order granted by this court. Yes.
Obliged.
Still number 69, Sri Sheshagiri Rao for petitioner, Ashwin Kira.
Yes.
Lords, I pray for a short accommodation. Kindly have it tomorrow, my lords.
Yes. Who is appearing?
Just a short point of impleading, my lords, of a pendant, I has purchased the property in 2014, my lords.
You are the impleading or?
We are the impleading applicant.
Your application is dismissed.
Allowed, my lord.
Allowed, my
Allowed.
lords. Kindly have it
No,
tomorrow.
suit for?
Partition, my lords.
Suit for
Pendant
partition. Purchaser can be impleaded subsequent. I think there are the judgments.
Yes, my lord, there are 3 judgments which are
Have
pretty.
to come and argue, my lords. Have it
Yes,
tomorrow.
tomorrow. Yes, at the request of respondent, petitioner, lead this matter tomorrow. Interim order granted is extended till next date of. Yes.
If possible, top of the list, my lords. I'll leave it to your lordship. Please.
Yes.
Still number 70, Rajesh Gowda for petitioner.
6/17 application filed by the defendant came to be rejected.
Yes.
Yeah, for the
Relief sought-
respondent.
Relief sought only, the suit is barred by law of limitation in page number 36 IA. The suit is for specific purpose filed by the respondent. We filed a written statement on 10/9/2024.
Yes.
The
No,
application.
that you can, that application for allowing will be considered from the date application has been filed. Then trial court has to frame the issue for limitation. Can be decided.
The
No, no.
only trial court observed, my lord, the mat is posted for class of PW 1 and 2. That is the only observation by the trial court in page number
But
11.
My
Yes.
submission
Number
would be, my lords, that suit is not barred by limitation because, my lords, the limitation started, my lords, prior to the COVID, my lords. So there was a exclusion of limitation period, my lords, by virtue of the
No,
order of the
you
Supreme
have filed
Court.
an application.
We filed application.
No, they filed
defendants
the application.
You have filed an application for?
For amendment, my lord.
You are seeking for an amendment of what? Written statement.
Written statement only starting, my lord, the suit is barred by limitation in page number 36.
You are seeking for an ground that.
Ground
suit is-
that the suit is barred by limitation in page number 36.
After
The
the
trial court
trial,
has to come to conclusion that, my lord, the matter is posted for class of PW 1 and 2. That is the only.
You have not taken that defense in that written statement.
They have not taken earlier point of time, my lord. The filed written statement on 10/9/2024. The application filed on 22/11/2025.
Now, is there anything is withdrawing that admission made? Nothing.
In page number.
He has not admitted earlier that suit is within the time.
no,
I'm
no.
not admitted.
Withdrawing. Now that question of law, it can be raised. How it
But
is.
what happens, my lords, is that, my lords, the agreement
The
was
time of
entered into
limitation
on.
start in which provision of law limitation start is not properly explained by the defendant in the written statement. I thought, how it is delayed?
My lord, in page number 15, my lord. Second para, ಇನ್ನುಳಿದ ಬಾಕಿ ರು 50,000ಗಳನ್ನು ನಾನು ಇಲಾಖೆ ಮುಂದಿನ 1 ತಿಂಗಳ ವಾಯ್ದೆ ಒಳಗೆ. The agreement was entered on, my lord.
Page.
In page number 15, second para. ಬಾಕಿ ಉಳಿದ 50,000 ರೂಪಾಯಿಗಳನ್ನು ನಾನು ಈಲಾಗಾಯಿತು ಮುಂದಿನ 1 ತಿಂಗಳ ವಾಯ್ದೆ ಒಳಗೆ. The agreement entered on 38/2019.
ಆಯ್ತು, 1 ತಿಂಗಳ ಒಳಗೆ
From the date of agreement.
ನೋಂದಾವಣೆ ಬೇಕಾದ ಸ್ವತ್ತಿನ ಖಾತೆಯನ್ನು ನನ್ನ ಹೆಸರಿಗೆ ವರ್ಗಾವಣೆ ಮಾಡಿಕೊಂಡು ಬಂದು ನಿಮಗೆ ತಿಳಿಸಿ ನಿಮ್ಮಿಂದ ಮೇಲ್ಕಂಡ ಬಾಕಿ ಹಣವನ್ನು ಪಡೆದುಕೊಂಡು ನಿಮಗೆ ನಿಮ್ಮ ಕುಟುಂಬ ಸಮೇತ ಬಂದು ನನ್ನ ವಂಶವೃಕ್ಷ ತಕರಾರು ಪತ್ರ ಶುದ್ಧ ಕ್ರಾಯ ಪತ್ರ ಮಾಡಿಸಿ ಕೊಡಲು ಬದ್ಧನಾಗಿರುತ್ತೇನೆ. ಮಾಡಿಸಿ ನಾವು
agreement entered on 38/2019.
No, that you have executed an agreement.
Agreement, alleged agreement.
What is that? ಇನ್ನು ಉಳಿದ ಬಾಕಿ 50,000 ರೂಪಾಯಿಗಳನ್ನು ನಾನು ಈ ಲಗಾಯಿತು ಮುಂದಿನ 1 ತಿಂಗಳ ಮಾಹಿತಿ ಒಳಗೆ ಕ್ರಾಯದ ಸ್ವತ್ತಿನ ನೋಂದಾವಣೆ ಬೇಕಾದ ಸ್ವತ್ತಿನ ಖಾತೆಯನ್ನು ನನ್ನ ಹೆಸರಿಗೆ ವರ್ಗಾವಣೆ ಮಾಡಿಕೊಂಡು ಬಂದು ನಿಮಗೆ ತಿಳಿಸಿ ನಿಮ್ಮಿಂದ ಮೇಲ್ಕಂಡ ಬಾಕಿ ಹಣವನ್ನು ಪಡೆದುಕೊಂಡು ಆಯ್ತು. ಸ್ಪೆಸಿಫಿಕ್ ಪರ್ಫಾರ್ಮೆನ್ಸ್ ಆಫ್ ದ ಕಾಂಟ್ರಾಕ್ಟ್ this is not been satisfied, it cannot be. Why that limit?
The suit has filed on 31/3/2022.
A limitation ಏನು ಬಂತದ್ದು?
Oh, the suit has been filed 31/3/2022, my lord. After lapse of almost 30 months. The time is essence of the contract in this.
That is true. Here he said within 1 month I will
From the
get
date of the
that.
agreement.
No, I will get that. You know.
ಈ ಲಗಾಯಿತು that he this day. This day ಈ ಲಗಾಯಿತು ಮುಂದಿನ 1 ತಿಂಗಳು.
ಆಯ್ತು.
ಈ ಲಗಾಯಿತು means on this day. The agreement ended on 38/2019. Legal notice issued on.
ಅದಕ್ಕೆ ಲಿಮಿಟೇಷನ್ ಹಾಕ್ಬೇಕು. You can take in a contention saying that he has not performed his part of the contract.
That is the only I sought for the amendment, my lord.
A limitation ಏನು ಬಂತು? Specific performance ಅಲ್ಲಿ as he performed his part of the contract. His part of the contract is that within 1 month he has to pay and he has to get it. Therefore, specific performance cannot be granted at all.
And 31/3/2022 in notice issued after lapse of 30 months.
ಆಯ್ತ್ರಿ, ಯಾವಾಗ್ಲಾರ ಇಶ್ಯೂ ಮಾಡ್ಲಿರಿ. One he has to seek for a specific performance. He should perform his part of the contract. His part of the contract is he has to pay within 1 month. He has not done it. Then he is not entitled for specific performance.
That is the only reason I sought for the amendment, my lord.
Amendment ನೀವೇನ್ ಕೇಳ್ತಿದ್ರ? It is barred by limitation ಅಂತ.
Yes, my lord, the suit itself is barred by limitation. The thing is that, my lord, 38/2019, the filed suit on 31/3/2022.
Yes.
Kindly see the synopsis, my lord.
Yes.
And my lord, the suit filed on 18/11/2023.
Suit filed on?
My lord, the agreement on 38/2019.
Suit filed on
18/11/2023. After lapse of 1.5 year of the notice.
ಆಯ್ತು, ನೀವು ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಯಾವಾಗ?
10/9/2024.
10/9/2024.
Amendment filed on 22/11/2025.
22/11/2025. 1 year, after 1 year.
After 1 year.
Yes, madam, 1 year is.
Lords, my submission is, my lords, the date of agreement is 38/2019. ಅಲ್ಲಿಂದ 1 ತಿಂಗಳು ಅಂತ ಹೇಳಿದ್ರೆ 39/2019 is the from there the limitation begins. Lords, ಆಮೇಲೆ ಇದು ಕೋವಿಡ್ ಎಕ್ಸ್ಕ್ಲೂಷನ್ ಬಂತು ಸ್ವಾಮಿ. 15/3/2020 ಇಂದ 28/2/2022 ವರೆಗೆ all the limitation was saved by the order of the Supreme Court, my lords.
No, is limitation to approach the court or transaction is also saved?
No, to approach the court. To approach the court, my lords.
No, he's not saying approach the court.
Please, my lords.
See, it is not that you have approached the court in late. He is saying that within 1 month you have not performed your contract.
He has to perform his contract. I am the plaintiff. I am the plaintiff.
You are the agreement holder. I am the owner. You are the agreement holder. You have to issue a notice within 1 month, not by me, owner.
He says, my lords, under Article 54 of the Limitation Act, time is the essence of the contract. So within 3 years from the date of this thing, my lords.
No, this limitation, he has to do it.
She has to
do it. A limitation ಏನು ಬರ್ತದ್ರಿ?
1 month from the date of 1 month. Can you see the
ಬರ್ಲಿಲ್ಲ ಅಂತ ಅಂದ್ರೆ he has not performed his contract, mister.
That is the only we sought before the trial court.
No, you said that. What is that you have started? Suit itself is not maintainable for.
Suit is barred by law of limitation.
ಯಾವ law limitation?
Article 54.
What is that 54?
Take it at 1 month, my lord. As 1 month. That the plaintiff has failed to perform his part of contract.
No, see, if you failed to perform a contract within 1 month, then limitation will start for him to filing in a suit, mister.
He has to issue notice. He has to issue notice within 1 month.
Our performance ಇಲ್ಲ ಅಂತ ಅಂದ್ರೆ ಅಲ್ಲಿ ಹೆಂಗ್ರಿ limitation ಬರ್ತದೆ?
ಅಲ್ಲ, ಅವರ ನೋಟಿಸ್ ಕೊಟ್ಟಾದ್ಮೇಲೆ ಸ್ವಲ್ಪ ಆಗೋದು. They not issued any legal notice even after lapse of the 30 months.
Mr. Counsel, limitation will not start for him, mister. If the limitation will start for him when you fail to perform the contract, then he will not fail to contract in the limitation.
I am the owner, Mala.
No, mister, you can take in a contention that he failed to perform his part of the contract, therefore specific performance cannot be granted.
That is only I am taking contention. That is only.
What is that contention? Show me that.
Page number 36.
Yes.
The suit filed by the plaintiff is obviously barred by law of limitation as.
ಅದು ಹೆಂಗ್ರಿ? ಯಾವ್ದು law ದಲ್ಲಿ ಬರ್ತದೆ?
My lord, Kindly see the suit filed on 18/11/20.
ಬರೋದಿಲ್ರಿ ಆಯ್ತು ನೀವು ತಗೊಳ್ಳಿ ಯು ಟೇಕ್ ಇಟ್ ಟು ದ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಎಸ್ ತಗೊಳ್ಳಿ
My lord.
ಅದಕ್ಕೆ ಲಿಮಿಟೇಷನ್ ಬರೋದಿಲ್ರಿ
Suit filed on 18/11/2023 after lapse of 3 years.
ನಾವು ಲಿಮಿಟೇಷನ್ ಮೇಲೆ ರೀ 3 years ಬಂತು ಎಲ್ಲಿಂದ ಲಿಮಿಟೇಷನ್ ತಗೊಂಡ್ರಿ
My lord, from 38/2019 take it as 38/2019. 39/2019 take it, my lord. And he filed 18/11/2023.
they have to perform his contract within 1 month.
Yes, my lord.
ಅದು ಅವ್ರಿಗೆ ಲಿಮಿಟೇಷನ್ ಎಲ್ರಿ ಅಟ್ರಾಕ್ಟ್ ಆಗ್ತದೆ.
So I am the defendant before.
Yes, you have argued. I will consider.
But I am the defendant before the trial court.
Yes, yes.
At the time of the, after the lapse of 3.5 years, they filed suit for specific performance.
Mr. Yes, yes, I have understood, Mr.
After lapse of 3.5 years, they filed, my lord.
ಯಾವ ಲಿಮಿಟೇಷನ್ ರೀ ಅವ್ರಿಗೆ ಲಿಮಿಟೇಷನ್ ಸ್ಟಾರ್ಟ್ ಆಗೋದು ಯು ಫೇಲ್ ಟು ಪರ್ಫಾರ್ಮ್ ಮಿಸ್ಟರ್ ಅವಾಗ ಅವ್ರಿಗೆ ಲಿಮಿಟೇಷನ್ ಬರ್ತದೆ ಅವರೇ ಫೇಲ್ಯೂರ್ ಆದ್ರೆ ಅವ್ರಿಗೆಲ್ಲರಿ ಲಿಮಿಟೇಷನ್ ಬರ್ತದೆ ಸಿ ವಾಟ್ ದೇ ವಾಂಟ್ಸ್ ಟು ಡೂ ಇಟ್ ವಿತ್ ಇನ್ 1 month they have to get it kata.
No, that is me. That is defendant. I am the defendant before. I am the owner.
No, who has to done it? He has to pay that 50,000.
He has to pay the 50,000.
But
I have to done that.
Have they paid the 50,000?
No, they are not paid.
Then they have not performed their contract. Their limitation question will not arise us. That's what trial court is also held.
I will make only one last submission. ಒಂದು ತಿಂಗಳೊಳಗಡೆ ಅವರು ನಾನು ಖಾತಾ ಒಂದು ತಿಂಗಳೊಳಗಡೆ ಸೇಲ್ ಡೀಡ್ ಮಾಡ್ಕೋಬೇಕಾಗಿತ್ತು ವಿತಿನ್ 1 month ಫ್ರಮ್ ದ ಡೇಟ್ ಆಫ್ ದಿ ಅಗ್ರಿಮೆಂಟ್ ಅವರು ಸೇಲ್ ಡೀಡ್ ಮಾಡ್ಕೋಬೇಕಾಗಿತ್ತು ದೇ ನಾಟ್ ಕಮಿಂಗ್ ಫಾರ್ವರ್ಡ್ ಟು
ವಿತಿನ್ 1 month ಅವರು ನಿಮಗೆ 50,000 ರೂಪಾಯಿ ಕೊಟ್ಬಿಟ್ಟು ಖಾತಾ ಚೇಂಜ್ ಮಾಡಿಸಿ ಆಮೇಲೆ ಲಿಮಿಟೇಷನ್
ಇದೆ there is no dispute about the ಖಾತಾ
ಉಳಿದ ಬಾಕಿ ಹಣ 50,000 ರೂಪಾಯಿಗಳನ್ನು ನಾನು ಈ ಲಗಾಯಿತು ಮುಂದಿನ 1 ತಿಂಗಳ ವಾಯಿದಿ ಒಳಗೆ ಕ್ರಾಯದ ಸ್ವತ್ತಿನ ನೋಂದಾವಣೆಗೆ ಬೇಕಾದ ಸ್ವತ್ತಿನ ಖಾತೆಯನ್ನು ನನ್ನ ಹೆಸರಿಗೆ ವರ್ಗಾವಣೆ ಮಾಡಿಕೊಂಡು ಬಂದು ನಿಮಗೆ ತಿಳಿಸಿ ಅಂದ್ರೆ ಏನು ಕ್ರಾಯದ
on the date of the agreement revenue entries was my name.
ಇನ್ನು ಉಳಿದ ಬಾಕಿ 50,000 ರೂಪಾಯಿಗಳನ್ನು ನಾನು ಈ ಲಗಾಯಿತು ಮುಂದಿನ 1 ತಿಂಗಳು ವಾಯಿದಿ ಒಳಗೆ ಕ್ರಾಯದ ಸ್ವತ್ತಿನ ನೋಂದಾವಣೆಗೆ ಬೇಕಾದ ಸ್ವತ್ತಿನ ಖಾತೆಯನ್ನು ನನ್ನ ಹೆಸರಿಗೆ ವರ್ಗಾವಣೆ ಮಾಡಿಕೊಂಡು
ನನ್ನ ಹೆಸರು ಆಲ್ರೆಡಿ ಖಾತೆ ಇತ್ತು on 2008 when the agreement was entered the revenue entries was my name. ಆವತ್ತು ನನ್ನ ಹೆಸರು ಖಾತೆ ಇತ್ತು separate RTC was in my name. This is a loan transaction between the parties. But I'm not on the merits, my lord. This is loan transaction.
ಇದು ಯಾರು ಹೇಳೋದು ಇನ್ನು ಉಳಿದ ಬಾಕಿ 50,000 ರೂಪಾಯಿಗಳನ್ನು ನಾನು ಈ ಲಗಾಯಿತು ಮುಂದಿನ 1 ತಿಂಗಳ ವಾಯಿದಿ ಒಳಗೆ ಅಂತ ಅಂದ್ರೆ ಪರ್ಚೇಸರ್ ಕ್ರಾಯದ ಸ್ವತ್ತಿನ ನೋಂದಾವಣೆಗೆ ಬೇಕಾದ ಸ್ವತ್ತಿನ ಖಾತೆಯನ್ನು ನನ್ನ ಹೆಸರಿಗೆ ವರ್ಗಾವಣೆ ಮಾಡಿಕೊಂಡು he has to transfer into his name.
No. Here is a little bit
ನನ್ನ ಹೆಸರಿಗೆ ವರ್ಗಾವಣೆ ಮಾಡಿಕೊಂಡು ಬಂದು ನಿಮಗೆ ತಿಳಿಸಿ ಅಂದ್ರೆ ಅವನ ಹೆಸರಿಗೆ ಖಾತೆ ಚೇಂಜ್ ಮಾಡಿಸ್ಕೊಂಡು ಬಂದು ನಿಮಗೆ ತಿಳಿಸಿ ಅಂತನಾ ವಾಟ್ ಇಸ್ ದಟ್ ಮೀನಿಂಗ್ ಮಿಸ್ಟರ್
from the date of within 1 month the purchaser has to register the sale deed.
ಎಲ್ಲಿದೆ ಆ ತರ
ಈ ಲಗಾಯಿತು ಮುಂದಿನ 1 ತಿಂಗಳು ಈ ಲಗಾಯಿತು ಅಂದ್ರೆ on the day
ಆಯ್ತ್ರಿ ಓದ್ರಿ ಮುಂದೆ ರಿಜಿಸ್ಟ್ರೇಷನ್ ಮಾಡಿಸು
ಈ ಲಗಾಯಿತು ಮುಂದಿನ 1 ತಿಂಗಳ ವಾಯಿದೆ ಒಳಗೆ ಕ್ರಯದ ಸ್ವತ್ತಿನ ನೋಂದಣಿಗೆ ಬೇಕಾದ ಸ್ವತ್ತಿನ ಖಾತೆಯನ್ನು ನನ್ನ ಹೆಸರಿಗೆ ವರ್ಗಾವಣೆ ಮಾಡಿಕೊಂಡು ಬಂದು on the date of the agreement revenue entries was my name. I will produce the RTC extract mail by tomorrow.
ಆಯ್ತ್ರಿ ಅದ್ರದ 1 ತಿಂಗಳ ವಾಯಿದೆ ಒಳಗೆ ಕ್ರಾಯ ಪತ್ರವನ್ನು ಮಾಡಿಸಿಕೊಂಡು ಅಂತ ಇಲ್ಲ ಅಲ್ಲಿ ಕ್ರಾಯದ ಸ್ವತ್ತಿನ ನೋಂದಾವಣೆಗೆ ಬೇಕಾದ
ಕ್ರಾಯದ ಸ್ವತ್ತಿನ ನೋಂದಣಿಗೆ ಬೇಕಾದ
ಸ್ವತ್ತಿನ ಖಾತೆಯನ್ನು ನನ್ನ ಹೆಸರಿಗೆ ವರ್ಗಾವಣೆ ಮಾಡಿಕೊಂಡು ಬಂದು ನಿಮಗೆ ತಿಳಿಸಿ ನಿಮ್ಮಿಂದ ಮೇಲ್ಕಂಡ ಬಾಕಿ ಹಣವನ್ನು ಪಡೆದುಕೊಂಡು ನಿಮಗೆ ನಮ್ಮ ಕುಟುಂಬ ಸಮೇತ ಬಂದು ನನ್ನ ವಂಶವೃತ್ತ ರೀತಿ ಯಾವುದೇ ತಂಟೆ ತಕರಾರು ಇಲ್ಲದೆ ಇಲ್ಲಿದೆಯಲ್ಲ ಕೆಳಗಡೆ ನೋಂದಾವಣೆ
ಪತ್ರ ಮಾಡಿಕೊಂಡು ಬದ್ಧರಾಗಿರುತ್ತೇನೆ. ಈ ಲಗಾಯಿತು means from on that day 1 month I have to get the documents according to them.
Yes.
After 1 month they have to issue the notice. After 1 month they have not issued any legal notice. After lapse of 32 months they have issued a legal notice. After issuing of legal notice after 1.5 years they filed a suit for specific performance. That is only contention, my lord. That contention has to be put forth in the written statement. And the earlier point of we could not able to incorporate the written statement. That is the only contention, my lord.
No, but even then that is a non-performance of his contract. It will go even that limitations.
Time is the essence of contract, my lord. That aspect has not been incorporated.
No, where is your application?
In page number 36, my lord.
What is that you have pleaded?
The suit filed by the plaintiff is hopelessly barred by limitation. As such, the suit is not maintainable for the relief of the specific performance contract against the defendant. This is the only relief sought.
Where is that application?
In page number 36, my lord, annexure E. Both are.
Yes,
Proposed amendment.
yes. Defendant above mentioned submits that for the sworn affidavit, plaintiff filed plaintiff hopelessly barred by limitation as such suit is not maintainable for the relief. Yes, specific performance the contract and yet let it be there that pleading, what will happen to that? He is not seeking
Nature of the
any.
suit, it not be changed,
That's-
anything.
My specific submission is, my lords, this agreement was entered into
No, madam,
just prior
he is-
to the
He
COVID.
is seeking, no, that you can be argued if the court frame that issue. He is.
Or I may be permitted to file a rejoinder.
Yes, that is there. Yes, he is seeking only to pleading, amendment of the pleading in that written statement. He is not seeking for an issue and all.
It's a law, it's a question of law, my lords. He can argue even without amending the written
That
statement.
it is best ground is that he has not performed his contract.
Please, that is the
Even
best
this-
ground.
Even this plea is allowed, either it will not cause any prejudice to you. He wants that plea. Yes, let him be, yes,
I may be permitted to file.
yes. In this writ petition, petitioner sought for washing order dated 16/2/2026 passed by first additional civil judge CJM Kolar in OS number 545 of 2023 on IA number 6 filed under order 6 rule 17. Plaintiff has filed a suit for specific performance of the contract. On appearance, defendant has filed a written statement. Issues ಆಗಿದೆಯಾ?
ಆಗಿದೆ.
Cross examination of.
On the basis of the pleadings of the parties, the trial court has framed that issue. When the matter was been set down for evidence, the application has been filed under order 6 rule 17 for amendment of written statement. If that amendment sought by the petitioner, the defendant is allowed, it will not cause any prejudice to that plaintiff. And in the interest of justice, the application is allowed, the writ petition is allowed, order dated so and so is set aside. The application filed under order 6 rule 17 by the petitioner defendant is allowed. The plaintiff is also permitted to file an amended additional you can also file an what you can file that.
They can't file any rejoinder.
Yes.
So what, my lords? My lords, my submission may kindly be noted.
Yes.
That, my lords, the limitation was could not be an issue because there was a saving.
Filed an application for amendment. Learned counsel for the petitioner submitted that. Respondent plaintiff submitted that. There is no issue framed regarding that limitation of filing the suit. Even the suit is filed within the time.
In view of the order passed by the Supreme Court,
Yes,
my lords.
within the time, be that as it may. If that impleading, if that application under order 6 rule 17 is allowed, it will not cause any prejudice to the plaintiff. By application for amendment, defendant is not withdrawing any admission made in that written statement. Accordingly, the petition is allowed, order dated so and so is set aside. IA filed under order 6 rule 17 is allowed. Yes.
Seal number 71, Srinivas Manohar Kulkarni for petitioner.
Yes.
The petitioner before your lordships is the judgment debtor.
Yes, who is a respondent? Yes.
My friend is here.
Yes.
My lord, the proceedings arising out of execution petition,
Yes.
arising out of a decree for money obtained by the decree holders.
Yes.
The petitioner before your lordships is the only judgment debtor. My lord, against, it is a matter which was passed, the judgment passed by the district court at Adoni in Andhra Pradesh. They have obtained the execution transfer order and execution is filed before the principal district judge at Chikbalapur. Against the judgment obtained by them, an appeal is preferred and the appeal is admitted before the Honorable High Court of Andhra Pradesh and it is pending. But they filed an application because we could not comply with the interim order of the High Court of Andhra Pradesh to deposit 50% of the decretal amount. They filed an application for attachment of my properties. But that application was allowed, against which this writ petition is filed. But this Honorable Court, on the first date of hearing, passed an order staying the execution proceedings subject to the condition that we deposit 50% of the, we deposit 20 lakhs.
Now, what is that total amount for recovery due?
The total amount as per Annexure B before your lordships is
57 lakhs 22,000. 57 lakhs 22,000 EP amount.
56.
57 lakhs 122.
22,173.
Please, ma'am. Now, this honorable court passed an order directing to deposit 20 lakhs on or before 26/3/2026.
Deposited.
We have deposited 15 lakhs, my lord, before the executing court. And I have filed an application to permit me to deposit balance in 30 days. It's not put up, my lord, before your lordships.
When that order has been passed, 27/3/2026.
27/2, yes, my lord.
Yes.
27/2/2026 was the order passed by this honorable court to deposit 20 lakhs within 26/3.
Yes.
We have deposited 15 lakhs as on 26/3. My humble submission is we will deposit the remaining 5 lakhs.
57 lakhs, 50% ಎಷ್ಟಾಯ್ತು? 57 lakhs, 57, 125.
Yes, it will come. Yeah, it will come to around more than 25 lakhs.
So you
28
deposit,
and half,
you
28
deposit
lakhs.
another 15 lakhs. No, it is nothing but you are overcoming that order passed by that other state of High Court, Mr.
No.
They said you deposit 50%.
Please.
In execution, you come and say that, stay that order. Now that it is reduced to 20%, it is nothing but that you are getting over from that order passed that other High Court.
My lord, I have deposited 1 lakh, 1.5 lakhs also.
There is an order passed there granting an interim order subject to deposit 50%. Now you have deposited 20, 50 and 30%.
15 lakhs they have deposited. Your Honor.
15 lakhs.
Madam, along with 15 lakhs, earlier in the execution petition, I have deposited 1.5 lakhs. Totally 16.5 lakhs is deposited.
Now another 15 lakhs if you deposit, we'll continue that interim order.
Right.
Or you try that in another state and get it, the stay of this, then reduce another 10,000. This is not, Mr.
No, the appeal is already admitted.
Order is granted to pay 50. Execution is petition is filed, not granted. Now that order has been challenged here, you are obtaining for a 20 lakh. Then you are now modifying that order passed by that Andhra Pradesh High Court, Mr.
No, my humble submission is.
Now you pay another 15 lakhs, we'll grant it. Otherwise, no. Yes.
My lord, now I have deposited totally 16.5 lakhs.
In 14 lakhs, Madi.
Interim order ತಗೊಂಡ್ರು in 11 ಲಕ್ಷ ಬರುತ್ತೆ ಸ್ವಾಮಿ. 27 ಲಕ್ಷ in 11 ಲಕ್ಷ ಕಟ್ಟಬೇಕಾಗುತ್ತೆ ನಾನು. I will deposit 11 lakhs.
I have to pay 56 lakhs, Mr.
Please, madam.
Don't restrict to 50. Interim order subject to that kotiradastini. As it you are making that you are only entitled to pay 25 lakhs. You have to pay that 60 lakhs. Now that you pay another 15 lakhs within 1 week, will continue. Otherwise, will not.
My humble submission is, my lord, within 1 week, I'll deposit 5 lakhs. I may be permitted to deposit the remaining 10 lakhs within 4 weeks.
No.
My humble submission is.
Or the entire.
Lakhs has to be granted.
He's an agreement.
By today. Otherwise, interim order has to be vacated. This court has granted 20 lakhs to deposit.
Therefore, my lord, I have filed an application
No, the
seeking for
application
modification of the order. It is
Rejected.
not put up before your lordships.
Application is rejected. Yes.
My lord, in the interest of justice, because he has deposited 15 lakhs
You have lost
on
the
26th of March.
case. Maybe, Mr. He has succeeded in the court.
My lord, the appeal, my lord, the appeal filed by us
What is that interim order granted by this Andhra Pradesh High Court?
to deposit 50%, my lord.
If it is agreed, you have to file an appeal to that Supreme Court.
No, my lord, we
Complying that. Then you are coming before that executing court, there is a stay. Stay is not complied. Then you are
my humble
executing court has
submission
But now they have sought, my lord, against the attachment order, this writ petition is filed. They have sought for attachment of my immovable properties.
Why it has to be stayed? Because there is already an order from the Andhra Pradesh High Court. Deposit 50%.
My humble submission is
EP is
deposit,
2
he'll
years
deposit
old,
10
Your
lakhs
Honor.
within 4 weeks, my lord.
EP is 2 years old, Your Honor.
Then
We have filed attachment petition about in the month of 2024.
The appeal is already
April.
admitted.
see, we'll have it tomorrow. You pay that 5 lakhs tomorrow because this court order you have to be compliant. First,
A
then we'll see that.
week's time, my lord.
Your Honor,
Week's time, I'll deposit 5 lakhs.
Tomorrow. 5
Not
lakhs
today.
tomorrow. See, on 26/2/2026, court has directed to deposit 20 lakhs by 27/3/2026. What is the date today?
26/3. We have deposited 15 lakhs within the period. 5 lakhs is the deficit.
Are not complied that Andhra Pradesh High Court order, not complied this court High Court order. Then you go to that another High Court and get it an interim.
My humble submission is a week's time may be granted, my lord, we'll deposit 5 lakhs.
First deposit 5 lakhs.
Please, my lord.
I want to deposit 15 lakhs. Now deposit 5 lakhs to see that this court order has to be complied.
By Monday, my lord, by Monday.
Yes, Monday.
Please.
One submission, Your Honor, because the other side.
ಏನಿಲ್ಲ, ಇದೇ execution. ಹಿಂಗೆ ಕಟ್ಸ್ಕೊಂಡು ಹೋಗ್ಬೇಕಷ್ಟೇ. You are doing that execution petition.
One submission, Your Honor.
Yes.
Here, my learned friend, name mentioned Soma Devi, the second decree holder. Second, not Soma, Sri Devi is name. Yes, Sri Devi.
ಯಾದ್ರಲ್ಲಿ?
But in the writ petition, there is we will correct it.
Court records, he is
We will correct
appearing
it.
since from the lower court.
Soma Devi ಅಲ್ಲ, ಶ್ರೀದೇವಿನಾ?
We will correct it.
Soma Sri Devi, her name.
Soma ಶ್ರೀದೇವಿ. ಆಯ್ತು, correct ಮಾಡಿ. Anyhow,
He mentioned Soma Devi. He even in the EP copy and he obtained attachment order copy, that is page number 19, Your Honor.
Anyhow, you are representing Mr. Counsel. You correct it, Mr.
Please, ma'am, we'll do it, ma'am.
Yes. Leave this matter on Monday.
Please, ma'am.
Interim order granted earlier is extended till next date of.
Please,
Monday ಒಳಗಡೆ ಕಟ್ಲಿಲ್ಲ ಅಂದ್ರೆ will first
Please,
5 lakhs.
Yes, ma'am.
I will fix the date for remaining.
Please, ma'am.
And may vacate the stay, Your Honor, because all proceedings has to be vacated.
Let us see on Monday.
Please, Your Honor.
Awaiting service of notice in all cases up to 89.
Your Lordship, in Indian
Awaiting,
serial number 89.
My lord,
Serial number 87.
Wait, we'll come to the 89.
The notice has already been served and the memo has been sent. There was urgency in the matter, so I have moved towards this honorable court for 27.
No, interim order is there.
We have not asked for an interim order, and because interim order stay the and main proceeding itself.
No, that notice serve ಆಗಿತ್ತನ್ನ ನೋಡಿ ಅದು. ಯಾರಿಗೆ ಸರ್ವ್ ಮಾಡಿದ್ರಿ?
Personally to the respondent counsel.
Yes.
There was an order as
Yes, up to 88. Awaiting service of notice, interim order, if there is any, will be extended till next date of it. 87 ಯಾಕೆ ಬಂದಿದೆ ಅದು?
87 I am ready. It can be disposed of tomorrow itself.
87 it is not awaiting service.
ಅಲ್ಲ, ಅದ್ರಲ್ಲಿ I am the only contesting party. ಕೊಡ್ತೇನೆ, ಅದು copy
87 ನೀವು ಯಾರಿಗೆ ಅಪೇರ್ ಆಗ್ತಿದ್ದೀರಾ? No, you are respondent.
I am first respondent.
You have not filed any application for vacating.
ಇಲ್ಲ, dispose ಆಗ್ಬಿಡುತ್ತೆ.
Dispose of ಅಂತಂದ್ರೆ then you have to wait for.
Definitely within 10 minutes.
Yes, this matter on 7th.
Okay.
Your Lordship,
Other matter.
serial number 89, Your Lordship. There is a serious urgency because there is an affixture, there is an auction notice on my property for the death of the respondent. And when I had asked for the equal share in the family court.
My lordship, serial number 89, I'll take notice to respondent, madam. Serial number 89, respondent, madam. I'll file wakalat for respondent.
Yes.
89. BM Kushalappa, madam.
Yes, so and so is undertaken to appear for all respondents.
Only one respondent.
Yes, respondent. Please this matter on 7th.
My lord, serial number 89. My lord, 49 is also.
Other 92 PF matter is also.
One submission, 92,
92. 92 weeks time is granted to do the pay the process. In addition, petitioner is also permitted to take out hand summons to respondent number 5. Yes, take out hand summons.
My lord, serial number 49 passed over matter. ನಾಳೆ
49 is an admission.
ಅದು ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಕಂಪೈಲ್ ಮಾಡಿದೆ.
ಆ ಪ್ರಿಲಿಮಿನರಿ ಹಿಯರಿಂಗ್ ಮ್ಯಾಟರ್ ಪಾಸ್ ಆಗಿರೋದು 49
tomorrow afternoon. From morning I have to go to hospital. 2:30 please.
ನೀವು ಪಾಸ್ ಔಟ್ ಮಾಡಿ 2:30 ಗೆ ನಾವು. Not 2:30.
2 o'clock hospital admission.
ಹೋಗಿ ಬನ್ನಿ. You ask some your colleagues to pass over or will pass it over.
2:30.
Serial number
119 my lord.
121 your lord.
Serial number 41.
Yes. Wherever there is an interim order, we will extend. Serial number?
Serial number 121 your lord.
104 may not be extended.
Yes, 104. Where is that Shiv Kumar?
No, they are purposely not 1 year they have taken stay, but they are not paying for.
Yes. 104. Where is Shiv Kumar? Yes.
Serial number 110, my lord, no.
110. 104.
And
Even so far, no steps has been taken. None appears, least this matter after 2 weeks.
Serial number 119.
That is not extended.
serial number 110.
All other matters, interim order will be extended. Means
121, let it be posted tomorrow, Your Lordship.
Yes.
My lord, 110, it is regarding maintainability is concerned.
Same order.
May kindly have it tomorrow, my lord.
Serial number 106.
Regard 110.
In the meantime, you have to comply office objection.
I already complied.
Serial number 121, let it be posted tomorrow, Your Lordship.
110, serial number 110 regarding maintainability is concerned.
Serial number 129.
Serial number 41, I already complied the office objection.
49.
41.
41. Yes, 41 is preliminary hearing tomorrow.
Serial number
110 tomorrow, my lord. 110 regarding maintainability is concerned. I will argue the matter on maintainability. There is a division based matter.
But they are not going ahead.
110, my lord.
To be
Tomorrow.
listed on any day, my lord, next week.
No, you are appearing for?
Respondent.
No, is there any interim order?
ಅಲ್ಲ ಇಂಟ್ರಿ ಬಾಂಡ್ ಇದೆ ಅದಕ್ಕೆ ಐ ಆಮ್ ಅಪಿಯರಿಂಗ್ ಫಾರ್ ದ ರೆಸ್ಪಾಂಡೆಂಟ್
You file an application.
ಅಪ್ಲಿಕ್ ಹಾಕಿದ್ದೀನಿ ಹೌದು
My lord, serial number 110.
If there is a learned counsel for the respondent 129, submit that IA has been filed, vacating office to verify and put up this matter.
Serial number 1 submission.
Serial number 119.
Serial number 95. Serial number 106, my lord. Only recalling the order.
That remaining matters, wherever interim order is there, we will continue and we will list on 9th.
My lord,
Serial number 106, my lord. There is an urgency, my lord.
ಮೇಡಮ್ ಎಲ್ಲ 9th ಬರುತ್ತಲ್ಲ?
ಮೇಡಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ 80 ಯಾವ ಡೇಟಿಗೆ ಹೋಯ್ತು ಮೇಡಮ್?
ಕೋರ್ಟ್ ಆಫೀಸ್.
ಸರ್ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಎಲ್ಲ 9th ಗಾ?
110 ಯಾವಾಗ್ರಿ?
ಎಲ್ಲಿದೆಯಲ್ಲ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತೆ 9ನೇ ತಾರೀಕು. 9 ಎಲ್ಲ 9 ಅಂತ ಹೇಳಿದ್ದಾರೆ.
ಥ್ಯಾಂಕ್ ಯು.
ಯಾವ್ದ್ರಲ್ಲಿ ಎಕ್ಸಿಸ್ಟಿಂಗ್ ಎಂಟ್ರಿ ಮಾಡಿದ್ರೆ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡ್ತಾರೆ. ಆಗಿಲ್ಲ ಅಂದ್ರೆ ಮಾಡಲ್ಲ. ಉಳಿದ ಎಲ್ಲಾ ಮ್ಯಾಟ್ರು 9.